functioned from 1st September 2019, and due to COVID, it has come into effect with 1st April 2022. Seniors may not require the details I am touching with, but youngsters, friends, వేయి ప్రశ్నలుండు విజ్ఞానవేత్తకు ప్రశ్నలుండబోవు పామరునకు విఘ్నుడవును నరుడు జిజ్ఞాస చేతనే నవయుగాల బాట నార్లమాట. ఇక్కడ ప్రశ్నించుకోవటం అనేది ఎదుటి వాళ్ళని ప్రశ్నించటం కాదు, మనం ప్రశ్నించుకోవటం. మనం ముఖ్యంగా ఈ మోటార్ వెహికల్స్ యాక్ట్లో గురించి ఇది ప్రస్తావన ఎందుకు చేస్తున్నానంటే, సవరణ చట్టాలు కానీ పాత చట్టం కానీ వీటిలో మనం చదివినప్పుడు మనకి అనుకూలమైన అర్థాలనే చూస్తాం. దీంట్లో ఇన్వాల్వ్ అయినంత డబ్బు మోటార్ వెహికల్స్ యాక్ట్ కింద యాక్సిడెంట్స్ క్లెయిమ్స్ కింద ఇన్వాల్వ్ అయినంత డబ్బు చూస్తే ఒక 2 రాష్ట్రాల బడ్జెట్ అంత ఉంటుంది ప్రతి సంవత్సరం. ప్రతి జిల్లాలో సుమారుగా 2000 ప్రమాదాలు జరుగుతాయి, క్లెయిమ్స్ పడుతూ ఉంటాయి. ఈ దేశంలో 700 జిల్లాలు, 700 ఇంటూ 2000. ప్రతి క్లెయిమ్లో కూడా ఇవాటున సగటున 7 నుంచి 10 లక్షలు, 7-8 లక్షల రూపాయలు ఉంటుంది. ఈ మొత్తాన్ని వెచ్చించుకుంటే అయ్యే కోట్ల రూపాయల డబ్బు ఒక రాష్ట్ర బడ్జెట్ అంతా. కానీ దీనికి అత్యంత నిర్లక్ష్యానికి గురవుతున్న చట్టం కూడా ఇదే. దీంట్లో ఎవరిని నిందించాల్సిన అవసరం లేదు, కానీ దీన్ని అర్థం చేసుకోవాల్సిన అవసరం అయితే ఉంది. సెక్షన్ 147, సెక్షన్ 146, సెక్షన్ 145 వెనక నుంచి చదివాను. సెక్షన్ 145లో గతంలో థర్డ్ పార్టీని డిఫైన్ చేశారు. దాంట్లో డెఫినేషన్ ఏంటంటే, థర్డ్ పార్టీ ఇంక్లూడ్స్ గవర్నమెంట్. ఎవరికి ఇంక్లూడ్ అవుతుంది అది? ముందు ఒకళ్ళ పేరు చెప్పి తర్వాత ఇంకొకరిని ఇంక్లూడ్ చేయాలి. ఇంక్లూడ్స్ గవర్నమెంట్. అక్కడ బహుశా ఆ చట్టాన్ని రూపొందించిన వ్యక్తి తన మనసులో భావం అందరికి కూడా ఇదే ఉండుంటుందిలే అని ఇంక్లూడ్స్ గవర్నమెంట్ అన్నాడు, ముందు చెప్పవలసిన వాళ్ళ పేరు చెప్పకుండా. అది ఇప్పుడు మొన్న సవరణ తర్వాత ఆ సవరణ కూడా చేయటం జరిగింది. థర్డ్ పార్టీ ఇంక్లూడ్స్ గవర్నమెంట్, ద డ్రైవర్ అండ్ ఎనీ అదర్ co-worker on a transport vehicle. గతంలో ఓన్లీ గవర్నమెంట్, ఇంక్లూడ్స్ గవర్నమెంట్. ఇప్పుడు ఇట్ ఇంక్లూడ్స్ డ్రైవర్ అండ్ ఎనీ అదర్ co-worker on a transport vehicle. వీళ్ళ గురించి చెప్పారు. అసలు థర్డ్ పార్టీ ఎవరు? ఫస్ట్ పార్టీ ఓనర్ ఆఫ్ ది వెహికల్ who enters into a contract with an insurer who is the second party, and third parties are the people who are not connected to the vehicle. It may be third party or third party property. డ్రైవర్కి, క్లీనర్కి, లేకపోతే దాంట్లో ఉన్న వర్కర్స్కి వాళ్ళ పరిస్థితి ఏంటనేది ముందు నుంచి ఉన్న సమస్య. అన్లెస్ ఎడిషనల్ ప్రీమియం ఈజ్ పెయిడ్, దే ఆర్ నాట్ కవర్డ్ అండర్ ది పాలసీ. ఎందుకు ఎడిషనల్ ప్రీమియం కట్టాలి? ఇన్సూరెన్స్ పాలసీని కనుక మీరు మొత్తంగా చూస్తే, ఇన్సూరెన్స్ పాలసీ 146 ప్రకారం mandatory. ఒక వాహనం బయటికి ఎనీ వెహికల్ దట్ కమ్స్ అవుట్ onto the road to ply must possess a valid and effective insurance. Unless there is an insurance policy, a vehicle cannot come to the road. But who are covered under it? Only third parties. Those third parties are those that are not connected to the vehicle. And now 145 have given a new definition with regard to the third parties, that is not only include the government but also the driver and the persons, co-workers in a transport vehicle. Now premium is not required to cover those risks. Why is it not covered? Why can't they be covered earlier? Because their claims, if injured or they suffer loss, they come under Workmen Compensation Act. Now they have come under Motor Vehicles Act. Though there is an option under Motor Vehicles Act under section 167 that the workers can make a claim under Workmen Compensation Act or Motor Vehicles Act, but not both. Now this, making this amendment, the driver and the workers come within the meaning of third parties. But here, how many people are considered to be third parties that travel in a vehicle is again a question. They are governed by Rule 252 of AP Motor Vehicle Rules 1989. Only in the seats provided by them, for them, in the cabin of the vehicle. So third party, he can be termed as a third party if he had an accommodation provided by the Act to sit in the cabin, in the seat provided by hips of 283 millimeters or so, something like that. So they all come within the meaning of third party, provided they have an accommodation in the cabin. 146 is mandatory. A vehicle cannot move. Now it comes to 147 of Motor Vehicles Act. 147 is not a mandatory provision. 147 is only explanatory. It explains that on payment of premium, these people are covered under the policy of insurance, and these are the terms. Earlier, before amendment, there was a proviso for 147 where it treats as provided that a policy is not required. This was wrongly understood by everybody, saying that there is no necessity of a policy to cover the risk. It cannot be. What is to be understood is that a separate policy is not required to cover different risks. Instead of using that, ఎవరో ఆ రచయిత గారి పైత్యం ఆ సపరేట్ వర్డ్ తీసేశారు, పెట్టలేదు, తీసేశారు కాదు, పెట్టలేదు. బహుశా ఆయనకు అర్థమైంది, మిగతా వాళ్ళకి కూడా అర్థమవుతుంది అనుకున్నాడేమో. Provided a policy is not required, that was what was mentioned. And ultimately what has happened was, everybody traveling the vehicle was covered. That is the reason why we had Satpal Singh case. And he also the Act also says that people covered under the Workmen Compensation Act, they are covered under the policy of insurance issued to a vehicle. That is the reason why the Supreme Court has made it clear in Ramashri Singh case, popularly known as Khalasi case, which was reported in 2003 ACJ 1550. Until that was given, until that judgment was delivered, there was no occasion for the court to think of the policy of insurance. Then, in the amendment, the amendment was made to that effect of removing that proviso. And there is an amendment to section 147, sub-rule 1, clause B, subclause Roman 2. Against the death of or bodily injury to any passenger of a transport vehicle, except gracious passengers of a goods vehicle, caused by or arising out of use of motor vehicle in a public place. Earlier this was not there. That was the reason that was wrongly understood because of the proviso, provided that a policy is not required, it covers everybody in a transport vehicle also. Now it is made clear by amendment of the Act that unauthorized gracious passengers, whoever it be, that are not covered under the policy. This is what to be understood, very particularly young friends. When you are reading the provisions, read from the beginning till the end, not to the extent where you require. If you don't read this and read the other provisions in other part of the section, you will understand it in a different way. First, who is an insured? He is the person who buys the policy, who pays the money to cover specific risks. Who is the insurer? Who sells the policy covering these particular risks only. The contract between them is only to this. Among all this buying and selling, the mandatory is to cover the risk of third party and third party properties. All other coverages, whether own damages or workers or some other thing which they have, these are all contracts only based on the contract. Unless premium is paid, it's not covered. There are many judgments to that effect which clarified on these aspects. And also violations of policy, which was previously 149(2). Now after amendment it has come to 152. 150 subsection 2. A vehicle should not be hired, a private vehicle should not be hired. Any vehicle must be driven by a person having a valid and effective driving license. Unfortunately, some recent judgments, what was said was, a person not having a license, not having a LLR, learner's license, can be termed as a person having a driving license, ignoring the fact that he must be accompanied by a person having a driving license to teach that. That part is missed. And the provision says this, judgment says that. Then again a confusion. Some courts accept that, some courts do not accept that. Keeping aside all these things, to know the facts, first we should know what is law. Whether this law applies to our case or not is important. As far 150, present 150 is concerned, and there is also one more difficulty that has arisen in recent times. Any friends who have been filing motor vehicle accident cases before the tribunal here and after amendment? Earlier there was no limitation. It was filed at any point of time. Now it is 6 months. What after 6 months? If it is filed from the date of accident, that's right. If it is delayed, whether an application under section 5 applies? Why? Exactly. అందుకనే ఆలస్యం చేయకుండా వేస్తే పోద్ది. ఎత్తుక్కొని మనం అన్ని కూడికలు తీసివేతలు తీసి ఇవన్నీ కూడా చాలా సున్నితమైన అంశాలు. వాడెవడో క్షతగాత్రుడు, కుటుంబం దెబ్బతినిపోయి ఉంది, వాడికి రూపాయి చేయాలి, రూపాయి రావాలి ఆ కుటుంబం నిలబడాలంటే. కానీ మనం చేయవలసిన పని సకాలంలో చేయలేదు. ఎవరిని తప్పుపట్టడానికి లేదు ఇక్కడ. పాత అలవాటు, దాన్ని జీర్ణించుకోవడం ఇప్పుడు ముఖ్యమైనది. ఏంటంటే పాత దాని నుంచి మనం వాళ్ళకి మార్పు చెందాలంటే చాలా కష్టం. ఒక మోసలో ఉన్నాం, దాంట్లో నుంచి బయటికి రావాలి. ఈ అమెండ్మెంట్ యాక్ట్ తర్వాత ఈ మధ్య కాలంలో జరుగుతున్నవి అప్పీల్లో కూడా ఉంది ఈ ఇబ్బంది. అప్పీల్లో వీ హ్యావ్ ఎ ప్రొవిజన్. ఇన్ కేస్ ఆఫ్ డిలే వీ కెన్ కమ్ విత్ ఎన్ అప్లికేషన్ టు కండోన్ ద డిలే. అసలు అవి ఇక్కడ అప్లై అవుతాయా కావా? As far as these are concerned, under Motor Vehicles Act, for young friends, I am once again, what is to be required is, you must be thorough with the policy and conditions of the policy. And very particularly, motor vehicle policy is a policy that is covered under many acts. Where there is own damages to a vehicle, if the claim is repudiated saying that there is a violation, that is a dispute under Consumer Protection Act and not Motor Vehicles Act. Where there is loss of life or proper damage to third-party property, that is a claim under Motor Vehicles Act. Where workmen suffer loss, that is a claim under WC Act, EC Act, presently Employees Compensation Act. So that was the reason why that proviso was written, provided that a policy was required, where it should have been said, provided that a separate policy is not required, because all the entries which are to be issued as different policies, own damages is a separate policy, workmen is a separate policy, personal accident is a separate policy, TP coverage is a separate policy. As all these are related to a single vehicle, all these are merged and kept into one policy. That is the reason earlier that provision wrongly read as so. So friends, the time is up that is given to me. What I request to all the young friends, particularly young friends, when read the provision thoroughly, provisions of this act, and now understand that you are dealing with a very big budget, which has in this country has a potential of that can control two states of this country. And involvement of such an amount, we must be very cautious that the victim should not suffer. And equally, the insurance companies says we are the custodians of public money, so we'll have to defend our case. Yes, even somebody feels mercy and says that I can do something and pay it, their audit will not accept it, and they will have their whip and their back from the audit department. So these are the reasons why the act should be read thoroughly. We also have పొరపాట్లు చేస్తుంటాం కొన్నిసార్లు. అందుకనే ఏటుకూరి వెంకట నరసయ్య గారు అంటారు, పొరపాటు లేని వారిని, పొరుగు సహాయం ఒకంత పొందని వారిని, మరణంబు లేని వారిని కనతరమ చిత్రగుప్త దస్తరమందు. థ్యాంక్ యూ.
Request Brahmanand Reddy garu to come on to the dais to felicitate Naresh garu. In fact, tomorrow also we are planning unscheduled program, but now declaring now itself. Yesterday the chief guest during inaugural session presented an amended act of that IPC. Still there are two enactments which are going to come into effect from 1st July, which are very, very important. Sri SRP Garu will present on the amended version of the Criminal Procedure Code tomorrow. Please kindly, sharply it will be beginning by 9:30, so that we can have a benefit of the new amended act, its features and comparison with the old act. Thank you, Naresh Garu. I request Brahmanand Reddy Garu to felicitate Naresh Garu. In fact, we used to have every this kind of session, a presentation on the Motor Vehicles Act. This time we could not find in the regular session. Thank you. Within short period, the first session, the already Justice Nagarjuna Reddy Garu arrived. Within short period, it will be commenced. L. Nageswara Garu also on the way. And third session, there may be a change. Justice Sachinad Murthy Garu may not come now. So Justice Ramakrishna Prasad Garu will present. Advance His Lordship's session as a third session, and almost every session today also very interesting, and all of us will be benefited by their presentations. My dear friends, most of you might have come to this campus day before yesterday itself in the night. You have been staying since then here. There might be a number of lapses in spite of our best efforts, still due to communication gap, because of vacation, number of officers of the campus, this university, are on a scheduled vacation. So there was some disruption. On the earlier occasion, we conducted the program immediately after vacation, where they are not in vacation, those officers. But this time, by the time vacation is declared to us, these auditorium is not available and the hostels are not available. Therefore, we could not have the benefit of these facilities. Decided to conduct the program on these three days where all these facilities are available. But unfortunately, those officers who are in charge officers for different works, for different purposes, are on leave. They delegated those powers to other officers. Due to some communication gap, there may be some lapses causing inconvenience to some of our friends. Please kindly bear with that. By this time, all those might have been rectified, and your stay will be comfortable for the remaining period. If anything is there, number there may be any issue of individual concern or a general issues any time during your stay. Please kindly please note down 8317 680-863. I will repeat 8317-680-863. This is Mr. Vinod. And another number, Mr. Ebenezer. Me number. 9949-739413. You can feel free to contact any one of them for any issue. Thank you.
Good morning, everyone. We welcome all the participants for today's event. I request the Honorable Chairman, Sri N. Dwarkanatha Reddy Garu, the Chairman of the Bar Council of Andhra Pradesh and the President of today's function, to come to the dais and adore the chair. I request Sri Devi Garu, Advocate, to present a bouquet to Honorable Chairman Sri N. Dwarkanatha Reddy Garu. Honorable Sri Justice C.V. Nagarjuna Reddy Garu, distinguished for his erudition and judicious discernment, epitomizes the zenith of legal acumen in the annals of Indian jurisprudence. His illustrious tenure as a jurist reverberates with the resonance of profound legal scholarship and unwavering commitment to justice. Renowned for his perspicacity in navigating complex legal doctrines, Justice C.V. Nagarjuna Reddy Garu remains an indomitable stalwart in upholding the sanctity of law and equity. His jurisprudential legacy is a testament to intellectual rigor and ethical rectitude, emblematic of his enduring impact on the jurisprudential landscape of India. In recognition of his commitment, professional excellence, and legal acumen, he was elevated as Additional Judge, High Court of Andhra Pradesh with effect from 11 September 2006 and appointed as Permanent Judge, High Court of Andhra Pradesh with effect from 10th April 2008. During his tenure, he disposed of over 43,000 main cases, which included about 1,300 reported judgments involving issues of far-reaching importance arising under constitution, administrative, civil and criminal laws. Justice C.V. Nagarjuna Reddy Garu demitted his office as a judge on attaining age of superannuation on 4th December 2019. I request the guest of honor, Honorable Sri Justice C.V. Nagarjuna Reddy Garu, former judge of Combined High Court of Andhra Pradesh and chairman AP Electricity Regulatory Commission, to come to the dais and adore the chair. I request Sri P. Narsinga Rao Garu and S. Brahmananda Reddy Garu, members, Bar Council, to present a bouquet to their lordship. I request the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishnamohan Garu, to come to the dais and adore the chair. I request Dr. Kamasai Garu, Senior Professor, to present a bouquet to Sri S. Krishnamohan Garu. I request Senior Advocate and member of the Bar Council of Andhra Pradesh and Program Coordinator Sri Ganta Ramarao Garu to come to the dais and adore the chair. I request Amravati Garu, advocate from Vishakhapatnam, to present a bouquet to Sri Ganta Ramarao Garu. I preside over the program to the President of Bar Council, to the Chairman of Bar Council, Sri N. Dwarkanatha Reddy Garu.
A man, no introduction in the judicial field of Andhra Pradesh. As a judge of the Honorable High Court of AP, his judgments will be referred for another 50 years. Such C.V. Nagarjuna Reddy, personally, as a chairman of the Bar Council, I call him as a judicial warrior. I do not know why somebody can say why he is a judicial warrior, but High Court advocates know that how he fought against the system itself. Such a man is before you, and he will present today's subject, the art of advocacy. Before asking him to speak on this particular art of advocacy, I'd like to say, apart from that, after retirement, he is now the chairman of the Andhra Pradesh Electricity Regulation Commission. And he is doing a wonderful job as far as the electricity reforms is concerned. I request you, sir, to address the gathering on the art of advocacy. Thank you.
The chairman of the Bar Council of Andhra Pradesh, Sri Dwarakanath Reddy, Vice Chairman, Sir Krishna Mohan, my former colleague on the disciplinary committee, Mr. Ganta Ramarao, my dear friends, Bar Council members, learned advocates, professors, law students, ladies and gentlemen. This is a great opportunity for me to be amongst you, especially post-retirement. People like me yearn for this kind of an opportunity because your very presence itself has the effect of recharging the spirits. So I profoundly thank the Bar Council led by its ebullient chairman, Mr. Dwarakanath Reddy, for giving me this opportunity of being before you. When the chairman, Mr. Dwarakanath Reddy, requested me to spare a session, giving me the freedom of choosing the topic, after pondering over for a while, I thought I should address on the topic, the art of advocacy. The reason I chose this topic is that it has eternal importance and perennial relevance. Art of advocacy is the bread and butter of a very practicing advocate. Without an advocate perfecting that art, he may earn money, but he cannot earn the fame of being a good or outstanding advocate. We keep, in fact, in my experience, I used to hear certain comments about some advocates. There were very notable advocates among them, but I don't want to name them. A counsel, when he is asked by somebody whether he has a point in the case, he says, I have no point in my case, but the opposite counsel is my strength. That means what? A counsel appearing against him is a self-goal master. Not because he is not knowledgeable, not because he is not competent, but because he lacks the art of advocacy. He will not put forth his point as per the mood of the judge. He will not stress a point which ought to be stressed. He will overemphasize a point which does not require such overemphasis. So, as a result of all this, because of the lack of advocacy, he will allow the other side to have better of him. So, this is the kind of importance which advocacy plays its role in the professional life of every advocate. When we hear the word of advocacy, we generally feel that it's a misconception, if I rather say, that advocacy starts only in court and ends in court. In my personal view, that may not be correct. Advocacy starts from the time of one's enrollment. It starts with the advocate choosing his chambers or office. We keep hearing about the pedigree. You know what pedigree is? It is generally referred to dogs. Before we buy a puppy, we inquire its pedigree. What is its father? What is its mother? What is its breed? What kind of nature it has? Whether it is savage, whether it is friendly, so on and so forth. Before we bet on a horse, we inquire about from which stable the horse comes. The great lawyer Mr. Fali Nariman, in his book Before Memory Fades, he refers to this exact point. Before you choose the chambers of senior, you should know about his pedigree. You should know about the traditions the office follows, the culture, the working culture, the environment, all that matters. Because finally, it is the fragrance of the goodness of that office which pervades you, at least during the initial professional days, your initial professional days. And it is the stench of the bad office which haunts you. Because I kept hearing during my practicing days that if somebody, even out of mistake, makes a misstatement of fact, and incidentally he came from not so an office which from an office which doesn't have a great reputation, people used to call, what else it is expected from him except this misrepresentation. So this is how I say that the stench emanated from the bad office always haunts you in your professional days. You may be a very good lawyer, but you will not be trusted. So the first and foremost step, I hope there are budding lawyers, there are also law students, this is very much relevant for them to know that you need to choose a good office. Good office need not necessarily be a very rich office. An office which adopts best practices in profession. An office which has proper culture, environment, working culture. All this make an office a good office. So one has to be very choosy in selecting the office. Once you get into the office, you have to learn, and there is no end for learning. In fact, I for one, in my initial days, when I was with my first senior, Mr. R. Venugopal Reddy, who later became Advocate General, he had a peculiar habit of starting his office at 8:30 or 9 p.m. We, the juniors, used to go to the office at around 7:30 after finishing early dinner, then finish whatever work he has assigned to us and wait for his arrival. We used to keep our drafts ready for his perusal. So he used to call the juniors one by one. By the time he finishes with all the juniors, it will be around 11 to 11:30 night. Then by the time we reach our home, it will be around 12. Then again, by 8 o'clock, we should be in the office. So this is the kind of commitment with which we worked in his office. And I should say that if I am standing before you today, it is only because of that hard learning I had in his office for 5 years that made me stand in my profession. Of course, I should not forget my later senior, Mr. V.R. Reddy, who also became Advocate General later, who gave me immense opportunities to represent the cases, to get that kind of exposure. All that exposure I could only because of my hard work I have put in during the initial 5 years period. And when it comes to learning, the younger generation may not know what kind of hard work we used to put in. I should say it's a donkey's job. Donkey's job because we never used to have the advantage of this information technology. If we are to look for legal position and pick out any decisions, we needed to consult digests, annual digests, that is called yearly digests, biennial digests, 5 years digest, decennial digest, quinquennial digest, whatnot. So we had to dust all those digests and keep on turning the pages topic wise. And if at long last we are able to get one judgment relevant, and to our disappointment we used to find that was already overruled. So this was the kind of learning or the method of learning we went through. But today, sorry, please don't. But today, just by a click of the button, you will get all the decisions, including overruled decisions. So it has become, your job has become so very easy that in a time of 1 hour or 2 hours, you can have the entire legal position in your grip. So this is the great advantage you have in learning. Please don't allow this kind of opportunities to fritter away. So learning is very, very important. And during the course of learning, you should win the confidence of your senior. That's very important. There may be 10 juniors in an office, but the senior will not trust all 10. He will only trust only those who put in real hard work and who will be of use to him. That you should remember. So you should always be ready to assist your senior. You should win his confidence so that he will give you more and more opportunities to represent in the court. Then, once you become independent, you have to deal with your clients. How do you deal with your client? That is also a part of art of advocacy. I know of advocates who are very rough with the clients. I know of some advocates who used to throw the files on the faces of the clients. I know of the advocates who never shares anything with the client. These are all bad examples. After all, the client is your paymaster. As Gandhiji said, the customer is your god, the client is your god. You owe your existence to the client. Without client, you are not there, there is no profession. That we should remember. But unfortunately, at least some of the advocates, if not all, some are very courteous, no doubt, treat the clients in a very rough manner. Please, one should not do that. Justice Kodandaramaiah, if I remember correctly, I read some 30 years back a book written by him on professional ethics. He said, please always remember your client is going to be your potential adversary. Your client will be your potential, maybe your potential adversary, because we have been seeing hundreds of cases being filed against the advocates by the clients before the Bar Council. That's what he really meant. So we should always keep in mind that the client is your valued customer. You should always be good with him. Then you have to share before you accept the brief, you have to share the probability of success with the client, your opinion. Of course, you should never be judgmental, because you are not a judge to judge what will be the final outcome of the case. But you should always give a hint to the client whether there is any possibility of success, whether it is a strong case or weak case. If you feel it is a weak case, you have to tell the client that you have to take the risk. Then ultimately it is for the client to decide whether to file the case or not to file the case. In fact, up to one stage, I used to commit a very fundamental mistake of turning away the client, saying that this is a weak case, in spite of his request that I should file cases. Finally, he will land up in some other advocate's office, he will file it, and I found to my amusement that he could even get stay in those cases, interim orders in those cases. So we should not be judgmental, but at the same time, we have to tell the client about the prospects of his success in the case, and then you have to leave it to the wish of the client to file the case or not to file the case. Another important aspect is charging the fees. How will you charge the fees? Some advocates, at least if not all, I wish advocate fees rules are followed. Some of the advocates will not touch the file unless fees is fixed. According to me, it's a bad practice. You should never turn away your client based on fees. The reason being, I will tell you the reason also. There is always what is called cross-subsidization. There may be a case where there will be windfall for an advocate without putting much efforts. There may be another case where you struggle a lot, you prepare a lot, you make all out efforts, but you may not be able to get proper fees. But what is earned by you in the first case, wherein you have not put in much efforts, will compensate for the case where you did not charge proper fees. I will recount my own experience in this regard. I was standing counsel for Electricity Board, AP State Electricity Board. Water. I used to have many cases for the entire combined Andhra Pradesh. All non-service matters used to be looked after by me. Sorry. And compared to today's level of fees, it was a pittance. If it is a writ petition, we used to get 250 rupees per writ petition. And in batch cases, for first case 250 rupees, and in other cases 100 rupees. A huge matter involving I can say those days itself, about 1,000 crores. I'm talking about 1990. That subject related to categorization of consumers. A new category was formed. It's called power intensive category among the industrial consumers. That was challenged. AP Ferroalloys Corporation was the leading client, Navabharat Ferroalloys Corporation, and two other companies. They were huge industries paying at least 15 to 20 crores towards electricity charges those days. Because for ferroalloys industry, electricity is the raw material. So I was a temporary standing counsel for some time, and then on completion of my 10 years of standing, my fortune could have it. I was appointed as standing counsel for APS State Electricity Board, youngest standing counsel. And Chief Justice Majmudar, a saintly judge, was the presiding judge, and he didn't know me. I can say, at the age of, with 10 years standing, for a new Chief Justice coming from outside, I was a non-entity. So, on the other side, my adversary was Mr. Ananta Babu. Ananta Babu was standing counsel for APSCB for 25 years. And then after ceasing to be standing counsel, he started filing cases against APSCB. So that was the advantage for him, and his personality, overwhelming personality, great personality. Then the case was heard. For 2.5 days, Mr. Ananta Babu argued, supported by Mr. Koka Srinivas Murthy, another stalwart, and of course Mr. M.R.K. Chaudhary was also there. And then when I started my argument, Justice Majumdar did not allow me to speak even for half an hour. I had to face volley of questions. So I had to swallow all that, and then slowly made my way through. And I took about 1.5 days to finally convince the court. They totally tilted in my favor. Then, in the reply, you know what Mr. Ananta Babu started? He had great felicity of expression. My lord, my young learned friend, with all his resilience, picked up something from my argument and something from your lordship's observations, and knitted a great case which has absolutely no substance. This is how he started his reply. And that showed his frustration, because he knew that the bench was totally in my favor, leaned to my favor. A bench which was totally against me, completely leaned in my favor. Finally, I succeeded. It's a reported judgment. I think AR 1990 AP Ferroalloys Corporation versus AP State Electricity Board. Ferroalloys Corporation, FACR, not AP. Ferroalloys Corporation versus AP State Electricity Board. The bench consisting of Chief Justice Majmudar and Justice Bhaskar Rao, A. Bhaskar Rao, Y. Bhaskar Rao. And the real essence in this story is, I had to charge my fees. How much I charge? The kind of efforts I have put in, you can't believe. For almost 1 month, I lost my sleep, because on the one side there are stalwarts advocates, and the case is inherently weak, I should tell you. It is inherently weak. Every day I used to call my chief engineer, superintending engineer, DE to my office. After completing my initial work, I used to sit with them every day for 1 hour, 1.5 hours. We dug into the record. I tried to make a case, a new case, in order to justify this classification, which in my personal opinion was absolutely not justified. There was no justification at all. But as a lawyer, I had to my duty. So, with the kind of effort I have put in, I thought any amount of fees will not justify the efforts I have made. And how, if I make a claim, how much I claim? By the time it was 500 rupees per writ petition. For first writ petition 500, next 3 cases 250, 250, 250, 750, 1250 rupees. Even if somebody pays me 5 lakhs of rupees, that would not be worth the efforts I have made. You know what I said? I refuse to claim fees. I have not claimed fees. I have not received fees in that case. But that I always etched in my memory that case. It is invaluable. I may not have received the fees, but it is such an invaluable thing. There, you know how I got myself reconciled. After all, the same SCB, AP SCB is paying me fees in various other cases. That would definitely compensate for what I have lost in this case. This is how I reconciled myself. That's why I said, never ever turn away your client only because he is not paying you the kind of fees you propose to charge or you quoted before your client. This is why I have recounted my experience. So this is one aspect. Then I also want to share an anecdote on this the unreasonableness of fees. There were 2 brothers. As usual, they fought for property. So a partition suit was to be filed. So it was a composite Madras state. So jurisdiction being a presidential high court, the Madras High Court used to have original jurisdiction. So one brother went to a lawyer. He was taken rather by some middleman to a big lawyer in Madras. Then the lawyer, after studying the entire case, he quoted a particular fees. Then this man was astonished, shocked. Then he slowly told the lawyer, "Sir, my father tells me that we are only 2 brothers. Means you are claiming a 1/3 share, 1/3 share towards fees. This is not a story. This is actually what has happened. A lawyer who knew this personally told us." So, of course, now I don't want to comment anything about the kind of exorbitant fees many advocates are charging, especially in Supreme Court. And I don't think a common man can afford to indulge in litigation. It's a different matter. As somebody said, advocates' fees rules. That's why I said I wish they charge as per advocates' fees rules. Nobody is just even looks. Then application of law to the facts of the case, and then start drafting your pleadings. How will you draft the pleadings? Of course, if you go to solicitor's office, he will draft 100 or 150 pages pleadings, making repetition, and copiously referring to entire case law, whatever knowledge he has of the case law. According to me, that is not the way of preparation of pleadings. One should remember that the pleadings are being spoken by the parties, not by the advocates. So somehow you have to step into the shoes of the party and then start writing the pleading. Most of the parties may not be knowing anything about law, so why should you state about law? Leave alone citing judgments. So the pleadings must be such that they must be comprehensive on facts. If necessary, you can broadly indicate the legal position. That is all the pleadings about. But all fundamental facts must be stated, because Tomorrow you may not be allowed to amend the pleadings, especially in civil suits. Courts are very strict nowadays, even to allow amendments. So, you must be comprehensive on the facts of the case. You may or may not indicate the legal position also, because it is the job of the advocate to present to service the legal position. In fact, if you write pleadings running to pages, judges may not have the patience to read all that. That may be counterproductive also. There used to be an advocate, even now he is practicing. He is a designated senior advocate. He used to file cases, writ petitions in electricity matters. His affidavits used to run to about 40 to 50 pages with countless number of grounds in the affidavit itself. It was a challenge for me to draft a counter affidavit, because the affidavit was replete with repetitions. So, after going through the affidavit for some time, at some length, we give up and we write whatever is necessary for our counter and file it. He is so agile. During the hearing, he will say, "My lord, my ground number H is not adverted to in the counter. That means it is deemed to be admitted." So, this kind of, it also creates problems to the other side. It's an unfair problem. So, and I know of two advocates, illustrious advocates I can say, and they have adorned the bench, both of them. Their affidavits never used to, exceed 3 pages. And one among them, a constitutional expert, would not even state the facts. He will say, "What is there? I can plead the facts in the court." But according to me, with due respect to them, that is also not the way of preparing pleadings. You must state the essence of your client's case, and all the facts which are relevant for the purpose of the case have to be necessarily stated in the affidavit. You should be luminous. You should be luminous, but not voluminous. Remember it. You should be luminous, but not voluminous. By mere volume, you will not improve the case. But at the same time, you should be luminously stating the essence of your client's case. That's very important. So, follow the middle path. Don't run to 50 pages. Don't restrict to 3 pages. It is not the volume that is important. It is finally the quality of the pleadings which is very important. That should always be remembered. So, this is all part of advocacy. Then, after pleadings, what comes? Presentation. Presentation is such an important thing. At home, you may think of advancing very great arguments. When it comes to your performance, you may not reach even 50% of your expectations. In this regard, I would like to refer to a great person, Robert H. Jackson. Robert H. Jackson, in 1930s, he was Solicitor General of United States of America, who later became Associate Judge. He has put in very humorously how presentation would be. Such a great man, not an ordinary person, great personality. He said, "I always made 3 arguments in every case." This is what he said. "I always made 3 arguments in every case. The one planned." The first argument is one planned. You plan. Second, the one presented, the one planned at home, then the one presented at court, and it consists of what? The arguments which are presented consists of what? Illogical, incoherent, and incomplete. Illogical, incoherent, and incomplete. This is how one presents. And then the third argument remains. When is that argument made? When he goes to bed. At the bedtime, he advances utterly devastating argument he thought of presenting in the court. See how beautifully he has put it. The kind of difficulty in presenting the argument is so lucidly explained by him in such a humorous manner. So this is absolutely true. In fact, in my own experience, I must have come across these situations many a time. I may feel that I'll rip away, I'll rip through the whole thing, I'll convince the judge this and that. Finally, I may not be able to achieve the output of 50% of what I thought. So, your effort is to bridge that gap or reduce that gap between what you plan and what you presented. Then only you will become a very successful lawyer. Then you have to cite case law. You should be abreast of case law. Without application of case law to the facts of the case, you will not be able to succeed. But how much case law you cite is another question. We see many advocates, in fact, in nowadays, I don't know what is happening now. They put the judgments in final hearing matters from left to right, maybe 20, 25 volumes, and it will really scare the judge. Sometimes some judges try to avoid hearing that case also, seeing the voluminous of cases. And then the advocate picks up each judgment, start reading head note and say, no, my lord, this is not relevant, keeps it aside. Then again, take another volume, read something, no, this may not be very much of relevance. Finally, out of those 25 books, he may be citing 2 or 3 relevant judgments, if at all at the best. Why scare the judge? So this is called the case diarrhea. Case diarrhea. Don't suffer from that. Mr. Nariman, in his book Before Memory Fades, you have to read that book. Before Memory Fades, Nariman's book is called Before Memory Fades. He says, don't suffer from case diarrhea. Case law diarrhea, sorry. Case law diarrhea. Too much of case law leads to diarrhea. That's not good. That will irk the judge. See, in the process, you know, Nanna Pulivache. See, if you cite 10 unimportant judgments, and later if you cite 1 important judgment, the judge will ignore that important judgment also. So that will lose its significance. So don't suffer from case law diarrhea. Cite relevant cases. And there is another important aspect, most important aspect. If you have 5 points in a case, which point you argue first? But Mr. Naireddy, which point you argue first? Huh? Loud. No. If you have 5 points, you may have best point, you may have not so good point, you may have bad point. Which point you argue? All right. Emma, which point you argue? Will you put forth the best point first or reserve it later? Huh? Best point at first. But there was an interesting conversation between Lord Hailsham of Marylebone Lord Hailsham of Marylebone. He was a member of House of Lords. And Wilfred Green, MR. Wilfred Green, a very celebrated judge of Court of Appeal. MR means Master of Rolls. A presiding judge of Court of Appeal in England used to be called MR. So there was an interesting conversation when they met one day. Mr. Green, Justice Green has asked this Lord Hailsham of Marylebone, which point you argue? He said, of course, best point. He said, no, you should argue the weakest point first. He says, see, if you start arguing weakest point, the judge will ask you, no, Mr. Gentleman, no, you go to next point. All right, next point is also not that good. All right, go to next point. Next point is also not good. Already, finally, you come to the best point. And you should not, he says, you should not assert that this is the best point. You should, with pretended hesitancy, say, my lord, I have this point. Then the judge will, if he is sensible, he will pick it up and he will start arguing for the counsel. Yes, this is the best point. Yes, my lord, I am obliged to your lordships. So this is how, after all, these are all perceptions. See, you may be right also, because it all depends upon the judge, because if there is an impatient judge, if you put forth all your bad points, weak points first, then he will not consider the best point also. So it's a double-edged weapon, no doubt. But see, these are the two celebrated personalities between whom this discussion has taken place. So perceptions vary. You have to finally play by the ear. This is the most important aspect. See, nobody will teach you the absolute art of advocacy, I am telling you. These are all tips. Out of your own experience, your intelligence, your legal acumen, your common sense, you have to finally build your case. And there are many times when we innovate our arguments on feet. Even most of you who are active practitioners must have experienced it. Certain points which we never thought of in our chambers. Suddenly, those points crop up in the court when you argue. That is called developing the argument on feet. So, this is, I can say, this comes by your inherent nature, your experience, your wisdom, so many things. So these are all, whatever I am saying, are basic things of advocacy. Then it all depends upon you, how to improve upon it. So then, if a judge is not with you, what will you do? No point in persisting. No point in persisting with it. All right, you go to the next point. And if he is with you, it's all right. You can abandon the first point. If he is not with you on the second point, go to the third point, go to the final point. Finally, you can say, my lord, I would like to press the first point again. Maybe there may be change of mind in the judge's mind. So, this is again part of art of advocacy. Then, always try to be polite. Never question the wisdom of the judges, because that will be rubbing the judge on wrong side. A judge may be wise, he may not be that wise. I don't want to use any derogatory words also. So all that you have good, bad, and indifferent judges. See, like a king is always right. King does no wrong. A judge does no wrong. So long as you are in his court, he is always right. So whatever he says, don't question him. But at the same time, don't be meek and weak. Put forth your point with assertion also, nothing wrong. But don't be disrespectful. Don't question the wisdom. And when a judge asks you to clarify on a point, bad habit for many advocates is, I'll come to that a little later, my lord. I'll come to that a little later. That will definitely irk the judge, and it will create an impression in the mind of the judge that you are going to avoid answering the judge. Never ever say that. Whenever a clarification is sought, you need to, it is your obligation and responsibility and duty to clarify to the judge as and when he puts you that question. And some advocates will be there who said, who is habituated to say, if some proposition comes from the judge, he says, I never heard such a proposition. In my experience, I never experienced this. All that will be counterproductive. Avoid saying that. Avoid confrontation. He may be a bad judge, but doesn't matter, because the power of pen is with him, not with you. What will you do? If you exceed your limits, you will be attracting contempt. Of course, there are some advocates who thrive on belligerence. They always question the judge. They always try to bully the judge. They are called bullies. And they mount personal attack on judges. Mr. Nariman, in his book, said once he severely attacked the opposite counsel by name Kirit Rawal. Kirit Rawal, the then additional Solicitor General. He was very unfair in mounting attack on him. The other side counsel, Mr. Kirit Rawal, did not utter a word. He did not even respond. Justice R.C. Lahoti, the then Chief Justice of India, he was hearing the case. He was presiding over the bench. He said, Mr. Nariman, it is time for you to stop practice. You are very unfair in your attack. It is time for you to stop practice. You know, Mr. Nariman said, he acknowledged R.C. Lahoti's comment and said, I am thankful for Justice Lahoti for making that comment, because I was so unfair to the other side counsel. So he says, never ever join issue with the other side counsel. Always be respectful to the other side counsel. I have seen many advocates who always used to look at the other side while submitting their arguments. They seldom look at the judge. He always looks at the other side. And there are some advocates who, at the end of every sentence, look at the gallery, playing to the gallery. See, these are all very, very unhealthy practices. And maybe by bullying, one may make some short-term gain, but in the long run, no judge will like such people. When I was the judge, there were some advocates who were very, very quarrelsome, and judges used to be afraid of them. And you know, without offending anybody, I would say that one advocate for 17 judges said, not before me, against one advocate. 17 judges. And most of those cases used to be posted before me. Of course, I never had any trouble. I never had any trouble with them. I knew how to deal with them, and they were also acknowledging it. And one advocate went to the extent of saying in open court, that troublesome advocate, that if your lordships doesn't do justice, nobody else will do justice. First, we should know how to deal with, and he was commenting privately that, see, I am trying to somehow corner this judge. He is such a smart judge, he never got caught. he did not give me that opportunity at all. So, of course, all judges may not have that kind of attitude. That's a different matter. We can't blame them. But in the first place, the advocates have no business to behave like that. After all, you have come here, you are a professional. You are a professional. You are not here to settle score with the judges. See, if you hit your head against wall, will wall break or your head break? Same thing. Howsoever weak the judge may be, you can't fight with him. Why should you fight? That is not your job. Your job is to fight for the client, not to fight against the judge. This is the fundamental thing a lawyer should always remember. You may have many issues, but that doesn't matter. When you are in the court, you should always be respectful. By being respectful, you will gain everything, but not lose anything. Whereas, by being offensive and rough, you lose everything. You lose not only the case, you lose the judge also. So that you should be very, very careful about. Then, you are an officer of the court, that everybody knows. When it comes to assisting the court, you should always be fair to the court. Your duty is first to the court, then only to your client. See, I had a very piquant situation. I was arguing a land acquisition appeal before a division bench. That was a case where, based on the oral evidence, certain compensation was fixed, ignoring the sale deeds. One of the parties to the sale deeds came before the court and deposed that no doubt a particular consideration is mentioned in the sale deed, but it is not that consideration. I have paid much more, which is in fact, generally it happens. Only for registration value, lesser value is shown, and the party always pays higher money. So he said, instead of 50,000, for example, I paid 1 lakh per acre, so take 1 lakh as the value. Then the lower court has taken 1 lakh and fixed compensation. The government filed appeals. It was a huge batch of appeals from Mahbubnagar. Then I was appearing for the farmers who lost the land in Priyadarshini Jurala project. Then the division bench, very intelligently, the presiding judge asked me, Mr. Reddy, please tell us whether oral evidence can exclude the documentary evidence. Then I don't know what to say, because I had to say it cannot be. But if I say that directly, then I'll be losing, my client will lose a lot of money, huge money. Then I said, and he said, I know about your fairness. I'll give you some time. You examine the legal position and place all the judgments before me. Then I went back. I have picked up at least half a dozen judgments, including the judgments of Privy Council, which refer to Section 91 of the Indian Evidence Act, which says that oral evidence is not admissible to displace the terms of documentary evidence, the terms in the document. Exclusion of oral evidence is the caption of Section 91 of the Indian Evidence Act. Then I placed all those judgments before the division bench. And I said, see, every recital in a document, in a sale deed, will not constitute term, but the quantum of consideration definitely constitutes a term. One can say a person who received who is shown to have received consideration in the document can come into the box and say that I have not received compensation, and that is admissible. Whereas, if he admits receiving compensation, he cannot say I have not received 50,000, I have received 1 lakh. He cannot say that because the quantum of consideration constitutes the term of the document. So the term cannot be replaced by oral evidence, is the proposition, legal proposition. So I cited half a dozen judgments against myself. The result is my client has lost 50% of the compensation. But I have won the confidence of the judge. As a lawyer, I have won the confidence of the judge, though some loss is caused to my client. That's why you should always be fair to the court first before you are fair to your client. Then, finally, I will come to the concluding part, because we can go on and on, but there is always a time constraint. See, never be humorous in the court, always be serious. But there may be instances where when the court is very serious, the proceedings are very serious, you can certainly lighten up by a certain mild humor. But Mr. Nariman again said, you should always be careful when you deal with the court. You will be dealing with the fire. So don't cross your limits in humor. Because after all, everybody will not be like Mr. G. Ramaswamy. I don't know how many of you have heard Mr. G. Ramaswamy. He was Attorney General of India. And he used to crack any joke and get away. One day, in Supreme Court, he was advancing a very ridiculous proposition, very ridiculous. The presiding judge asked him, Mr. Ramaswamy, do you feel we are fools to accept this proposition? Pat came the reply, my lord, I am put in a quandary. If I say yes, I will be committing contempt. If I say no, I will be committing perjury. But how many of you can get away with this kind of humor? And this happened about 15 years back. I don't know what the present state of the affairs in the courts. I don't know. But everybody cannot be like Ramaswamy. And one more little anecdote. See, I think it's Ramaswamy, somebody, the SLPs were being heard. A subject, wagering contract, cropped up in a case. The judge asked a very smart counsel, Mr. So-and-so, can you give me an example of wagering contract? He said, SLP, my lord. So these are all humor which most of the judges may not take it lightly. So you should be very careful about it. So these are all a few aspects of art of advocacy which I wanted to share with you. And there are many, many more aspects which could be discussed maybe at a different time. So finally, before I conclude, I once again thank all of you for patient hearing, and once again thank Mr. Dwarakanath Reddy and his team for giving me this opportunity. Thank you.
Thank you, Justice Nagarjuna Reddy Garu, for your excellent experiences, not only as a lawyer, but also as the judge of the Honorable High Court, and now as the chairman of the Andhra Pradesh Electricity Commission chairman. Thank you, and I hope particularly many of the young advocates will take a cue of this experience of the Justice Nagarjuna Reddy Garu and imbibe yourself in your professional field in future of your life. Thank you, Mr. Nagarjuna Reddy Garu. Now I request all the Bar Council members to come over to the dais and felicitate the guest, Justice Nagarjuna Reddy Garu.
take a break of 10 minutes and please be back by 12. Let's take a short break. Please be back by 12 o'clock. I request all the advocates to be seated. I repeat, I request all the advocates to be seated in their places. I request all the advocates to be seated in their places. The program will commence shortly. I request all the advocates to be seated in their places. I request all the advocates to be seated in their places. I repeat, I request all the advocates to be seated in their places. I request the Honorable Sri N. Dwarkanatha Reddy Garu, the Chairman, the Chairman of the Bar Council of Andhra Pradesh and the President of today's function to come to the dais and adore the chair. I request Prashanti to present a bouquet to Honorable Chairman Sri N. Dwarkanatha Reddy Garu. Honorable Justice Lavu Nageshwar Rao Garu, a distinguished jurist and former judge of the Supreme Court of India, is renowned for his profound legal acumen and contributions to Indian jurisprudence. With a career marked by integrity and expertise, his tenure on the bench exemplified meticulous adherence to constitutional principles and fair dispensation of justice. His judgments have significantly shaped legal precedents in India. And some judgments, in some cases like Narendra versus K. Meena, Krishna Kumar Singh versus State of Bihar, or Abhiram Singh versus C.D. Komachin, have made into textbooks, preparing today's students to be better advocates tomorrow. He always had reflected a deep commitment to upholding the rule of law and protecting fundamental rights. Honorable Justice Lavu Nageshwar Rao Garu's legacy continues to inspire and influence the legal fraternity, making him a respected figure in India's judicial history. I request the guest of honor, Honorable Sri Justice Lavu Nageshwar Rao Garu, the former Judge, Supreme Court of India, to come to the dais and adore the chair. I request V. Chandrasekhar Reddy Garu and Y. Nagi Reddy Garu, members, Bar Council, to present a bouquet to their lordship. I request the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishna Mohan Garu, to come to the dais and adore the chair. I request Lavanya to present a bouquet to Sri S. Krishna Mohan Garu. I request Senior Advocate and member of the Bar Council of Andhra Pradesh and Program Coordinator Sri Ganta Ramarao Garu to come to the dais and adore the chair. I request Maushmi to present a bouquet to Sri Ganta Ramarao Garu. I hereby preside the program to the Chairman of Bar Council, Sri N. Dwarkanatha Reddy Garu.
Thank you, sir. I'm welcoming the former judge of the Supreme Court, Honorable Justice Nageshwar Rao Garu. Many of you know that he is the son of the soil, hail from these places, adored the bench of the Supreme Court, and on our invitation, he came here to address all of you. Listen carefully, make a note of it, and study well of that particular what the justice is saying, and review it after going to your offices. Now I request Honorable Justice Nageshwar Rao Garu to present on the role of bar and bench in the administration of justice.
The chairman of the Bar Council. I think I'm audible. Yeah. I hope I am audible. Andariki vinpadutundi kadandi? Yeah. The Vice President and members of the Bar Council. My friend Justice Nagarjuna Reddy, Justice Ramakrishna Prasad. I don't know whether there are other judges of the Andhra Pradesh High Court. I'm sorry if I'm not able to recognize them. Members of the Bar Council and ladies and gentlemen, andariki namaskaram. Nenu ninna sayantram I'll be speaking in English as well as Telugu. I think it will be much easier for you also to understand what I'm saying. I'm not saying that you don't understand English, but I'll be more comfortable in speaking in Telugu also with you. నేను నిన్న సాయంత్రం మార్నింగ్ నుంచి సాయంత్రం దాకా పనిచేసి ఢిల్లీలో ఎయిర్పోర్ట్కి వచ్చాను. వచ్చిన తర్వాత ఇవాళ మాట్లాడాలి కదా అని ఆలోచిస్తున్నాను ఏం మాట్లాడాలని. ముందు నేను ఇక్కడికి వచ్చి మాట్లాడింది మీరు గుర్తుపెట్టుకుంటారా లేదనేది నాకు అనుమానం వచ్చింది. The first thing I was thinking about is what is the impression that I can create on all of you. As the chairman of the Bar Council was telling you, I come from a small village which is about 50 kilometers from here. I'm like any of you sitting in this crowd. At your age, I was also sitting like you and hearing some judges coming in and speaking, telling the lawyers about how they're important to the society, what they should do, what is public service, what is learning, etc. I should confess that I did not pay much attention when those judges were speaking. But I realized later that there's so much you can learn from the experience of persons who have led their life in law. నేను అలాంటి వాడినే 40 ఏళ్ళు లాయర్గా ఉన్నాను, జడ్జిగా కూడా ఉన్నాను. నేను ఇప్పుడు మొదలెట్టినట్టుగా చదువులో చాలా యావరేజ్ స్టూడెంట్. నేనేమో లా స్కూల్స్లో చదువుకోలేదు, ఆంధ్ర క్రిస్టియన్ కాలేజ్లో చదువుకున్నాను. When I was reading, I don't remember going to classes every day. I should confess that I was going to college only for a few days. Those were the days when people were trying for some other professions. ఎక్కడ పనికి రాకపోతే లా ప్రాక్టీస్ మొదలెట్టే రోజులు అవి. So I went to Delhi. I had high hopes of becoming an IAS officer or an IPS officer. 1 year I stayed there and then wrote my civil service examination. I couldn't get through. దాని తర్వాత ఏం చేయాలా, లా డిగ్రీ ఇచ్చారు కదా, సో ప్రాక్టీస్ మొదలెట్టాలని ప్రాక్టీస్ మొదలెట్టాను. ఇక్కడేనండి నేను ప్రాక్టీస్ గుంటూరులోనే మొదలెట్టాను. I was here for a year. Then I thought that I should shift to a higher court. అందుకని హైకోర్టుకి వెళ్ళాను. హైకోర్టులో 10 ఏళ్ళు ప్రాక్టీస్ చేసిన తర్వాత I thought that I needed to challenge myself. Then I thought I should go to the Supreme Court. I was doing pretty well in the High Court. I had a number of cases. I had a number of juniors working with me. Ramarao was my colleague when I was a junior to Mr. Y. Suranarayana, from whom I have learnt everything. I owe what I am today to him. I worked for 5 years with him. Thereafter, all my friends were suggesting that I'm committing a mistake going to Delhi, because I'm pretty comfortable here and Delhi is a lottery. ఢిల్లీ వెళ్తే వర్క్ ఉంటుందా లేదా, మళ్ళీ ఏం చేయాలని. సరే మళ్ళీ నేను చెప్పే కదా మా ఊరు ఇక్కడే అని, ప్రాక్టీస్ లేకపోతే మా ఊరు వెళ్ళిపోతాను. మళ్ళీ ప్రాక్టీస్ చేయలేం కదా హైకోర్టుకి వచ్చి. I took that challenge and went. I'm telling you all this not to tell about myself. I'm telling you all this so that you can relate your lives with me. Not that I've achieved much. There's absolutely nothing I've achieved. There's so much to achieve. I see a future for myself at the age of 66, 67. So then I started practicing law. I had no godfathers. I'm not from a lawyer's family. I'm from a farmer's family. I found my feet. I really worked hard, worked for about 14 hours a day. I continue to work for 14 hours even now, which means just take this 95, I shifted to Delhi. From then to now, every day I work for 14 hours. Why I'm telling you that I'm working for 14 hours is trying to tell you that all of you have to work if you have to succeed. I keep repeating this. Whatever I'm talking, I want you to reflect and then see what is it that you can learn from somebody's life, a person like you who has risen and become a Supreme Court judge after practicing law for so many years. I was very fortunate in getting opportunities. Getting an opportunity to argue in a court itself is something very difficult, especially in higher courts, the High Court or the Supreme Court. ఎవరైనా నమ్మొచ్చి కేసు ఇవ్వాలి కదా సుప్రీం కోర్టులో ఆర్గ్యూ చేయమని, ఎందుకంటే దానిపైన మళ్ళీ అప్పీల్ లేదు. సో యు గో అండ్ దెన్ fortune favored me, so I got number of opportunities and I was doing very well. జీవితంలో జడ్జి అవుదామని ఉద్దేశం ఎప్పుడూ లేదండి నాకు. I never wanted to become a judge. When I was asked to become a High Court judge when I was about 42 years, the Chief Justice told me that I can go to any High Court in this country. It took me only 2 seconds to tell him I don't want to become a judge, because I wanted to become a lawyer. I loved being a lawyer. Even today I repent why I accepted judgeship. Because a lawyer's life is much more thrilling than the life of a judge. The satisfaction that a lawyer gets when he succeeds in a matter for his client, I don't think I experienced it when I was a judge for 6 years. I'm not saying judgeship is not good. I'll tell you as I go on as to how important a judge is to the society. But for me personally, I always felt that being a lawyer is something very lucky for a person to be in such a great profession. And succeeding as a lawyer is something every person who joins law would want to. So that's what you work for. Initially, when I was asked to become a Supreme Court judge, I said no. Again, I was asked the second time, I accepted, and then I went back to the verandas. I saw I can't miss these verandas of the Supreme Court. Going around in the verandas and sitting in the canteen with all friends, I thought that's more interesting than sitting as a judge and hearing cases from morning to evening. Again, I withdrew the consent. When I was asked the third time in 2016, I thought destiny was chasing me. Even then, I told the Chief Justice, I'll come back tomorrow morning and tell you. He said, no, you sign now and go. I was in Pathurst in court. Then he told me there are 3 other judges whose appointments are waiting for you. I can't give you any time. I don't know, some weak moment I accepted and signed. Next day I went and asked the Chief Justice, can I withdraw? He said, I've already sent it to the government. So there's nothing we can do about it. So I became a judge. Now I'm telling you, the role of a judge is also very important in the society. I enjoyed being a judge. To the best of my ability, I think that I have done whatever I could do as a judge for 6 years. After laying down office in 2022, I have started doing arbitrations, which is, you know what an arbitration is, the adjudication again outside court under the Arbitration Act. I do not only domestic arbitrations, international arbitrations in London, Singapore, Dubai, also in South Africa. This is where I said that I want to do something more. I want to challenge myself. I want all of you to learn to challenge yourself. You don't need to see a competitor in somebody else. Every person, every human being rather, in whatever profession he might be, should feel that he should excel in whatever he's doing. You should think of being at the top. You dream high. You might not reach there. Then only you will reach somewhere. There's no point in being in the crowd. There's no point in saying it's all right, I'm also leading my life. So every person should definitely think about what he is going to be in the next 5 years, what is going to be in the next 10 years, the next 15 years. I just told you all this only because you should realize you don't need to come from an affluent family. You don't need to come from an advocate's family. You don't need to be a son or a daughter of a judge to succeed in this profession. Each one of you can succeed in this profession if I could. That is the reason I told you what my life is all about, and I also want you to realize that it's not very difficult. The only thing that you have to do is work hard, be in the right place at the right time, and make the correct choice as to what you want to do. This is what you will have to realize. And once you do this, I don't think it's very difficult to succeed in this profession. I'm not going to speak much today. I want you to speak. This is going to be an interactive session. I'll ask you a few small questions and I want answers from you, and thereafter I want you to tell me what you understand about the role of an advocate or a role of a judge in the administration of justice. You know what administration of justice is. This is what courts do, administering justice. So what is the role of a lawyer in this? What is the role of a judge? I'll just speak for another 10-15 minutes, and then I want you to speak. I want to understand from you what you think about the role is. What do you think the deficiencies are? And what do you expect? You're all lawyers. What do you expect from judges about their role in administration of justice? So this is how we will proceed. I'll ask you to answer later. I want you to tell me what is the difference between law and justice. Sattaniki, Nyayaniki, Teda enti? Are they the same? Are they interrelated? Please think, and then I'll ask you a little later after 15-20 minutes. I want whoever can tell me what is the difference between these two, you please tell me. And the other thing is, I think most of your courts would be having a statue of Lady of Justice outside your courts. And she is blindfolded. In some of the courts following the US practice, she has a sword also, along with the balance in her hand. Why is this Lady of Justice blindfolded? So you just think about it and tell me if you know why is this Lady of Justice to whom we all go and then see, and then sometimes we go and then garland her when we go to courts as judges. Why is she blindfolded? Later, you just reserve for yourself after 10-15 minutes. I want whoever can tell me what it is all about. I'm not testing your knowledge again, please don't misunderstand me. I just want to understand whether people give importance to small things like this. We are all told that we are in a noble profession. Why do you call this a noble profession? How are we different from other professions like a chartered accountant or a doctor or an engineer? They are also part of building the society. How are we different? Why do we call ourselves noble profession? You must have heard about this. I'm not very sure, but I'll tell you. To bring change in the society, kill all lawyers is what Shakespeare said in one of his plays. అంటే మనం విషం అన్నమాట, అందరం చంపేమని లాయర్లు అందరం, అప్పుడే సొసైటీ బాగుంటుంది. షేక్స్పియర్. But we are also called reptiles. సొసైటీలో చెడు మాట్లాడే ప్రొఫెషన్ ఏదైనా ఉందంటే నెంబర్ 1 మనమే, లాయర్స్. తర్వాత డాక్టర్లు, హాస్పిటల్ డబ్బులు తీసుకుంటున్నాయి, అవన్నీ తర్వాత. ఫస్ట్ లాయర్స్. ది ఎనిమీ ఆఫ్ ద సొసైటీ is lawyers. Why is this? On one hand, we call ourselves belonging to a noble profession. On the other, we are accused of all these things. Do we deserve this? So this is something which I think we should think about. What is this? Lawyers are not treated well in the society. And what is the role that we play in the administration of justice? Lawyers play the most important role in the administration of justice. What is administration of justice? We have laws, we have to implement those laws. And the courts are there. The courts enforce the constitution as well as the laws. And judges cannot enforce these laws without the assistance of lawyers. I'm telling you, without the assistance of lawyers, it's impossible for a judge to administer justice. That's how important the profession of law is. I will not say that you are two wheels of a chariot. Actually, you are the bigger wheel. The role of a judge in this administration of justice is definitely not as important as the role of a lawyer. Why do I say this? The confidence of public in the institution of judiciary is pivot to good administration of justice, which means that it's so important. ముందు ప్రజలకి మన ఇన్స్టిట్యూషన్ పైన నమ్మకం లేకపోతే ఇంక ఇన్స్టిట్యూషన్ నడవదు. So if people have to have confidence in the institution of judiciary, that is only through lawyers. You are the ones who are interacting with the clients who are coming to court, or people who want to approach the courts for administration of justice or for justice. Administration is done by the court for justice. So for them to come to court, you should inspire confidence in them that you will get justice if you go to court. Resolving dispute is the most important thing for harmony in the society. Otherwise, there will be absolutely, it will be a jungle. It will not be a civilized society. And resolution of disputes happens through lawyers. So the question each one of us have to put to ourselves is that are we equipped to do our jobs in getting justice to our clients? లా పాస్ అయ్యాం బాగానే ఉంది. లా పాస్ అయిన తర్వాత మనం ఏం చేసాం అనేది ఇంపార్టెంట్. నేను చెప్పే కదా, నేను లా పాస్ అయ్యాను ఏసీ కాలేజ్ నుంచి. బట్ when I went to Hyderabad, when I started practice, I found that I don't know anything. I went to Delhi, I started practice, I thought that, my God, there's so much to learn. I became a judge and then I was thinking that, how do I manage this? I don't know anything. Even today, I feel that there's so much to learn. Whatever we know is only a drop in the ocean. Law is very vast. How do we learn it? So, even if we haven't had good education by not being fortunate in going to national law schools, etc., we have come from some traditional law schools like AC College or some other college, you can improve. You can learn. Let me tell you, ladies and gentlemen, people who have studied Telugu medium, who did not study in convents, have risen to be Supreme Court judges, have risen to be one of the best lawyers in the country, only by hard work and industry. They've learned. They've learned by the way, they've learned by reading, they've learned by working hard. So it's not as if anything is beyond us once we start learning. We had a senior counsel from Andhra Pradesh in the Supreme Court by name Mr. P.P. Rao. I don't know how many of you have heard about him. Chanpere. ఆయన నేను ఢిల్లీ వెళ్ళిన తర్వాత ఐ వెంట్ అండ్ మెట్ హిమ్ ట్వైస్ ఆర్ థ్రైస్ వెల్ బ్రీఫింగ్ ఇన్ టు ఆర్గ్యూ మ్యాటర్స్. ఒకసారి పోయి బ్రీఫ్ చేస్తే హీ యూస్ టు మేక్ నోట్స్ అండ్ దెన్ అండర్లైన్ ఎవ్రీథింగ్, అగైన్ గెట్ ద టెక్స్ట్ and then dictate whatever he has to argue to the stenographer. You again go to him after a month in the same matter to brief him. ఆయన ఈ ఎక్సర్సైజ్ మళ్ళీ రిపీట్ చేసేవాడు. నార్మల్గా తెలుగుగల లాయర్లు ఏమంటారంటే, నేను ఆల్రెడీ చదివే కదా, నువ్వు నన్ను బ్రీఫ్ చేసావు, నా నోట్స్ కూడా ఉంది, నేను ఆర్గ్యూ చేస్తాను, వెళ్ళాను, ఏదైనా కొత్తగా ఏదైనా ఉంటే చెప్పను. You go to him the third time, he'll again do it. I asked him, why are you doing all this? Then he told me, నేను మిగతా వాళ్ళలాగా అంత తెలియగలను కాదు, బట్ ఐ ట్రై టు మ్యాచ్ దెమ్ బై వర్కింగ్ దట్ ఎక్స్ట్రా అవర్. దిస్ ఈస్ సంథింగ్ విచ్ ఐ హవ్ లెర్న్డ్. ఐఎమ్ ఆల్సో అన్ యావరేజ్ పర్సన్. టు కంపీట్ విత్ పర్సన్స్ హూ ఆర్ మోర్ కాంపిటెంట్, హూ ఆర్ మోర్ ఇంటెలిజెంట్, హూజ్ ఐక్యూ ఈజ్ మోర్, ద ఓన్లీ వే యూ కెన్ డూ ఇట్ ఈస్ వర్క్ a little more harder. You read the brief twice, thrice, 4 times. You read the law. You read it again and again. You will definitely learn. ఎంత మట్టి బుర్ర అయినా కూడా 10 సార్లు చదివితే ఆటోమేటిక్గా గుర్తుంటుంది. సో ఆల్ దిస్ ఈస్ ఇండస్ట్రీ. సో ఫస్ట్ థింగ్స్ వాట్ వీ హ్యావ్ టు డూ ఈస్, ఆఫ్టర్ యూ కమ్ అవుట్ ఆఫ్ కాలేజ్, డోంట్ థింక్ దట్ వీ హ్యావ్ అ లా డిగ్రీ, దర్ ఇస్ నథింగ్ టు లెర్న్. యూ హ్యావ్ 3 new criminal laws coming into force in another 15-20 days. Have we started working? Have we started looking into the law? What is the advice that we are going to give to the clients if we don't know what the law is? There's a complete change. Even persons who have been practicing for 40 years, I know IPC, I know CRPC, I know Evidence Act. But there are amendments that are made to all the 3 acts. The sections have changed, the philosophy has changed in some of the chapters. How are we going to tell the client about all these things when they come to us? So we will have to first start reading. So I think I would advise you to buy books if you haven't bought, and then start reading now itself. I'm not saying that you haven't. Most of you must have purchased, but some of you must have been taking it easy. Let us see when it comes. Please don't do that, because you are going to advise clients tomorrow. There are amendments that are made to even provisions pertaining to arrest, etc. So if somebody from your ilaka is coming and asking you what are the provisions relating to arrest, what are the safeguards, you might not be able to advise them properly. The major problem is with half-baked lawyers not advising the clients properly and the clients not getting justice in courts. That's not what administration of justice is about. I'm just telling you about the criminal procedure code, etc., because every law has to be ingrained by you. Every law, with which you are comfortable. Assume that I'm doing only motor vehicle accidents case. At least I should be proficient in that branch of law, because I have to advise clients who are coming to me, telling them that this is the law. Law keeps changing. Supreme Court writes one judgment today, writes another judgment in another next month. Unless you keep abreast yourself about what is happening in courts, you would not be able to advise them properly. So the role that is played by a lawyer in the administration of justice starts with learning. Learning is something which I said is a lifelong experience. Youngsters who are coming out of college, you will have to think that my recognition as a lawyer should come from my merit of being a lawyer, nothing else. ఏదో పార్టీలో జడ్జిని కలిసాము, ఆయనకి ఏదో కాఫీ ఇచ్చాము, ప్లేట్ అందించాము, దీంతో ఆర్డర్ ఇస్తాడు అనుకునేది చాలా పొరపాటు. ప్లీజ్ డోంట్ థింక్ లైక్ దట్. Don't run behind judges. Don't think that by recommendations you are going to succeed in this profession. Some of them might, but that's not the proper way to succeed in the profession. Your recognition should come by your performance in court. You're every day in a theater, and your performance is watched now by the entire world because of these virtual hearings, but otherwise at least people who are sitting in court, the judge as well as the lawyers, your compatriots as well as the clients, and the manner in which you acquit yourself in court is what you're going to get work from. That's the only way you can get work from. With recommendations you can get appointments, but you won't get work. You might be appointed to some corporations as standing counsel, get work, but otherwise, insofar as private work is concerned, it will come only through your merit. Every lawyer should think of improving his merit. Every lawyer should be recognized only by the manner in which he behaves with the bar, the manner in which he acquits himself in court, as well as the learning that he has of the subject. So, learning is something which is non-negotiable. నేను చదవకుండా ప్రాక్టీస్లో ఉంటాను అనేది చాలా పొరపాటు. డబ్బులు సంపాదించవచ్చు, డబ్బులు సంపాదించడానికి ప్రొఫెషన్ ఎందుకంటే ఇంకేదైనా చేయొచ్చు, స్క్రాప్ అమ్ముకోవచ్చు. మనం నల్ల కోట్లు వేసుకొని పెద్ద లాయరు, సొసైటీలో నాకు చాలా మర్యాద ఉంది, కానీ ఐ థింక్ ఆల్ దిస్ ఈజ్ నాట్ గుడ్. దట్స్ ద రీజన్ వీఆర్ కాల్డ్ రెప్టైల్స్. So if you want to be a responsible lawyer playing a part in the administration of justice, first things first, you'll have to be a learned person. Being a learned person is not going to come overnight. నా దగ్గర ఒక జూనియర్ ఉండేవాడు ఢిల్లీలో. ఆయన ఒక నెలలోనో 2 నెలల్లోనో కపిల్ సిపుల్ అయిపోదామని ప్రయత్నం చేశాడు. ఏం చేసేవాడు, రాత్రి అంతా చదువుతూ ఉండేవాడు. రాత్రి పగలు జడ్జిమెంట్లు చదువుతూ ఉండేవాడు. చదివితే అర్థం కాదండి అలాగా. నేను కూడా ట్రై చేశాను, చదవని, బట్ త్వరలోకి ఎక్కాలి కదా. ఇట్స్ నాట్ దట్ ఈజీ. యాజ్ ఐ సెడ్, ఇట్స్ ఎ లైఫ్ లాంగ్ ఎక్స్పీరియన్స్. యూ లెర్న్ by the hour, you learn by the day, you learn by the month and a year. సో ఒకసారి చదవకపోతే 2 సార్లు అలాగా. బట్ అదర్వైజ్ సడన్గా ఒక క్యాప్స్యూల్ లాగా 1 నెల రోజుల్లోనో 2 నెలల్లోనో అన్నీ వచ్చేయాలంటే అయ్యే పని కాదు. అందుకని లెర్నింగ్ కూడా కాన్స్టెంట్గా ఉండాలి. ఐఎమ్ నాట్ సేయింగ్ మీరు ఋషుల్లాగా అన్ని పనులు మానేసి పుస్తకాలే పట్టుకోమని కాదు. యూ ప్లీజ్ సెటప్ టైమ్ ఎవ్రీ డే. యంగ్స్టర్స్, యూ థింక్ దట్ ఐఎమ్ గోయింగ్ టు వాట్ ఎవర్ హ్యాపెన్స్, ఐఎమ్ గోయింగ్ టు రీడ్ అట్లీస్ట్ ఫర్ 4 hours a day. ఇప్పుడు అందరికీ కంప్యూటర్లు ఉన్నాయండి, అందరి దగ్గర మొబైల్ ఫోన్లు ఉన్నాయి, ఈ యాప్స్, లా యాప్స్ అందరికీ అవైలబుల్గా ఉన్నాయి. పాత రోజుల్లో అంటే నేను జూనియర్గా పనిచేసే రోజుల్లో మా సీనియర్ ఏదన్నా ఒక జడ్జిమెంట్ తీయమంటే అది ఒక జడ్జిమెంట్ వెతకడానికి ఒక డైజెస్ట్ వెతికి దాంట్లోంచి ఒక జడ్జిమెంట్ తీసి ఒక రోజంతా పట్టేది, ఒక 4-5 జడ్జిమెంట్లు తీయటానికి. ఇప్పుడు అదేం అవసరం లేదు. ఐ ఆస్క్ మై కలీగ్స్, ఈ లా క్లాక్స్ కానీ వీళ్ళందరినీ 10 నిమిషాల్లో దే కమ్ అప్ విత్ 25 జడ్జిమెంట్స్, relevant judgments, because everything is at the click of a button. And I'm sure that all of you are acquainted with these computers, etc. So I think you have facilities now where you save time on unnecessary things, and then if you can utilize this time for learning more and more, all of you will definitely play a major role in administration of justice. See, manandar paina there is a big burden on our shoulders. ఏంట్రా అదంటే మన ఇన్స్టిట్యూషన్ పరువు కాపాడుకోవటం. There is a lot of disrepute that is coming even to the institution of judiciary. So all of us have this great burden. Hercules laga manam mostunam danni aa burden. So all of us have to play a role. ఇప్పుడు మన ఇన్స్టిట్యూషన్ లేదంటే మనం అందరం లేము. If people stop having confidence in the judiciary and they don't go to court, మనం పనులు మానేసి ఇంకేదైనా పని చేయాలిపోయి. ప్రస్తుతానికి ఇంకా ఉంది some hope for people in the judiciary. But there's so much said against the judiciary. So we will have to change this perception of people to the judiciary. A person who's coming to any lawyer should feel that I'm getting a proper advice. జడ్జి గారికి డబ్బులు ఇద్దామని చెప్పలేదు లాయర్ గారు, అదర్ సైడ్ మేనేజ్ చేద్దామని చెప్పలేదు లాయర్ గారు. నీ కేసులో పాయింట్ ఉంది, నేను బాగా చదివి ఆర్గ్యూ చేసి నీ కేసు గెలుస్తానని చెప్పాడు. దిస్ ఇస్ హౌ వి షుడ్ బి. ఐఎమ్ కమింగ్ టు ద నెక్స్ట్ పాయింట్ అబౌట్ ది బెస్ట్ ది క్వాలిటీ ఆఫ్ ఎ లాయర్ షుడ్ బి ఇంటిగ్రిటీ. మనిషికి ఇంటిగ్రిటీ లేకపోతే ఐ థింక్ నో పాయింట్ ఇన్ లివింగ్, especially when somebody is coming to you for help. So you should be honest and you should have integrity. So this integrity has to be ingrained in ourselves. I am 100% sure that whatever I am saying is only an ideal situation, utopian antaru. రామరాజ్యంలో మాట్లాడుతున్నాను నేను. నాకు తెలిసి మీరులో పనిచేసేవాళ్ళు, ఇక్కడ ఉన్నవాళ్ళు చాలామంది మఫ్సిల్స్లో లాయర్లుగా ఉంటుంటారు. దట్స్ వాట్ ఐ వాస్ టోల్డ్, మోస్ట్ ఆఫ్ యు ఆర్ ప్రాక్టీసింగ్ ఇన్ ద మఫ్సిల్ కోర్ట్స్. ఐ నో హౌ డిఫికల్ట్ ఇట్ ఈస్. వెన్ యూ స్టార్ట్ ప్రాక్టీసింగ్ లా, you'll have to think of your survival, sustenance. You get married, you'll have to take care of your family, and all of you might not be very fortunate in having sufficient work to take care of yourself and your families. And you are anxious that you have to get work. And in this anxiety to get work, you might not be patient to wait because you don't have the resources to wait. So you might be diverting your path or deviating your path to somehow or other get yours. Go to police stations or go to other people or try to get appointments through political ways. There might be compulsions. I really understand. మన దేశంలో ఉన్న 20 లక్షల మంది లాయర్లు ప్రపంచంలో ఎక్కడ ఉండుంటారు. నేను పొద్దున్నే రామకృష్ణతో అడుగుతున్నాను మాట్లాడుతూ వచ్చేప్పుడు, ఐ వాజ్ టెలింగ్ హిమ్, ఇంతమంది లాయర్లకి ఎక్కడుంది పని కోర్టులో? 5 కోట్ల కేసులు పెండింగ్ ఉన్నాయండి మన దేశంలో. నేను ఎక్కడ పోయిందో చెప్తూ ఉంటాను, 5 కోట్ల కేసులు ఇవన్నీ అయిపోవటానికి ఆ నీతి ఆయోగ్ ప్రకారంగా 326 సంవత్సరాలు పట్టుద్దట. సో అది అయిపోయేలోపు మళ్ళీ ఇంకొక 5 కోట్లు వస్తాయి. మరి ఇన్ని కోట్ల కేసులు పెండింగ్ ఉండి మరి లాయర్లకి వర్క్ ఎందుకు లేదు? సొసైటీలో లానే డిస్పారిటీస్, ఉన్నవాడికి చాలా ఉంది, లేనివాడికి లేదు. I have seen this country. నేను చెప్పా కదా, I was very fortunate in succeeding in the profession. ఈ దేశంలో అన్ని హైకోర్టులోనే ఆర్గ్యూ చేశాను కేసులు. నేను ఈ దేశం నలుమూలలో చూశాను లాయర్ల పరిస్థితి ఏంటనేది. అందుకని అన్నాను లాయర్ పని మానేయకూడదు, అంత ఇంట్రెస్టింగ్గా ఉండేది. నేను కొన్ని కోర్టుల్లో ఆ లాయర్ని వరండాల్లో కూర్చొని పేపర్లు అక్కడ పెట్టుకొని క్లయింట్ల కోసం వెయిట్ చేసే కోర్టులు చూశాను. హైకోర్ట్, నాట్ ఈవెన్ మఫ్సిల్ కోర్ట్స్. ఐ మెన్షన్ అలహాబాద్ హైకోర్ట్. బయట టీ బండిలా ఉంటే ఆ పక్కన బోర్డు పెట్టుకొని లాయర్ గారు కూర్చుంటారు, ఆ టీ వాడితో మాట్లాడతారు. ఇలాగా వేల మంది లాయర్లు ఉన్నారు. నేను ఢిల్లీలో ఒక ఇల్లు కొనుక్కున్నాను, రిజిస్ట్రేషన్ కోసం ఆఫీస్కి వెళ్ళాల్సి వచ్చింది. సరే, నాకు ఎవరైతే ఏజెంట్ ఉన్నాడో తీసుకెళ్ళి ఒక లాయర్ సహాయం అడిగాము, ఆయనకు ఒక 10,000 రూపాయలు ఇవ్వాలన్నాడు. సరే పర్వాలేదు, యూజ్ చేస్తాను. ఆ గ్రేటర్ నోయిడా ఆఫీస్కి వెళ్తే 250 మంది లాయర్లు అక్కడ కూర్చొన్నారండి. వాళ్ళు చేసే పని ఏంటంటే పైరవి. కోర్టులో కేసులు ఆర్గ్యూ చేయటం కాదు, నా దగ్గర ఉన్న పేపర్లు తీసుకొని రిజిస్ట్రార్ దగ్గరికి వెళ్ళి ఆయన దగ్గర సంతకం పెట్టించుకొని పేపర్లన్నీ సరిగ్గా ఉన్నాయో లేదో చూసి తీసుకొచ్చి ఇస్తారు. అండ్ దే గెట్ దట్ 5,000-10,000 రూపీస్. ఐ ఆస్క్డ్ దెమ్, ఎంతమంది లాయర్లు ఉన్నారు ఇక్కడ? He said there are about 500 lawyers in that small registrar's office. So this is how bad the situation is. I fully understand the situation of lawyers at the ground. It's not easy, but you'll have to rise above all this. You'll have to find new avenues of work. కోర్టులో సివిల్ కేసులు తక్కువ ఉన్నాయి. జడ్జిలు అంటారు సివిల్ లా ఎవరు చేయట్లేదండి, అందరూ మోటార్ వెహికల్స్ యాక్సిడెంట్ కేసులే చేస్తున్నారు. లేకపోతే దే ఆర్ ఇంట్రెస్టెడ్ ఓన్లీ ఇన్ బెయిల్ అప్లికేషన్స్ ఆర్ యాంటిసిపేటరీ బెయిల్స్. సో యూ సీ బోత్ సైడ్స్ ఆఫ్ దిస్. నేను ఇక్కడ గుంటూరులో ప్రాక్టీస్ చేసేటప్పుడు గుంటూరు వాజ్ నోన్ టు బి గుడ్ ప్లేస్ వేర్ సీనియర్ సివిల్ లాయర్స్ వేర్ దేర్. ఆఫ్టర్ దట్ ఐ బీన్ ఫైండింగ్ అవుట్ పీపుల్ వేర్ సే చాలా తక్కువ మంది ఉన్నారండి సివిల్ లా చేసేవాళ్ళు. ఎందుకు? వై ఈస్ దట్ డర్త్? That's only because of our being very anxious about making more and more money. నాతో పాటు ఉన్న కలీగ్ ఒక కారు కొనుక్కున్నాడు, నీకు ఇంకా స్కూటరే ఉంది. సో దీస్ ఆర్ ఐ థింక్ థింగ్స్ విచ్ యూ హ్యావ్ టు సప్రెస్ ఫర్ యువర్ సెల్ఫ్. యూ థింక్ అబౌట్ నేను ఏం జరిగినా కూడా నా పని నేను తప్పు చేయను, చదువుకుంటాను, వస్తుంది. అందరికి అవకాశం వస్తుందండి. సమ్ పీపుల్ మైట్ గెట్ ఇట్ 2 years, సమ్ పీపుల్ మైట్ గెట్ ఇట్ ఆఫ్టర్ 10 years. వన్స్ యూ హ్యావ్ ఎంటర్డ్ ద ప్రొఫెషన్ యూ విల్ హ్యావ్ టు వెయిట్. So please wait for your chance and do the right thing. Otherwise you go and then join some law firm or a law company as a law officer or whatever. Don't be in the profession. Because there's no point. Survive avvatam kashtam ainappudu untam kashtam. Tappu matiki cheyadu. That's why I said integrity. This is one quality which would go a long way in improving the administration of justice in this country. I'm talking about lawyers and the qualities that they should have. The learning, integrity. Third one is public service. Why am I talking of public service? See, people call this profession a noble profession because apart from your survival, which is not spoken of, you as a lawyer is supposed to serve the life, liberty and property of an individual. People practicing in the constitutional courts, they argue about rights. You have the fundamental rights, all of you might be knowing, these are the Bill of Rights. So our lawyers very carefully guard these rights of citizens by filing writ petitions, etc. Property is something which is taken care of, not only in the High Court and Supreme Court, if the government is acting in excess, or otherwise even resolving disputes in the civil courts. Public service is because every person in the society looks up to a lawyer. I'm not saying that they're doing it now, but otherwise, I remember Justice Kodandaramaiah, who was a retired judge of the United Andhra Pradesh High Court, if you call him, Justice Narasimha's father. He told me once that he went a long time back to Varanasi and he knew nobody there. He went there and then told some person, he didn't know Hindi also. So he asked him, can you help me? And then the person was not willing to help. And then he told somebody that he is a wakil. The moment he said that he was a wakil, there were 10 people who came to help him. This was early 1960s, 1970s, about 50, 60 years back. He said, Nageshwarao, yanta maryadaya valaki vakil ante. This is the respect that vakil had in the society those days. But do we get the same respect if you go and tell somebody you're an advocate? Merely because we put a sticker on our car that we are an advocate, we think that the police will not stop us. That's how we have come to, and then I know of people wearing black coats in the evenings thinking that whatever they do, police will not do anything. But this will not beget respect. Respect comes only through your demeanor. Respect comes through your behavior. The respect is something which you can't demand, but you can command by your behavior, by your attitude to the society. So respect cannot be asked, so it will not come like that. So we have a dire need to change ourselves. It's not only these 500-600 people here, but let us make a change here. Every day let us think about from today that am I doing the right thing? Where am I? Can I do something for the public? As I was talking to of public service, there are so many people who do not know what their rights are. There are so many people who can't even think of going to court. So if we can just think about those persons, and try to help them. Because you are the persons who are supposed to know law. You are the persons who can enforce law in courts. That's what they are looking to you for. So there is so much of service that can be delivered or rendered by a lawyer apart from taking care of his livelihood. So if you are able to help people in getting justice, that itself is great service. That's why we are different from a doctor or an engineer. That's why we call ourselves a noble profession. I'm going to ask you later as to what you think about a noble profession. Now I've said enough about lawyers. Now how is it that judges can play a role in the administration of justice? I'm telling you, ladies and gentlemen, this job of a judge is very difficult. When I was a senior advocate, there used to be lawyers coming to brief me. I've seen so many advocates coming from various high courts. I'm not talking of our high court. I had more work from other high courts than the Andhra Pradesh High Court, though initially I had a lot of work from Andhra Pradesh. Invariably, at least 4 to 5 out of 10 people used to say that the judge has been purchased. So when I'm reading my brief, I was being told by people sitting opposite me that judge has been purchased. Or otherwise, the other side lawyer was purchased. So I tried to tell them that I can't argue in the Supreme Court that the judge has been purchased. Please don't tell me all this. So you tell me whether there's a point, then only this I can argue. Once we lose a case, there is no necessity of blaming a judge. A judge has to decide either way. There are two people who are going to court. So one person wins the matter, the other person says, this fellow has taken money. It's so easy to accuse a person of not having any integrity, of being corrupt. See our plight as judges of the Constitutional Court. You decide in favor of a private party, people would say that he has taken money from the private party. You decide in favor of a government, people would say that he wants some employment after retirement, that's why he has decided in favor of the government. The poor judges, how can they survive like this? Even when I was a lawyer, I used to tell my juniors, it's all right, we go to court, we argue and then come off. Just look at this people sitting from 10:30 to 4 o'clock hearing all sorts of nonsense being argued in court. And you expect them to be not rude, not aggressive. It is difficult for a human person, for a human being to sit there and then maintain equanimity. So please have some consideration for judges. There might be some judges who are not good judges. There might be judges who do not have the quality of being patient, the quality of not showing tolerance, being aggressive, being rude to lawyers. It is just a reflection of the bar. ఎక్కడి నుంచి వచ్చామండి మేమంతా మీలో నుంచే కదా, పైనుంచి ఊడిపడలేదు. We are all part of you. Someday somebody comes and then says you're going to become a judge, you're a judge, that's all. Otherwise మేమే పెద్ద పరీక్షలు పాస్ అయ్యి మీకంటే ఎక్కువ మార్కులు వచ్చి సెలెక్ట్ అయింది ఏం లేదు ఇక్కడ మన సిస్టంలో. So if lawyers are a reflection of the society, judges are a reflection of the lawyers. When you say so many lawyers are there, అందులో మంచి వాళ్ళు ఉన్నారు, చెడ్డవాళ్ళు ఉన్నారు, తెలివిగల వాళ్ళు ఉన్నారు, తెలివిలేని వాళ్ళు ఉన్నారు, అలానే జడ్జెస్లో కూడా అన్ని రకాలు ఉంటారు. You'll have to put up with them. And I also used to tell my lawyers, don't complain about judge. Your job is to succeed before a judge by arguing in the manner in which you can get an order from him. That's what you're engaged for. What is the difference between you and another person if you're not able to somehow or the other manage with a judge who might not be the person whom you like? So have some consideration to judges and the problems that they have. And I'll also tell you that ఏదో జడ్జి గారికి ఒక కారు ఉంది, పోలీసులు ఉన్నారు, ఓ రెడ్ లైట్ ఉంది, దీనికోసం అని చెప్పి 40 ఏళ్ళు వచ్చిన తర్వాత ప్రతివాడు జడ్జి అయిపోదామని. Don't ever think about you're trying to work your way to become a judge. My experience has been that when somebody asks you to become a judge, you should not refuse it. Otherwise, you don't run behind this post. That should never happen. Because once you are going there, you are going there only to experience power, not to discharge your duty. And if you are not equipped, you are going to suffer every day. కోర్టులో కూర్చొని కేసులు వినేటప్పుడు విషయం తెలియలేదనుకోండి, మీరేదో వచ్చి ఒక పెద్ద లా చెప్పి సుప్రీంకోర్టు జడ్జ్మెంట్లని చెప్తే ఇప్పుడు జడ్జ్మెంట్ రాయాలి కదా. సో వెరీ డిఫికల్ట్ టు డిశ్చార్జ్ డ్యూటీస్. అందుకనే డయాబెటీస్, బ్లడ్ ప్రెషర్ అన్నీ వస్తాయి జడ్జిలకి. Because they're not able to take it every day. It's not that easy. What is it that you expect from a judge? You expect a judge to be impartial. No favoritism, no nepotism. Number two, the most important quality, honesty and integrity. As I told you about lawyers, judges is completely non-negotiable. ఇంటెగ్రిటీ అనేది వాళ్ళకి ఆలోచన లేదు. అది తప్పు చేయకూడదంటే చేయకూడదు అంతే. దట్స్ హౌ ది జడ్జ్ హ్యాస్ టు బీ. జడ్జ్ హ్యాస్ టు బీ పేషెంట్, టాలరెంట్ టు వాట్ ఈస్ హ్యాపెనింగ్ ఇన్ కోర్ట్. ఇట్స్ డిఫికల్ట్, బట్ హ్యావింగ్ యాక్సెప్టెడ్ ద జాబ్, యూ కాన్ కంప్లైన్. If you have to sit, you have to sit from 10:30 to 8 o'clock. But otherwise, you'll have to maintain your equanimity and hear cases. So, with all these qualities, what else do you need from a judge? A judge is seen with some respect. So, it's not only your conduct in court, but even your conduct outside court counts. How a judge is doing whatever he is doing. So, people think that, oh, this is the way a person has to be. All righteousness is seen in a judge. We have some restatement of value for judges and in 1997 lo Supreme Court issue చేశారు. ఓ 15-20 ప్రిన్సిపల్స్ జడ్జెస్ అందరూ అది ఫాలో అవ్వాలి. I've been seeing as a lawyer and as a judge that this is a human quality that all of us want our names to be in the newspapers, photographs to be in the newspapers. Everybody would want publicity, people speaking in TVs, etc. Even judges also are like that. They would also want some publicity for what they are doing. This is something which we should not do. Any publicity should come from your judgments. Any publicity should come from what you do in court. And that you should not work for judges. I know of Supreme Court judges who are only talking to the gallery and not to the lawyer. I've seen my own experience, I know. So this is something which every judge has to keep away from. A judge should not have any sort of a political inclination or a lineage. Absolutely not. I can't be seen to be aligned to a party. There was a high court at some point of time called a court of one party and another party. I'm not speaking of our states. It should not be done. So people should not go to court on the basis of which judge is hearing the case, whether this person is going to hold against a particular political party or people who are sympathizers of the political party. We should not make any comments which give a signal that somebody is aligned to a political party. Even lawyers, every lawyer has a right to support a party. Every lawyer has a right to believe in the philosophy of a party. You know, so many lawyers who become ministers at the center, Kapil Sibal, Chidambaram, Abhishek Singhvi, so many people are there who belong to various political parties, but when they come to court, you should see the camaraderie which they have. They don't fight. I know of this state where people fight on political lines in the bar. Please stop that. Please do stop that. Please don't do that. Don't pollute your bar associations and bar council on the basis of your political inclinations. So, don't do that. That is very bad. Now I'll go back to judges. So judges should not be seen or should not be even perceived to be people who are supporting any party. Even a remote chance of somebody saying that, oh, why are you supporting this party? Orders might be passed. Every order that is passed will definitely be criticized in social media. And we have seen in this state social media even making personal comments against judges. Poor judges, they can't even speak, they can't go to the press, they can't make statements. It is for you to protect the judges. Who will protect the judges? The bar has to come to the forefront to protect the judges. So if judges are also ruffled, if judges do not have the courage to pass an order in a particular case, there is no justice. Why are we talking of administrational justice? Assuming a case is coming before me, I have to decide the bail application of somebody who belongs to a particular political party. Even before I take the bail application in social media, there are news saying that this fellow belongs to the same caste as the person whose bail is taking. What can the judge do? If he recuses, people will say this is not what you are supposed to do. You are a coward. On the other hand, if he decides whichever way, that just imagine the plight of a judge at home. Next day he has to go to court and then decide that matter. Now, fortunately, I did not face in Delhi because caste, etc. is not there. But if you are coming from a particular state, the one thing I want to tell here, gentlemen, this country will not develop unless we give up caste as a mode of identification of a person. Even Ambedkar said in his last speech in the Constituent Assembly, I remember the date, 26th of November 1949, just before the Constitution was adopted. He said, you have got political independence, but we did not get independence because at that point of time there were about 3,500 castes in the country. He said the entire country is divided on the basis of caste. How is it that there is any independence? I don't think the situation has improved even now. I keep on thinking, Manavadu, Navadu, how are we going to develop? And where is this going to? You don't want any person belonging to a different caste, a religion or region to succeed. All the time we are spending only about other people not doing well. In this profession I have seen right from day one, if you are weeping over other fellow's success, you will never succeed. You are not going to do well because the other fellow has done well. He might be incompetent, but he is lucky he has got it. That's how you should be. So please stop thinking on caste lines. Caste is something which has been a bane of the society, especially in this state of Andhra Pradesh. So all of you as lawyers, you will have to enlighten the people that will have to rise above all this. What are we speaking of Article 14? We speak of right to equality. Equality is a part of justice. Everybody has to be equal in the eyes of law. Where is equality? So all of us have to shed this. I'll come back to the last leg of my lecture on how judges would contribute to the administration of justice. I just want to say something. There's nothing serious about it. There's something called the Contempt of Courts Act. So one retired Chief Justice told me that he went to a club in Bangalore and he saw two people fighting about some car being reversed. వెనక్కి వెళ్ళి ఇంకో కార్ని కొట్టాడు వాడు. ఆ కార్లో వాడు దిగి నువ్వెందుకు నా కార్ని కొట్టావంటే వాడు నీ సంగతి తెలుస్తాను, నేను కంటెంప్ట్ నోటీస్ ఇష్యూ చేస్తాను. సో వాడికి అర్థం కాలేదు ఏంటి కంటెంప్ట్ అని. వాట్ ఈస్ దిస్ కంటెంప్ట్? సెడ్ యూ కమ్ అండ్ హిట్ మై కార్ అండ్ దెన్ యూ సే ఇష్యూ కంటెంప్ట్, యూ డూ వాట్ ఎవర్ యూ వాంట్. So then the retired Chief Justice goes there to see what is happening. And then the judge says that, brother, see, this fellow did not stop the car properly. He stopped it here. I went and hit. And that fellow stood up and said, what is this contempt? I don't understand. So for a parking problem also, if a judge is going and saying that I will haul you up for contempt, so how is it that we are dealing with these contempts? I know of a retired judge holding court on a railway platform in Delhi because he was not given a berth. But PS in పిలిచి నుంచోబెట్టి he started saying that I'm going to commit you for contempt. Contempt is not for these purposes, gentlemen and ladies. See, if a judge would want to satisfy himself, to show that he is the boss, And then you want all the officers working in the state or center to come and stand before you from morning to evening. That's not the reason why contempt power has been given. Even in England, where we took the Contempt of Court Act from, has given away contempt. Contempt of Court Act is only for the purpose of showing that there is majesty of law. Because an order passed by the court has to be implemented. What is the use of passing an order? Meero chief case largi chesi, court order pass chesi, order implement avupadi enduku idana dandaga. So people should respect law. People should respect courts. If at all they don't do it, yes, you make them do it by using this coercive sword of contempt. Not for the purpose of personally a judge feeling that I am the boss. That's not to be done. A judge has to sympathize with people who are coming to court. Judge has to be cordial to the bar. And unless the bar and the bench are together without any chinks between them, administration of justice is not possible. You don't like judges, you pass resolutions, you boycott courts. If the judges continue to not behave properly in court, this is what is going to happen. So we have to, every judge has to find a way of dealing with the bar. As I said that lawyers have to deal with the judges, judges also have to learn like that. And what is this administration of justice for? I am telling you, without the judiciary in place in this country, executive would have run amok. And if the judiciary and executive is hand in glove, either kalsiparu anukondi, citizens would have nowhere to go. So judiciary always safeguards the rights of persons by administering justice. In administering justice, without the help of lawyers, the judges cannot do anything. So with the help of lawyers and with the assistance of competent lawyers and efficient lawyers, judges who have integrity, judges who have merit, judges who are efficient, they would be definitely taking our country forward. ఎవరో ఒక ఆయన చెప్పాడు నాతోటి, ఇతను చాలా మంచి ఆవిడండి, కొంచెం జడ్జిగా కన్సిడర్ చేయమని. కానీ జడ్జిగా మంచివాడైతే అల్లుడిని చేసుకోండి, జడ్జి ఎందుకు చేస్తున్నారు? సో మంచికను ఎఫిషియన్సీకి కనెక్షన్ లేదు. యూ షుడ్ బి ఎఫిషియెంట్. నౌ I would want you to tell me what I asked you about, and anything else you can ask me, I will tell you to the best of my knowledge. Can you just pass on a mic? We'll just spend 10 minutes, 10-15 minutes. I think I've taken a long time. Anything, anybody can ask me anything about what they should be and what they should do, whatever you feel about it. There's a gentleman standing there. Constitution continues to be the same. And Constitution is suprema lex, which is the law of the land. So all these new acts, they're all statutes that are made. This is in addition to the power that is there in the Constitution, where the President has the power to pardon, as well as 163 onwards, where the Governor has the power to pardon, remit. They will continue to be the same. CRPC amendment, if I remember right, I've also not read it in detail, that speaks of whether an appeal can be filed against the remission. I think that's what it speaks of. That only takes away the remedy, but otherwise the power is there in the government. Yes?
Good afternoon, sir. I am Ravindra Babu, advocate. My point is,
పర్లేదు చెప్పండి, పర్వాలేదు చెప్పండి.
Advocates are fighting.
ఇద్దరికి చెప్పాలి.
Advocates are fighting mainly because whenever a ruling party is there, they are getting appointed as APPs, PPs like that. This practice is unconstitutional. This is against Article 16 and also against Article 14. A separate class is being created for a ruling party. I want to stop this. If it is stopped by all, then there will be no fighting. Bar will be united. So this is also against Bar Council ethics. they are getting recommendations from MPs, MLAs, and everybody knows it. And the recommendations are with the collectors. So Bar Council also failed to consider this as unethical practice. They should sensitize the advocates. They should not do that. That is my request, and I am going to fight
Against
if
the Bar
anybody
Council?
does.
Yes. See, Bar Council members, to the best of my knowledge, are elected people, isn't it? Number one. Number two, about appointment of law officers of the government. What do you suggest it should be? Because law officers are legal advisor to the government, and the government have the liberty to appoint their own persons. So you have to bring in level playing field should be through political resources. What is it that law can do? Recruitment for law officers. I think the state can make such certain rules saying that there should be recruitment. To do that, file a writ petition. Yes. No, because there's nothing I can comment about it. Whatever you said is correct. Right to? Yeah, correct. See, that's why he says that there should be parity in appointment of law officers. That should be done by the government. Yes.
Sir, good afternoon, sir. Myself, Manoj. I am the final year student of National Law University, Visakhapatnam. Sir, as you said, you said that more than 5 crores cases are pending in this country, and if we see, the people are suffering a lot from in this adversarial system. What would be the solution for this, sir?
There is no solution. But otherwise, I'll tell you. I'm going to tell you something. There is no quick fix solution. There is no magic wand. Recently, I was speaking in a conference in London. They asked me, if you have a magic wand, what is it that you would do? I said, I'll wipe out all the arrears in Indian courts. So, there's no magic wand. But all of you must have heard about this alternate dispute resolution. In alternate dispute resolution, you have arbitration, you have conciliation. Conciliation has gone, now you have mediation. I'm going to talk to you about mediation now. Good that you reminded me. I think the Bar Council recently has made a suggestion to the colleges to include mediation in its curriculum. The Mediation Act has come. And according to the Mediation Act, any private settlement, it need not be through courts, is also enforceable. Though it has not been notified because the rules relating to Mediation Commission are being finalized, it's not been notified. It will be notified very soon. Once that comes, I would suggest that lawyers have to take up mediation seriously. I'll tell you, ladies and gentlemen, I've met people from the mediation bar in Singapore and in London and in the other countries. The mediation bar and lawyers in mediation are making more money than lawyers in litigation. So don't think that this is an activity which is only being done for the purpose of satisfying somebody. Even according to the Mediation Act, there is no problem of charging. Even if you see cases that are referred to by court for mediation, though the schedule is less, there is a thought of increasing even that schedule of fees. To be a mediator, first things first, lawyers should take this seriously, because it will not only wipe out arrears, it will also infuse confidence in the public that their cases are being decided. All of you must be knowing about Section 89 CPC. Before a civil judge starts trial, he should call the parties and ask them as to whether a case before the judge can be sent for mediation. And if the parties agree, the judge sends the case to the court annexed mediation center. I am told now that there are not sufficient mediators who are trained in this state, in this country. So recently, the Supreme Court, which is called the MCPC, Mediation, Conciliation and Project Committee, they're coming out with online modules for mediation training. I'm going to speak to them after the speech. I was trying to tell them, I'm thinking of telling the Bar Council that they should start mediation training for lawyers in the state. I've already spoken to your Chief Justice. He reacted favorably. We have judicial academies here, we don't have academies for lawyers. I've been telling Ramarao for the past 10 years as to the need for starting an academy for lawyers. So if a training can be conducted, if you take up the training, don't think that training is something which you can't go through after spending time. After my retirement, I underwent 2 training courses of mediation of 40 hours each, just to learn what mediation is, just to understand how mediation is going to help in litigation. I found it to be very good. And I was a mediator in very important matters which are pending for 25-30 years because of an assignment by the Supreme Court. The satisfaction that I got while mediating a dispute is completely different from adjudicating a dispute. Both parties go home happily. So there is no winner and a loser. Both parties win. And then you put an end to that litigation. The recommendation that I will make is that all of you take this mediation seriously. Those of you who are interested in mediation in an alternate profession, so you can undergo training, and I'm sure there are so many cases which can be mediated. It's not only family disputes, it's not only diverse matters, commercial matters, consumer matters. All these statutes have a provision that the courts have to send them to mediation, including the Companies Act. There is a provision that mediation has to be attempted first. Please take mediation seriously. And I'm sure that the Bar Council would start this mediation trainings, because I'm heading the Hyderabad Arbitration Center. We have been training people. I will send trainers from Delhi, and if the Bar Council is willing to accept it, we'll have some trainings here for mediation which will help you. Thank you so much.
Sir, regarding noble profession, I feel that this profession has lost its nobility, sir. Basically, majorly because of this law schools. See, but just by paying 15,000 a year, no need to go to the fee. You can college. You are easily getting a degree, sir. And I feel that strongly this regulations should start from the law schools, sir. I feel that Bar Council of India, as prescribed by the Bar Council Act, should regulate these law schools, sir. And basically from that the change begins. What I strongly observe in the state of Andhra Pradesh also, by paying per annum 15,000, no need to go to classes, they are managing the attendance. Simply they will be giving the attendance and you can write the exams and getting a degree. Just advocate. Even that's the situation in the states. So that should be regulated, sir.
Yes, systemic problems.
Yes, sir. And as you said, law and justice. See, law is the road to reach the final destination of justice, sir. But nowadays, if you see that this, even the rowdy sheeters and these people are doing better justice in our area. I am from a small town called Amalapuram, sir, where people have more faith in these people, white and white politicians, than lawyers and courts. Because if you go to a court to settle a partition suit between a family, it is taking 10-12 years. That people simply doing mediation. Give me 5 acres. Okay, you took 5 acres, 5 acres. Done. Simply partition done in one day. Sir, we are getting instant coffee, instant WhatsApp chats, everything instant, but no instant justice in this country, sir.
Yes. Don't be dejected by whatever is happening in Amalapuram. You're going to
Yes,
be
sir.
a lawyer.
Yes, sir. Yes, sir.
So
No,
you
I
should-
just taking it as an illustration.
You should have hope.
Yes, sir.
You
Yes,
should
sir.
have hope
Hoping
that
for
the
that.
system will change.
Yes, sir. There should be some change. Should begin.
Let us hope it will change.
Sure, sir.
We'll
sure,
bring back the nobility together. It's
Sure.
only youngsters like you who can do that.
Sure, sir. Thank you.
Sir, sir, one more thing, sir.
Say we are proud of you.
Thank
Noble
you.
profession, he has expressed a noble profession of law. Actually, we do call you as a baron. Baron, you are a baron. We are proud of you, sir.
Thank you.
Actually, I enrolled in the Supreme Court Bar Association, sir, recently. A small things how to progress in Supreme Court. Let you give a little bit guidance.
Already I have overshot my time.
Sir,
Later.
Sir. Okay, sir.
Sir, one more thing, sir. Sir, this one more thing. See, alternate dispute resolution system is very good for decreasing the case quantity of the case. But in my opinion, ఈ డిస్ప్యూట్ రెజల్యూషన్లో మీడియేషన్లో లాయర్స్ పార్ట్ అండ్ లాయర్స్ని ఎక్స్క్లూడ్ చేస్తున్నారు సార్. ఎందుకు ఈ సిస్టంలో ఈ మీడియేషన్ అనేది, ఈ ఏడిఆర్ అనేది సక్సెస్ కావట్లేదంటే, ఈ లాయర్స్ని ఎప్పుడైతే మీడియేషన్లో ఎక్స్క్లూడ్ చేసి లాయర్స్తో పని లేకుండా ఈ కోర్టులో కేసెస్ ఎప్పుడైతే క్లోజ్ చేస్తున్నారో అప్పుడు లాయర్స్ దీనికి సపోర్ట్ చేయట్లేదు సార్. సో వాట్ మై ఒపీనియన్ ఈజ్, సో బీ పార్ట్ ఆఫ్ ది లాయర్. ఎందుకంటే ఆ మీడియేషన్లో లాయర్స్ని కానీ బోత్ పార్టీస్ని కానీ ఇంక్లూడ్ చేస్తే బోత్ పార్టీస్ని లాయర్స్ కూడా ఉండాలి అని చెప్పేసి ఏదైనా ఒక రూలింగ్స్ కానీ ఏదైనా ఒక సిస్టమ్ కానీ తీసుకొని వస్తే ఈ ఆల్టర్నేట్ డిస్ప్యూట్ రెజల్యూషన్ సిస్టమ్ ఏదైతే మీడియేషన్ ఉంది, ఎందుకంటే ఈ మీడియేషన్ ఈజ్ ఇన్ అవర్ జీన్స్. ఎందుకంటే మనం బిఫోర్ కమింగ్ టు ది కోర్ట్ బోత్ పార్టీస్ ఒక మధ్యస్థం చేసుకొని ఒక మీడియేషన్ చేసుకున్న తర్వాత అక్కడ కుదరకపోతేనే కోర్టుకు వస్తారు. సో ఇక్కడికి వచ్చిన తర్వాత మీడియేషన్ చేసేటప్పుడు ఇక్కడ ఒక బోత్ పార్టీస్కి బోత్ లాయర్స్ ఉంటారు. ఆ లాయర్స్ని కూడా పార్ట్ ఆఫ్ ది మీడియేషన్ చేయకుండా ఉండండి, దానివల్ల ఈ సిస్టమ్ ఫెయిల్ అవుతుంది. సో ఏడీఆర్లో అంటే మీరు ఒక మంచి సజెషన్ చేశారు. సో మీడియేషన్ గురించి మొత్తం అందరికీ చెప్పాలి, లాయర్స్ని ఎడ్యుకేట్ చేయాలని చెప్పి ఈ లాయర్స్ని కూడా ఈ మీడియేషన్లో ఇంక్లూడ్ చేసి, ఎందుకంటే ఆఫ్టర్ ఆల్ ది లాయర్స్ ఆర్ ఈకింగ్ దేర్ లైవ్లీహుడ్ విత్ దిస్ ప్రొఫెషన్. కేసు లాయర్కి తెలియకుండా వెళ్ళిపోయి మీడియేషన్ అయిపోయి క్లోజ్ అయిపోతుంటే ఎక్కడో ఈ కోర్ట్స్లో చూసుకున్న తర్వాతనే లాయర్ తెలుస్తుంది. సో ఇది లేకుండా చేసి లాయర్స్ని కూడా ఇంక్లూడ్ చేసి దీంట్లో పార్ట్ ఆఫ్ ది చేస్తే బాగుంటుందని చెప్పేసి నా ఉద్దేశం సార్.
లాయర్స్ని మీడియేషన్ ప్యానల్స్లో ఇంక్లూడ్ చేయాలంటే
continuation, sir.
Yes.
Just the continuation to him. Continuation to him.
Continuation.
Uh,
Yes.
In this context, the role of police was very well developed in the local system. So, by excluding the advocates, so it is promoting by the, it may be a allegation, so presiding officers.
Yes,
In the
yes,
courts,
I know how the
local
Lok
courts.
Adalat is working. I don't
Okay.
want to be too critical
Num-
about it. But when I said mediation, it's not Lok Adalat. So both of you are not correct in what you're saying. I'm
Yes.
talking about mediations in civil courts.
Civil courts.
And mediators who are appointed are only lawyers, not anybody else. And who is going to be appointed? A trained mediator.
Yes.
And when are you going to get trained? That's the reason why I'm asking all of you get trained. There will be a panel that will be prepared, and only mediators who are lawyers will be appointed. I'm not talking about Lok Adalat. Thank you. Thank you so much. I'll end again by saying, నేను వచ్చేప్పుడు ఏమనుకున్నానో మొదట్లో చెప్పాను. నేను చెప్పిన కొన్నైనా గుర్తుపెట్టుకోండి. I'll be very happy for coming all the way from Delhi to speak to you. Thank you.
Sir, do you have time for one more question? Just one last question. You were saying that we should avoid bench shopping. Don't see which way the judge is inclined to rule. But we don't live in an ideal world. We know that certain judges, even in the Supreme Court, are inclined to rule in a certain way. If we take your advice, how do we balance it with the duty to the client, where we have to get the best outcome for the client also?
See, I never said that you should not raise your voice. A lawyer should be independent, a lawyer should be fearless. Whenever you feel that some injustice is being done, whether it will be the Supreme Court or the High Court, you have a right to raise that, raise your voice to bring it to the notice of the Chief Justice or even to the public that this is what is happening. You know of a few lawyers in the Supreme Court who do it. If you are timid, you can go to them and ask them to raise this point. One thing that you should remember is all lawyers should be courageous as the judges should be. If at all there is something wrong happening on the other side of the bar, the lawyers should not take it lying low. I'm not saying go and beat him up, but otherwise raise the point, raise the issue, and a person definitely would learn. So I can't give any solution to what you are asking. There are instances and instances where wrongdoings are happening, but as a association of lawyers, you are the lawyers who have to raise it up. Please don't take anything lying low. Raise these issues. Thank you.
Thank you.
భారతదేశ ఉన్నత న్యాయస్థానం న్యాయమూర్తి అయిన మన లావు నాగేశ్వరరావు గారి ఇంగ్లీషు తెలుగు మిళిత ప్రసంగములు, వారు న్యాయవాదిగా న్యాయమూర్తిగా వారి ప్రాధాన్యతలు, వారు ఏ విధంగా మెట్టున ఎక్కి సుప్రీంకోర్టు తీరాలు దాటిండే విషయాలు వారు సంక్షిప్తముగా మీకు విన్నవించారు. న్యాయవాదులు ఏ విధంగా ఉండాలి, న్యాయమూర్తులతో ఏ విధంగా మనం ప్రవర్తించాలి, అదే కాకుండా అవసరం వచ్చినప్పుడు ఆ అవసరాన్ని బట్టి అది న్యాయమని నీకు అనిపించినప్పుడు న్యాయమూర్తుల మీద కూడా ఎదుర్కొనే ధైర్యం మనకు ఉండాలి. అంత మాత్రాన రాంగ్ సైడ్ రబ్ చేయొద్దని మారు క్లియర్గా చెప్పారు. చాలా ఉన్నతంగా, ఉదాత్తంగా ఈ ప్రసంగ సారాన్ని మీరందరూ గ్రహించాలని, ఈ ప్రసంగ సారాన్ని మొత్తం ఆంధ్రప్రదేశ్ తీరంలోని న్యాయవాద సంఘాలలో కూడా మీరందరూ ఇక్కడికి వచ్చిన వారు చెప్పాలని, ప్రత్యేకంగా వారికి రాష్ట్ర న్యాయవాద ఉన్నత మండలి తరఫున ప్రత్యేక ధన్యవాదాలు తెలుపుతున్నాను. Now I request all the Bar Council members to come over to the dais to felicitate the guests. Please.
I request the advocates to be seated. We have another session.
If you want a early lunch break, continue, don't rise from your seats. Next session we will continue immediately.
Honorable Justice Sri Gannamaneni Ramakrishna Prasad Garu started his career as a lecturer of law and taught various law subjects in a law college in Guntur. Had set up his practice in the Supreme Court of India, New Delhi in the year 1996 by joining the chamber of Honorable Sri Justice Lavu Nageshwar Rao Garu. He practiced in various realms of law such as constitutional law, administrative law, commercial laws, corporate laws, arbitration law, consumer disputes, medical negligence, civil and criminal cases, pills, service law, land acquisitions, and revenue cases. He had been the standing counsel for various organizations such as APS RTC, GHMC, Andhra University, Acharya Nagarjuna University, Nizam Institute of Medical Sciences, and Sri Venkateshwara University. He had been the Special Standing Counsel for the Government of Nagaland and also served as the Standing Counsel for Rajya Sabha Secretariat and Rajya Sabha TV. He had been practicing in the Supreme Court, High Court of Delhi and Punjab and Haryana High Court, and in various national tribunals in Delhi for 26 years before being elevated as a judge of the High Court of Andhra Pradesh on 14th February 2022. I request the guest of honor, Honorable Sri Justice G. Ramakrishna Prasad Garu, Judge, High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Sri Sunkara Rajendra Prasad Garu and V. Brahmareddy Garu, members, Bar Council, to present a bouquet to their lordship. I hereby request the chairman and Sri M. Dwarkanatha Reddy Garu to preside over the session.
Now I request Mr. Brahmananda Reddy Garu and Rajendra Prasad Garu to come out to the dais and other the bench. Honorable Justice Ramakrishna Prasad, the judge of the Honorable High Court of AP, he will present and he will shed on particularly on the subject of right to property and the constitutional aspects. Thank you, sir.
Honorable Chairman of the Bar Council of Andhra Pradesh, Vice Chairman, the Coordinator, the other dignitaries on the dais and off the dais, friends, ladies and gentlemen, today's session as we have, in which I'm asked to address, is on the right to property vis-a-vis the constitutional aspects. Now Mr. Ganta Ramarao, who had spoken to me, had informed me that most of the participants here are from the trial courts, and then I've asked him as to what is the relevance, because the constitutional aspects of the right to property may not be of a regular relevance for you in the practice, but nevertheless he said that it is good for the trial court lawyers also to know the constitutional rights which are guaranteed with respect to this property, and that would also help you all. Now, this right to property on the constitutional side is a very, very vast subject. Maybe that the kind of amendments which have been brought into force, amendment of the Constitution itself, and the 9th schedule, so many, almost about 250 statutes have been placed into the 9th schedule. What is the significance? I will broadly touch upon without going into the very intricate aspects of it, because they are very, very highly technical, and it requires a very long discourse to explain as to the purpose of each of the amendments to the Constitution and so on and so forth. Now, dealing with the concept of property, the right to property is a very, very cherished right. One of the jurists, Montesquieu, he said that the right to property is so dear that a person may forget the murderer of his father, but a person would never forget in his life who has taken away or snatched away his property. The right to property is so much cherished. That property is the one which gives you a sense of security. Property is the one that indicates wealth. Property is the one that indicates your social status, and so on and so forth. Property is also, apart from the immovable and the tangible property, we also have certain intangible properties like the intellectual property and other things, which I'm sure the other speakers are going to touch upon. Now, the property as such and the ability to hold property originally was only by the muscle, by the strength of the person, because then there were no conferment of title or right to property or anything of that nature. So as the concept of property has evolved from time to time, the states, the administrations, the statutes, they have become very important. Some of the countries, right to property is a fundamental right. In some of the countries, right to property is not a fundamental right, but it's a statutory right. Some of the socialist countries, in those countries, the right to property, there is in fact no such right at all. Or it is said that it is the most indefensible right, which means that no law protects you from the state taking away your property, because there is no ownership of a property, of a private ownership of property as such. That was the situation. That is the present situation even in all the socialist countries. Bill of Rights, America recognizes the right to property as a fundamental right. Now, we deal with this concept today with regard to two periods. One is the pre-independence period and the other is the post-independence period. Right to property in the pre-independence era, the British era, was under the Government of India Act 1935. Section 707 of the Government of India Act had incorporated the provisions with regard to not the right to property, but the manner in which a citizen's property can be taken away. Now, apart from the private rights with regard to property that the trial court advocates regularly deal with under the Transfer of Property Act, and of course under the various agricultural land transfers by way of registration, etc., the state we are concerned with, because the right to property vis-a-vis the Constitution, we will only be discussing as with regard to the power of the state to take away your property, and in what manner can the state exercise its power to take away your property. So the property can be taken by the state only for two reasons. One is for public utility, and the other is that where there is necessity for any other purpose, the state will have to justify that the property can be taken only in accordance with the procedure established by law. Originally, under the Indian Constitution, Article 19(1)(f), Article 19, Subarticle 1, Clause F, which is in the Fundamental Rights chapter, dealt with the right to property. It conferred a fundamental right. Now, before we deal with these, I will just broadly touch upon as to what is the Constitution and what is the significance of the fundamental right, and also as to what is the significance of the directive principles of state policy. As my predecessor, Justice L. Nageshwara Garu, was just mentioning about the Suprema Lex, which is the supreme law of the land, that is the Constitution. As we have enacted it, in Chapter 3 is the core of the Constitution, which deals with fundamental rights. The importance of this is that you will find it under Article 13, Clause 2, which says that state shall not take away or abridge the fundamental rights what are enshrined in Chapter 3. These fundamental rights, starting from Article 12, way up to Article 35, they all are under Chapter 3 of the Constitution, and they deal with the fundamental rights. They confer or they guarantee to the citizens of this country the fundamental rights. Now, when once something is placed in Chapter 3, that is the Fundamental Rights chapter, the state cannot in fact abridge any of these fundamental rights, not even by a procedure established by law. that is the reason why I'm saying that Article 13 is the core of the very constitution itself, which protects the fundamental rights and protects the citizens from being deprived of their fundamental rights only through this Article 13 Clause 2. This is very, very essential. The article, this particular article, by which it says that the state cannot make a law that takes away or abridges a fundamental rights, has become a subject matter of discussion and debate for a long time, ever since the Constitution has been enacted. Now, as you all know that the preamble of the Constitution also deals with the socialistic economy that what is contemplated and the social rights of individuals. Then we have chapter 4 that deals with the directive principles of state policy. These are also important, but the difference between chapter 3 and chapter 4, the students studying constitutional law must be able to say what is the difference. That's okay, that's what I've also said. But what is the difference between these two? I'll just... Exactly, yes, yes. Yes, yes. That's right, very good. So therefore, as a young friend has clarified, that these fundamental rights are justiciable. Directive principles are non-justiciable. Now, what is the meaning of justiciable and what is the effect of something being non-justiciable? Justiciable means if there is a breach to your right with regard to any of the provisions in chapter 3, you can bring an action in the court of law. You can challenge that breach of a fundamental right before the court, before the constitutional court, that is the High Court and the Supreme Court. Whereas the directive principles of state policy are only merely directive in nature, but nevertheless very important. They are very important, but they are non-justiciable. Now, how and in what way are the directive principles, as what I was just mentioning, which are there in part 4 of the Constitution, so important? Article 39 specifically says that the state shall endeavor to reduce the disparities and also in striving towards social justice, and also to see to it that the state's natural resources and the other resources are not concentrated only in a few hands. Today, while we are dealing with the right to property, it becomes very, very essential to understand as to the transformation of the constitutional provisions with dealing with the right to property, why and how they have taken place. So at the time when the Constitution has been adopted by us, the government has rather perceived that 80%, because as I was just mentioning, that Article 39, the state shall endeavor. The state means the government of, be the central government as well as the state governments, shall endeavor to see to it that the natural resources of this nation are not concentrated only in a few hands. That means what? It means that a few people in the country should not be able to, should not be allowed to exploit these natural resources, while the natural resources are meant for the common good, that is to be used for the whole society, the whole nation, people of the whole nation. So in order to give effect to this, the government has seen that 80% of the natural resources, or because India is an agrarian country, and our economy is an agrarian economy. Our economy depends on agriculture. And the country has, our rulers have realized that 80% of the agricultural land which is available is only concentrated only in about 15% of the people. Badly, perhaps because of the British, the administration which concentrated in encouraging the Jamindari system, as they are called as Bhumihars in the north, where the British itself has actually encouraged only few people to hold the land so that these people will be responsible in paying the revenues to British on the land that that is held by them, and allowed this ownership of land to remain only in about 14% or 15% of the people of this country, controlling 80% of the land. Then what can you do? You have fundamental right on one hand which says that the state cannot make a law which takes away a fundamental right. As on the date that we got the independence, 80% of the people, 15% of the people were already owning and holding and controlling 80% of the land. Now, how do you reconcile these two? On one hand, you have the fundamental right not to make a law to take away. Now, a right has already set in the hands of a few people, right of ownership of land. So if you have to take it out, it is this 19(1)(f) which is coming in the way. Article 19, sub-article 1, clause F, which is coming in the way in making any law to take this land from the people who've been holding this land and to distribute it to the landless people. That is what has been perceived, the first constitutional amendment has been made by the Constituent Assembly itself. Now, during the Constituent Assembly debates, now there's a difference between the Parliament of India and the Constituent Assembly. This is also one aspect which, of course, most relevant for the High Court advocates, but definitely even the trial court advocates also should know that the Constituent Assembly has been formed only for a purpose of enacting the Constitution. They are not elected representatives. They have just been appointed immediately after the independence, and their purpose would be served, and it becomes functus officio the moment Constitution is enacted and adopted. Now, thereafter, it is the election which has to take place. The Parliament has to then would become the lawmaker for the country. Then the Constitution also provides a provision which empowers the Parliament to amend the Constitution, that is Article 368. Article 254 is also relevant in the sense that in order to make any amendment to the Constitution, there is a power in the Parliament even to amend any provision of the Constitution. Now, even by this, by the operation of Article 13(2), it can be understood that you can amend anything, but you cannot amend the fundamental right. Whereas fundamental right to hold property is a fundamental right. So, the very Constituent Assembly which has enacted and given the Constitution to the country sat and again had brought in the first amendment to the Constitution. And by the first amendment, Article 31, Article 31A and Article 31B have been inserted into the Constitution, which is also a part of the fundamental right. Now, what is Article 31A and Article 31B? 31A says that anything which relates to the property if any law reforms are brought in, agricultural or agrarian reforms, they cannot be challenged in the court of law on the basis of violation of a fundamental right. Article 31, capital A. Article 31, capital B says, Article 31, capital B has created Schedule 9 of the Constitution. And it says that any statute which is placed in Schedule 9 of the Constitution, again, cannot be challenged in a court of law for violation of a fundamental right. So by this, the Parliament thought that it can now very freely introduce land reforms and so on and so forth. Then the first challenge came, challenging the constitutional amendment, first constitutional amendment, in Shankari Prasad's case. Very interestingly, the issue that was raised is that this first amendment, which is brought by the Constituent Assembly, the challenge is the Constituent Assembly does not have the power to amend the Constitution. Because it is a Constituent Assembly which has enacted the Constitution and given it to the people of this country, exercising its constituent power. Thereafter, it is only the Parliament which can. But again, the Parliament, whether it can amend the fundamental right in such a manner that this fundamental right cannot be challenged in any court of law if a statute is placed in the Schedule 9 of the Constitution. So this is another very interesting brainstorming challenge which has been brought about. Now the Supreme Court has considered these aspects and had felt that the fundamental rights are definitely fundamental. Article 13(2) is the core which protects the violation of a fundamental right of a citizen. But the common good is superior to the individual right of a person. So where a particular statute is intended to bring in a social change by creating for a common purpose, for a common good, then these fundamental rights must give way to the common good. So that is the philosophy which has been advocated by the Supreme Court. And also, on a technical ground, the Supreme Court had said that Article 13(2) only deals with, it states that the state shall not make a law. So the law means it is with reference to the legislation made by the Parliament, and it is not the constituent power under which the Parliament has exercised its right, and therefore these laws are constitutionally valid. It's a bit technical and complicated, but I don't know if I've made my point clear to you. The difference, so the explanation given by the Supreme Court in upholding this particular provision is by saying that the law, the word law which is used in Article 13, Clause 2, refers only to a legislation. Legislation means, see, the Constitution is something different from a legislation. The source of legislation is the Constitution, but the law which is enacted by the Parliament is merely a legislation, and therefore this legislation is not covered by, is not hit directly by the fundamental rights. So in this manner, the Supreme Court had upheld the First Amendment to the Constitution. Then thereafter there is a few amendments, and continuously the states have been enacting various agricultural reforms in the form of, even we also in Andhra Pradesh, we have agricultural reforms. Then we have the Urban Land Ceiling Act, which also was brought into effect. Now all these were protected only because they have been placed in the 9th schedule of the Constitution of India. Then we have thereafter in Sajjan Singh again, the same principle was raised. Then there was a 7th amendment which is made to the Constitution for placing certain acts in the 9th schedule of the Constitution, and that also came to be challenged. Following Shankari Prasad, in Sajjan Singh also Supreme Court has ruled that it is possible and fundamental rights can be abridged only for a common good. Then in Golaknath, 17th amendment to the Constitution came to be challenged, again placing another land reform statute in the 9th schedule. In Golaknath, the court found that this is not possible. So, I think 6 judges majority have ruled that what is said in Shankari Prasad and Sajjan Singh are bad in law, and the state has no power and no right to amend the Constitution in such a manner that it can deprive the fundamental right of a citizen. Now this happened in the year 1963. Now see, look at this situation. From 1951 up to 63, the position was that the states could enact statutes and place them in the 9th schedule so as to keep them away from the challenge by the citizens with regard to violation of a fundamental right. Now a lot of people have already been deprived of their land by virtue of the land ceiling enactments, where for each unit a particular ceiling of land has been fixed, and a unit of a family can only hold a particular extent of land. So over and above that, the land would vest with the government. By then, a lot of people have already lost their lands. Now all of a sudden in Golaknath's case, the Supreme Court then says that this law is bad. Then what is to happen? Should the land be given back? So the Supreme Court had then said that we are overruling the previous judgments prospectively. That means only from today the effect will be there, the protection of a fundamental right will be there, but for the things which have happened in the past, this law, what we are declaring today, is not applicable. That is what is called as the prospective overruling. What is important for us today is only with regard to the situation in which the property law has undergone continuous change. Maximum litigation in this country has happened only with regard to property law. It is a cherished one. Nobody would like to lose right over the property. Then came the Keshwananda's case, which is again related to the property, where the theory of basic structure was propounded. Then that is again a different chapter which will take a lot of time to discuss all the intricacies, but what is necessary in this case is simply to say that there are certain basic structures in the Constitution and you cannot violate it, but at the same time, what has been held in Golaknath and so on and so forth came to stay. So then what happened is, by virtue of the 44th Amendment to the Constitution, Article 19(1)(f), which has been there all along, but has been diluted to a major extent by virtue of this First Amendment, 4th Amendment, 17th Amendment, then partly 24th and 25th Amendments also. The government has realized that so long as this fundamental right remains, then we cannot freely go ahead with these agricultural reforms, and had brought in, by virtue of the 44th Amendment, it had repealed 19(1)(f), Article 19(1)(f). It has repealed and has placed this article from the, removed it from the fundamental rights chapter and has placed it under Article 300A. Article 300A of the Constitution says that a procedure that the state shall not deprive a person of his property except by a procedure established by law. So today the situation is that the law as what it exists, and we have the land acquisition statutes also, that only in public interest and by exercising 19.5 subclause 5, by virtue of reasonable restriction, somebody can be deprived of his right to property only for public purpose. We had the Land Acquisition Act of the 19th century, and that has been repealed, and a new enactment has been brought in the year 2013. So now the compensation, also there's been a lot of litigation as to what is the compensation, what is a just compensation. Today the compensation, the law on compensation is that the real value of the land should be paid to the person who is deprived of his land. So that is the way in which this law has undergone various constitutional changes. Now, if you have any doubts or anything, then you can, because these are issues which will take a very long time to discuss each and every amendment, which is not possible in this today's discussion. But if you have any other doubts on fundamental rights or the right to hold property vis-a-vis the Constitution. Sorry?
Presently going on, sir, Land Title Act, what about that opinions in Land Title Act? Someone are cancelled, that someone are good or bad in the present AP government. Land Title Act. What is your opinion, sir? Land Title, tell me, sir.
I cannot express an opinion as a citizen. As a sitting judge, when the issue comes before us, then we'll be able to deal with it judicially.
Okay.
That is all. So opinions cannot be expressed, please.
Okay, sir.
Only if you have any doubt with regard to the history of law, that can be clarified. Opinions are only given by judges by writing a judgment. Yes.
Sir, this is extend, sir, or cancelled, sir, presently?
Sorry?
Presently, AP Land Title Act extended, sir, cancelled.
That I think you will get it in today's paper, newspaper. Now there is again a constitution bench which is reviewed and again have upheld. Upheld, but certain restrictions have been issued. Now the just to say that
my lord, my perspective about right to property and constitution, my view is, my lord, the conflict only between 19F only. Rest of the fundamental rights were not disputed, Your Honor.
no.
Till such time, right to property remains as a fundamental right.
Yes.
There is a conflict. Interest, public interest at large, and the limited interest, Your Honor.
Yes. Yes.
So, after the Constitutional 44th Amendment, when it is made as a ordinary right, by removing the nature of the fundamental right, the entire class has been settled, Your Honor.
Yes.
Please, my perspective, Your Honor.
That's right. What you said is right.
Please.
What you said is right, and that's what we have just discussed also.
Please.
That it has been reduced into not an ordinary right, not a statutory right. It is a constitutional right.
Constitutional right.
Yes, but the status of a fundamental right is gone.
Yes, please, please.
And now with regard to the 9th schedule, Madam was just asking. 9th schedule, one or two comments I would like to make. Not a comment, but it's a matter of fact that 9th schedule, as what is conceived by the First Amendment to the Constitution, is a unique experiment which is done by our parliament. Nowhere in the world you will ever find such a kind of a schedule which is which is made a part of the constitution and which is kept above the provisions of the even the fundamental rights. This is a very unique experiment which our parliament has done, and by virtue of the judgments of the Supreme Court, 9th schedule came to stay. Came to stay means it is still valid. That is the situation. But when after the 9th schedule has been enacted, this has become a panacea for all the states to place any law under the 9th schedule. Originally, 9th schedule was conceived only for the purpose of bringing in these agricultural reforms and other land reforms. But later, even these various states have been using the 9th schedule for increasing the reservation above 50% and so on and so forth. So even in that respect also, a constitution bench of the Supreme Court had upheld the placement of even the reservation policies and reservation statutes in the 9th schedule, but still it has limited the quantum of reservation only up to 50% and not above 50%. Yes. Anything else? All right. Well, last year exactly about this time, we all have met, and I see a lot of enthusiastic advocates having come here to undergo the training. My endeavor and my appeal to the Bar Council is to make these training sessions more frequent, maybe once quarterly or so on and so forth. And then secondly, there can be a continuous training where the advocates, depending on their free time, maybe once in a month to hold it for a couple of days, but then to make it mandatory for all the advocates who's maybe practice up to 20 years or 30 years practice, up to 30 years, that they should maybe in a period of 5 years, they should undergo training of at least a minimum number of sessions, maybe 4 or 5 sessions over a period of 5 years. If you can do that, then depending on the convenience of the advocates, they can come and enroll, while the sessions can go on continuously, maybe once in every month. A session can go on, and whichever advocates have free time to come and participate, they can enroll even 1 week before or 2-3 days before, come and participate in these sessions and then get a certificate. So over a period of time, say for example, for about 5 years, in a period of 5 years, if an advocate, it becomes compulsory for an advocate to undergo say about 5 sessions. That means 1 session a year. Depending on your convenience, anytime you can come, undergo that session for a couple of days and then go back. So maybe you can think of that also, because in United States, not for the legal profession, but I have seen that medical profession, it is compulsory to undergo periodical training, and the license is medical license for each of the doctors is renewed on this basis. After undergoing, then they have to, for renewal of a medical license, they have to show that they have attended this many classes over a period of this one fixed period. So if you can adopt this method even by the Bar Council, maybe State Bar Council may not be able to do it, but the Bar Council of India should be able to do it for the continual education for the advocates. So wish you all the best in your profession.
Sir,
Thank you very much.
Sir.
Yes.
Sir, myself Sundar Ram, sir, from Telangana. Sir, apart 5th schedule of Constitution, my area covered under the agency tribal area, sir. There is restrictions in the market values and the land exchanging. How the constitutional aspects of the land acquisition in 5th schedule area, scheduled tribes area?
Yes. No, 5th schedule is entirely a different one. That
Then
is
how
under the
constitutional safeguards are-
under agency laws. Under agency laws, the rights are well preserved. It is not only the right to land, but there are bundle of rights or bundle of, say, the cultural rights of a particular tribe and so on and so forth. If they are to be preserved, they are all placed under the 5th schedule.
Then how the land acquisition safeguards in
Sorry?
that land acquisition safeguards are constitutional safeguards in that area. There is no market value, sir. There is no transactions between the registration values.
You know that you need to be more specific. I will not be able to address that.
There is no specific market value, sir. There is no registration act in that. How the constitutional safeguard in the agency areas?
See, agency areas are not free from acquisition, state acquisition, provided they justify a public purpose. They are not free from, they don't have any immunity as such. Now, the agency laws protect the local tribes and so on and so forth. So to see to that extent that the independent buyers will not be able to buy land. If at all they buy, the purchase is void. The purchase itself is not recognized.
Thank you, sir. Please sit, sir. Justice G. Ramakrishna Prasad's presentation on the constitutional law with the right to property is well received by all of our advocates. I want to say a few words about our guest. Our guest first started his practice in the Supreme Court. He come over here as a judge. Yes, and he is also a son of the soil. I thank you very much, sir, for joining with us, along with the number of the advocates who came from all parts of Andhra Pradesh. Certainly, your views regarding the education as far as advocates training on any subject depends particularly on the financial crunch, how the governments are running, either the central government or the state government or other things. Certainly, we will put before the Bar Council of India to take into consideration of this aspect of your session. And I hope so the Bar Council of India take into consideration of the entire India. Until then, please don't think otherwise, my dear young friends, that the Bar Council of Andhra Pradesh has not done in spite of the Honorable Judge has suggested it. We will certainly recommend it. Our Andhra Pradesh is a part of the India, and we are governed by the laws of Bar Council of India. Once the Bar Council of India says, we will oblige it and we will do it. Thank you, sir. Next, Mr. Nagireddy Garu, Chidambaram Garu, and Narsingh Rao Garu to come out, Chandrasekhar Reddy Garu to come out to the dais and join with all the Bar Council members who are on the dais to facilitate the guests. Thank you.
Couple of announcements. Buses are waiting
and we will make a proposal on the council members.
4 onwards, I have been in this field. I
And
have
we will
seen
make a proposal
in
on
due
the
course of my journey
council members.
in my Ulysses, a number of new laws have been came into forth. One day when we were practicing section 6 to section 52,
Please, J.R. Reddy garu, for execution of a decree,
must be practicing law for quite a while. How can they succeed? When you feel happy, or a teacher.
But in a law of adverse possession, declaration is. Can he write 5? So these two.
thank you. Now I request all the Bar Council members who are on the dais to felicitate the Honorable Chief Justice.
With the permission before this program, there are a couple of announcements.
To sit in the cabin in the seat provided.
Remaining period. Important. Sri SRP Garu will present on Act. All of us will be.
Reported judgments involving issues of far-reaching importance arising under Constitution, administration,
led by its ebullient chairman, Mr. Dwarkanath Reddy, for giving so on and so forth. Before we bet on a horse that made me stand in my profession, of course, I should. The real essence in this story is I had to charge my fees. An unfair problem. So, and fixed compensation. I was.
Thank you, sir. Welcoming.
Accepted judgeship. Because a lawyer's life is much more thrilling than the life of a judge. There is going to be confidence of public in the institution of judiciary is pivot to good administration of justice, which means that it's so important. Mundu prajalaki మన ఇన్స్టిట్యూషన్ పైన నమ్మకం లేకపోతే ఇంక ఇన్స్టిట్యూషన్ నడవదు. So if people have to have confidence in the institution of judiciary, that is only through lawyers. You are the ones who are interacting with the clients who are coming to court, or people who want to approach the courts for administration of justice or for justice. Administration is done by the court for justice. So for them to come to court, you should inspire confidence in every law. ఇవన్నీ అయిపోవటానికి ఆ నీతి ఆయోగ్ ప్రకారంగా 326 సంవత్సరాలు పట్టుద్దట. టు ఏ లాయర్, ఐఎమ్ నాట్ సేయింగ్ టు సపోర్ట్ ఏ పార్టీ. See, బార్ కౌన్సిల్ మెంబర్స్
కి బోత్ లాయర్స్ ఉంటారు. ఆ లాయర్స్ కూడా పార్ట్ ఆఫ్ ది మీడియా.
సంఘ సారాన్ని మొత్తం ఆంధ్రప్రదేశ్ తీరంలోని న్యాయవాద సంఘాలలో కూడా మీరందరూ ఇక్కడికి వచ్చిన వారు చెప్పాలని ప్రత్యేకంగా వారికి రాష్ట్ర
at all. Or it is said that it is the most to understand as to the that this fundamental constitutional changes. Now, all right. Well, last year exactly established by law. Article, that is the reason why that you can amend any what is
Hello. 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 Good afternoon, everyone. I request all the advocates to be seated, please. I repeat, I request everyone to be seated. I request the Honorable Sri N. Dwarkanatha Reddy Garu, Chairman of the Bar Council of Andhra Pradesh and the President of today's function, to come to the dais and adore the chair. I request Nageshwar Rao Garu to present a bouquet to Honorable Chairman Sri N. Dwarkanatha Reddy Garu. Born to late Sri Satti Bala Narendra Reddy Garu and Lakshmi Devi, completed Bachelor of Law from Andhra University, Visakhapatnam. After enrollment, initially practiced at Tadepalligudam courts and later shifted practice to Composite High Court of Andhra Pradesh in the year 1996. He joined the chambers of learned senior counsel late Sri VLNGK Murthy Garu. Also flourished practice independently in all branches of law, including civil, criminal, constitutional, taxation service, non-service, motor accident claims and matrimonial cases. Married to Srimati Padma Subba Reddy Garu and blessed with two sons, Mr. Nagendra Reddy Garu and Mr. Fanindra Reddy Garu. Assumed charge as permanent judge of the High Court of Andhra Pradesh on 14th February 2022. I now invite the guest of honor, Honorable Sri Justice Sati Subba Reddy Garu, Judge, High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Sri Y. Nagireddy Garu, members, Bar Council of Andhra Pradesh, to present a bouquet to their lordship. I request the Vice Chairman of the Bar Council of Andhra Pradesh, Sri S. Krishna Mohan Garu, to come to the dais and adore the chair. I request Senior Advocate and Member of the Bar Council of Andhra Pradesh and Program Coordinator, Sri Ganta Ramarao Garu, to come to the dais and adore the chair. I now request our Honorable Chairman of the Bar Council of Andhra Pradesh, Sri N. Dwarkanatha Reddy Garu, to preside over the session.
I request the former public prosecutor of the Andhra Pradesh High Court, Mr. Nagireddy Garu, to come over to the dais, and also Chandrasekhar Reddy Garu, Bar Council members, to come over to the dais. Honorable Justice Subba Reddy Garu, who is a Judge, High Court of Andhra Pradesh, he will present a subject on Specific Relief Act and the Registration Act. Particularly, these particular two acts are very important for trial court advocates. Specific Relief Act and also Registration Act. Now, if you are thorough, 25% of the work is there as far as the Specific Relief Act and the Registration Act. Please make a note, make useful of Justice Sati Subba Reddy Gari speech. Thank you.
Good afternoon. Dignisanti Dayas of the Dayas, my sister Jyotirmayi. Now I have to commence in the presence of my sister there, vast experience on civil side. Yes, sir. Now we'll start with Specific Relief Act 1963. Before we start, let us see the history of this act. This act was initially enacted in 1877 and this continued up to 1963. When this was, the act was enacted in 1877, it was modeled on the New York Civil Code, embodied with British equity codes. That's how the act was enacted in 1877. Then after 9th Law Commission recommendations, this act was this 1963 act came into force, and we are continuing as on today with almost number of amendments. These amendments, recent amendments of 2018, everybody knew about that. The main object of this act is to provide relief to the parties suffered loss or injury due to breach of contract or legal obligation. If you look at this act of relief, SR Act, I'll say SR Act, the main thing is breach of contract and legal obligation. These are all the, if you look at every section, either breach of contract or legal obligation. And it's also, we'll use this act to enforce individual rights and obligations in relation to contracts. If we look at this provisions of the act, if we see these provisions, if we divide this act into some 2 or 3 parts, section 5 to 8 of the act deals with possession and recovery of possession of the possession and recovery of possession. Then the main, whenever we deal with specifically, we'll say the contract. That is section 9 to 24. That is specific performance of contracts. Then the other thing is declaratory reliefs, preventive and declaratory reliefs. That is main. That's we deal with under section 34, 35. Declaratory reliefs, and preventive relief is from 36 to 39, 36, 38, and even up to 39 also it's preventive relief. That's how we have to separate this act. If we separate this act into these parts, it's easy to us to understand the provisions of the act and the gamut of the act also. If we see section 5 of the act, which deals with recovery of specific immovable property, which is in every, wherever especially in trial courts, a person come to us and say that somebody is in possession of the property and he is occupied my land, and I have to file a suit for. You have to file a suit. Then we have to frame it. Is it under section 5 or section 6? Because if it is section 5 or section 6, this is very thin. Section 6 is concerned. Everybody knew. Even a owner disposes a tenant. Within 6 months, he can maintain a suit for recovery of possession under section 6. Within 6 months, you have to specifically plead and prove that I was disposed in a particular day, and I am filing this suit within 6 months thereafter. The difference between 5 and 6, if you see 5 is concerned, you are asking for recovery of possession of the property, basing on title. If you see 5 and 34 have to go together, but 6 is concerned, it's an independent provision where you have to plead that I was disposed in a particular day, and I'm maintaining this suit within 6 months from the date of dispossession. It's a summary in nature, where court will not go into title aspect. Section 6 of the Act, that is something one should know the difference between 5 and 6. And against 6, there is no appeal lie. Section 6 is concerned, no appeal would lie against Section 6 because it's summary in nature. Court is not deciding any title of any party. It's only court will look into whether you are disposed or not. That's the only thing. And whether the disposition within 6 months or not. That is why Section 6 to say no appeal would lie. Six 3. Against the order under section 6, no appeal shall lie from an order of decree passed in any suit issued under this section, nor shall any review or such an order or decree be allowed. That is the reason why only CRPs are being filed against the order under section 6 of the Act. If it is under section 5, court is going to decide as to your ownership. Then if the court satisfies that you are the owner of the property, court, if you have to see, because section 5, we cannot say 5 and 34, that's what I'm saying, 5 and 34, where, for example, a third party comes and deny your title over the property. When you are going to, and he is in possession of the property, then the suit to be filed is suit for declaration coupled with possession. There, section 5 comes into play, where you have to lead evidence as to you have to plead and prove your ownership. Once you prove your ownership, probably court, if the court believes that you are the owner of the property, then court also declares title as well as consequential lease possession. That's where the difference between, if it is 5, you have to again, you have to fall back, the limitation is also something different on 64, 65. But if it is 6, it is only 6 months is the limitation, Act itself specifies that. There is a difference between 5 and 6, you see that. Then the main chapter we are dealing with is in a specific form in the Relief Act is 9 to 25, where enforcement of contract. This enforcement of contract is concerned, the recent amendment of 2018, everybody is thinking that there is a vast changes in the Act and the court now has no discretion. That will come to that. But according to me, still the court got discretion. That I'll discuss with this. If you see section 10 of this amended Act, as per the amended Act of 2018, which comes into operation from 1st August, it seems. Specific performance in respect of contracts, it is subject to section 11 to 14 and 16. This is what the amendment carried out in 2018. The object of this amendment, if you see this object, initially, in fact, if you see this amended Act, there is a time frame also to dispose of the suits. This under this amendment, amended Act of Relief Amendment 2018, the time was 20 months, it seems. Yes, under this amended Act, it is the court shall dispose of within 12 months from the service of summons to the defendant. And this can be extended by 6 more months on an aggregate of regarding regions. The purpose of this amendment is to ensure, if you see these amendments also, section 14 coupled with section 20, the purpose is to see to it that the suits relating to infrastructural agreements, as stated in the schedule under section 41, energy contracts, are these things, they have to be disposed of at the earliest point of time, and the object is to see to it that if I see the object, 6-member committee constituted, they felt that because of this delay in disposal of these cases, the investors, nobody is coming forward to invest the amount in it. That's the main purpose. That's how this amendment was carried out in 2018. That's the reason why section 14 was substituted, and what used is substituted performance, that's the word used in section 14 for the first time under this act. As we know, the traditional practice is that agreement of sale, filing suit for specific performance, and the defense regarding section 12 deals with fault performance. What is the extent of the at what stage we can go for, and if it is the if section 12 to say that if it is only small portion, still you can exercise your right. And all this section 12 and 13 is concerned the rights of purchase of lessee. And section 13B, if you see 13B, this is correlates to section 41 of the TP Act. Section 13B of the Relief Act, the reason why, especially from the lower court, my advice to number of my friends is that please go to senior and at least learn these, because if you see, maybe a good orator in the law school and you'll be first in the moot court, there is no doubt about that. But when it comes to, if you see section 13B here and section 41 of the TP Act, you will there's a complete, in fact, see, section 13B say, where the concurrence of other person is necessary for validating the title, and they are bound to concur at the request of the vendor or lessor, the purchaser or lessee may compel him to procure such concurrence with the conveyance by other person is necessary to validate the title. This is how the language in section 13B speaks. See section 41 of the Relief, Transfer of Property Act, where an ostensible owner, we enter, if we transfer the same for consideration, the transfer shall not voidable on the ground that the transfer was not authorized to make it, provided the transfer after reasonable care, so and so. That's what. Then even after a person who does, the first principle is that nemo dat quat non habet. A person does not convey title better than what he is having. That's the first principle of law we are saying. But under section 41 of the TP Act, an ostensible owner claiming to be the owner of the property, if we alienate the property, by that time we don't have the title, but he acquires the title at a later point of time, still we can enforce saying that because you acquired the title, we can make good my title. The same thing section 13B say of the Relief Act. Section 13B also, concurrence of the other person, this similarity. So section 13B, when it comes to rights of purchaser lessee against the person who has no title, of imperfect title, you have to see these things so that you can also make use of it. Then, under this amendment, section 14 was completely substituted now. Section 14A, a party to a contract has obtained substituted performance of a contract in accordance with section 20. He can't maintain a suit for specific performance except for damages. That is also section 22 say he had to issue notes and section within 30 days. Then what is substituted performance? This is almost, we'll say, a remedial measure. These substituted contracts, the word used in section 14, for example, there is a construction contract. We enter into agreement with a particular person to construct the building. For whatever the reason, the person failed to go ahead with the work and he could not perform as part of the contract. He is waiting for his completion of construction. You can proceed with the construction by a third party agency or by your own. you can complete the work. And after completion of work, you can also you can ask for damages because his failure to perform is part of the contract. The sufferance you suffer, you can maintain a suit for damages. This construction contract, then service contracts, where you engage some labor, some personnel to monitor your service. Then he failed to extend that service. Then you do on your own, or you engage some third party, and the third party quotes more than what the other person quoted, because you suffered. You will not, in the normal course, you are supposed to file specific performance suit, you have to wait till the result. But by virtue of the substituted performance, which has been by virtue of 18 amendment, you can proceed with that. You can complete it. Still, your right for damages remains. But if you complete, section 23 say, once you complete, you can't maintain specific performance, but it will still have a right, so far you are concerned, for damages and for compensation. That is what the nicety of the present amendment. It is because, as I stated, the international community, they are not coming forward to invest the amount in India because the length of time these suits are being taken in India is concerned. This was amended and it's a recommendation by 6-member committee. And for this, as I stated, construction agreement, service contracts, land development, even manufacturing contracts, infrastructure, especially this is what infrastructure projects is something which we have to see that because of this infrastructure projects only, this was in fact incorporated into this. Even engineering contracts, supply contracts, all this comes under that phrase. That is what section 14 speaks about, this supplement performance of this substituted performance. Because see, for example, this infrastructural contracts where a person completes, enter into agreement, and A enter into agreement B to perform certain project where there is some delay or something else, then B resigned it, or B failed to perform, then A entrusted work to C, and after that A issue notice to B, then he files for damages. Then in such a case, court on its own can appoint a commission, an expert, and to get its opinion, his or its opinion, and that can be form part of the record under section 14(3), 14 capital A3. And you can also examine the expert also in this regard. It's not that the plaintiff or defendant can maintain a petition to appoint a commissioner, to refer an expert. The court on its own can do that, because section 14 capital A say, if you see 14 capital A, 14 and 20, the amendment is only to see to it that the suits of this nature, because there is schedule under section 41 where 41 HA, the schedule speaks about transport, energy, water, sanitation, communication, and social commercial infrastructure. That's how the schedule there. These are these contracts where the delay occurred. Nobody can be compensated tomorrow. A person resigns from the contract, then you have to file a suit for specific performance. It takes 10 years. Who is going to bear these expenses? That's the reason why this was incorporated. If you see even section 20B of this Amendment Act, 20B say, no injunction shall be granted. In this section 20B, 20 capital B, sorry, small b, sorry, 20 capital A. No injunction shall be granted by a court in a suit under this Act involving a contract relating to an infrastructure project specified in the schedule, while granting injunction would cause impediment or delay in the progress of completion of such infrastructure project. Section 14 section 11, as I stated, section 10, the specific performance subject to section 11 to 14 and 20. 14 speaks about substituted performance and 20 speaks about the performance of performance and how you have to perform that, because under section 20, clause 1 say is entitled to, but that is subject to, again you have to issue notice within 30 days, then you have to institute. Now, without issuing notice, you can't maintain suit also in that regard, because you are completing your work. Unlike other suit where you have to wait for till, like if it is a regular suit for specific performance, where an agreement between two parties, you can't enforce it without, you can't proceed with further unless a decree is in your favor. But these contracts are concerned, you have to proceed with. Otherwise, tomorrow the escalation of cost and all these things. That is the reason why this amendment of 2018 is mainly concentrated about this contract specified under schedule under 41 HA. Then after the decrease for specific performance, if the balance amount is to be deposited, court will grant certain time. Everybody knew about that. And the failure of the part of the plaintiff to deposit the amount, section 27 and 28, rescission. Notwithstanding the decree, if somebody fails to deposit the amount or adhere to the conditions of the decree, the defendant can maintain an application of section 28 to resign, and the court will examine and pass order even in spite of the decree also. The reason why sometimes we'll say that like a partition, a decree of specific performance is preliminary decree but not final decree. Section 28 operates always. Then the main important is section 31. 31, after full bench judgment of Composite High Court, cancellation of document, where the matter carried to Supreme, it's not directly, but in the other case, Ganga Lakshmi case, it was overruled according to the same. Who has to cancel the document? Person who executes the document or a third party to the document. Shruti Singh's, Justice Ravindran judgment, 2010. It's a very, his lordship dealt with that a person who executes the document is the person who has to cancel the document if you have to maintain a suit for cancellation. Otherwise, a third party to the document has maintained suit for declaration but not for cancellation of document per se. He is not executed. Maybe your right is affected by virtue of this document, particular document which is affected by A in favor of B. But you are not party to the document. You are a third party to the document. Hence, your right, you are supposed to maintain suit for declaration and consequential relief. But you can't maintain suit for cancellation per se. That's how this was Shruti Singh's case. Everybody, if nobody knows, will pass on the 2010 Justice Ravindran judgment. Then section 34, which is every second case in trial court or third case is declaratory suit. Everybody says declaratory suit only. What is declaration? It is legal character. If somebody say that a right to property which has been denied, then you'll maintain suit for declaration. A particular thing to declare a marriage, you are filing suit for declaration. Legal character and property both. Then can you maintain declaratory suit alone, or you have to ask for other ancillary relief? Please see section 35 in this. A suit for declaration per se is not maintainable, per se. For the reason, the ancillary relief you are supposed to ask for, somebody denies your right to the property, and is in possession of the property, you are filing suit for declaration and recovery portion of the property. If somebody is trying to invade, you are asking for declaration injunction, consequential injunction. Somebody is already encroached and made construction, you are asking for mandatory injunction. The purpose is to see to it that the decree should be implementable. A decree for declaration will not give, if it is you can't enforce it tomorrow, it's of no use. The reason why, if you see section 34, proviso, provided that no court shall make any such declaration where the plaintiff, being able to seek further relief than a mere declaration, omits to do so. And the other thing is that once the court declares a decree of declaration, the thing is this is right in rem, it's against world, whole of the world. But section 35 say it's only between the parties to the suit. When we are dealing with declaration injunction, injunction will say that it's personam and declaration is right in rem, against whole of the world, maybe. But for example, A and B, A files a suit against B for declaration and get a suit for declaration and decreed is in his favor. C, who is a third party, he claims better title than A. And if he files a suit against A to declare his right, A cannot plead that no, I have already filed suit against B and there is a decree in my favor. Hence you can't maintain the suit. The reason why the legislation is very clear. If you see section 35, effect of declaration is specifically dealt with in the section 35 of the Act. A declaration made under this chapter is binding only on the parties to the suit, persons claiming through them, and where any of the parties are trustees and the persons for whom, if in existence at the date of the declaration, such parties would be the trustees. So in so many, it's very clear that though it's a decree in rem, but you cannot, if a third party is claiming better title than the decree holder, he can't say that no, it's rem, you can't maintain. Please keep it in mind. Then other thing, injunctions, preventive relief. One is possession, second one is enforcement of contract, then declaration, then preventive. When it comes to preventive, it deals with from 37, 36 say, 37 temporary injunction and temporary and perpetual injunction, 38 speaks about perpetual injunction, 39 say mandatory injunction. Very often we come across everybody using the word, I got temporary injunction or interim injunction. I'm sure there's a lot of difference between ad interim injunction, and perpetual injunction. Especially trial court advocates, sir, please keep the difference between ad interim injunction, temporary injunction and perpetual injunction. Ad interim injunction is concerned where the court grants injunction immediately when you file the application before it without issuing notice to the third party, the other person. Court grants injunction ad interim. Immediately the court, if you satisfy the court, everybody knew that prima facie case, balance of convenience and irreparable loss. The court grants ad interim injunction immediately and then issue notice, direct the plaintiff to take out notice to the defendant or respondent in IA. Then after filing of counter, the court decides whether to continue or to vary the injunction. If the court makes the injunction absolute, that is temporary injunction. Or interim, that will add interim, then it comes it continues till the completion of trial. After trial, if the court decrees, that is permanent injunction. Because we have been saying as an advocate or even after this side, I'm looking at, they said I got injunction. What is the injunction you are getting? According to when somebody also, latest one also where fortunately where and my sister dealt with one case where identity bench was granted and police filed application for police aid. It was, sir, maybe sir, it will carry away, that's except see in injunction, to implement injunction, except judgment of Justice Manavendra Roy, where his lordship said that because identity injunction you can't maintain it. Otherwise, if you go to 82 AP Satyanarayana's case, they say if you don't see the difference between ad interim, temporary, then it says that only injunction is there, okay, implement it. Please maintain this distinction. Whenever you are using words also, please see this, because we have been coming across every time. Ad interim, interim and perpetual. And you know, mandatory injunction is concerned whenever, and the one more thing, we are filing suit for directly for mandatory injunction without asking for declaration. Somebody encroached upon your property and he constructs something, then we are filing also suit for mandatory injunction without asking for declaration. Justice Fazil Ali, 1970 Madras, very classic judgment. His lordship said, you have to ask for declaration of title, then only you can maintain mandatory injunction. The mandatory injunction suit per se is not maintained by 1970. Very, very classic judgment. I'll just pass on that also too. Because see, he may deny your title. Somebody, see, made construction, that means he is there, he made construction, it's not overnight construction sometimes, of course, that's a different thing. Recently now overnight they are making, that's a different thing, but he is in possession of the property, and you ask for mandatory injunction without asking for declaration. There's also, we have to please see that whenever you are asking for mandatory injunction, according to me, you are asking for declaration also. That per se now. Then about 41, injunction when it cannot be granted. When diffuse, we say anti-suit injunction. These things prevent to prevent execution. These things under section 41. When it comes to, this is what the specific relief act mainly say. One is, the first part is possession, second part enforcement of contract, then declaration, after declaration preventive relief. Preventive relief is injunctions. As we said, the object is, at every stage you see breach and legal character. These are, at every stage you will find that. Breach is concerned if somebody encroaches. Then performance is, even that is in 5 and 6 also you will find that. And the second part, declaration, performance of contracts is concerned, there is a breach, somebody tried to breach the contract, then only you are trying to perform it. Perpetual is, preventive is concerned, somebody is trying to encroach upon your, so is invading. So whenever, so that is why the very object is to see to it that whenever you suffer injury, injury should be legal injury and it's relating to contract or other. This is where the Relief Act, Specific Relief Act holds the field. As is stated, Section 13B and Section 41 of TP Act, this relevancy. And when you come to substituted performance, when it comes to damages, again we are going to Section 70 of the Contract Act. Contract, you have to determine the damage on Section 73 of the Contract Act again. The relevancy, see, this Act, Specific Relief Act, Transfer of Property Act and Contract Act, sometimes Sale of Goods Act, You have to read all these things. If you rely upon one single act, say that you want to proceed further, the other act definitely, the section, some defense may raise, because under section 9 you can raise defenses which are legal under the Relief Act. Section 9 speaks about the defenses you're entitled to raise, the defense. And as we know, so far as if civil suit is concerned, pleadings are very much important. Please, the Relief Act, you are not supposed to stop with Relief Act. You have to deal with Relief Act, TP Act, Contract Act, then you have to frame it. And the relevance of Registration Act is concerned, if you see section 3 of the Transfer of Property Act, where it say registration is knowledge to every person. Of course, it's not in that language, but it is what we say. The language, the exact language employed, a person is said to have notice of an act when he actually knows that fact, or when, but for willful abstention from the inquiry or such which ought to have made, or gross negligence, he would have known it. Where it relates to explanation 1, where any transaction relating to immovable property is required by law to be and has been effected by a registered instrument, any person acquiring such property or any part of or share or interest in such property shall be deemed to have notice of such instrument as from the date of registration. That's how somebody say that I am not aware of this registration and I am a bona fide purchaser. Immediately the defense is that section 3, the present service, and you are aware of this. Of course, everything is subject to exception. The exception you have to plead and prove. When we look at this Relief Act and Registration Act, the main thing is section 17 of the Registration Act, the document where the documents require registration, and section 17(1). And 17(b) say exemption also there for registration of certain documents. Because if you see a sale deed under section 54 of the Transfer of Property Act requires registration because if it is more than 100 rupees. Now even 17 of the Registration Act, 17(1)(g), it says that an agreement of sale requires registration, but exception is for 49 again, 49(c). In a suit of specific purpose alone, you can press this for, but even for recovery of amount, in a suit for specific performance, you can't rely upon an unregistered document. It's only an exception to, in a specific performance suit and section 49(c), in unregistered agreement also you can also present it for before the court. And when it comes to the Registration Act, we are executing the documents and presenting it after certain period. A document executed on this particular day, if you present it after 3 months or 52, more than 4 months, I think you have to pay 10% of the registration charges as penalty, subject to document execution. Means we have to see the sign by the parties, then immediately you have to present it within that particular time. If you don't present it, then you have to pay 10%. Recently also, when I had at the bench, when it presented a suit, a writ petition is filed before my court, when I pointed out this, the council immediately withdrawn the writ petition and he want to execute one more because it's almost after 10 months he filed the writ petition saying that sub-registrar is not entertaining the document. It's 52. And the other, I'll just give you that all. The other thing is that registrar cannot inquire into the title of the parties. That also you are aware of all this. You can't go into the dispute of the title except for whether the document presented is in proper manner or not, whether you paid the fee or not, whether section 32 capital A it is complied with or not. But he cannot go into the validity or the title aspect, except it's very thin line. He can't, if registrar start entertaining these civil disputes, he can use, we can only say that he can use this jurisdiction of civil court. And there is the act says that it's no duty of the registrar to inquire into the title. And after full bench judgment, 22, rule 26, 1K1 came into existence where unilateral cancellation. You cannot cancel the document unilaterally, it's only bilaterally. But still they are entertaining and but it's in fact no registrar, it's no registrar because they are taking advantage of the word conveyance on sale. But when the Supreme Court in Gangalakshmi's case interpreted that it's conveyance on sale, and even other High Court judgments are there where gift deed has been said, you can't cancel unilaterally, still they're entertaining. In agreements of coupled with GPI, they're entertaining, they're cancelling unilaterally, but it is contrary to Rule 26, 1K1. Partner completed this. This is what the overall scope of this these two acts I just narrated. And any questions from, so that will interact is always better. Yes, sir, please. Yes. 10 times of the registration value. What is impounding, sir? Document, and section 33 to 35. Sir, you present the document which requires stamp duty, and the stamp duty is sufficient stamp duty, and it is the duty, please see section 33, it is duty of the court or the public officer, whenever you present the document before the court or public officer, it is their duty, see the language, to see to it whether it's properly stamped or not properly stamped. If it is court, 10 times. If it is before the registrar, up to, but generally they are giving it up to 3 or 4 times. Because when you are supposed to find, see, for example, the sale deed is there, or another document is there, it's not properly stamped. You won't present it. Of course, it's not sale deed, but it's only certain documents. So we'll confine to, sir. Let us not, because it will go on like this. Yes, madam.
Registrar cannot cancel the document
unilaterally.
Whether it is a coercion or fraud place, if any party unilaterally, he has to go to the civil court.
Yes, absolutely, madam.
I had read in one general, Registrar General, Inspector General has a power or suo moto or any application by the parties can summons the...
How do you, madam? That's what, that requires evidence, madam. How do you say? See, you can't say that type of... See, you are pleading fraud. coercion or undue influence.
Undue influence.
Or you are pleading it.
That's
How do the registrar is expected to determine that without evidence and record?
That it is amended in the Registration Act. I
No.
did not.
No, it is only, madam, Senior Citizens Act only, under Senior Citizens Act, where a document is executed to say that in lieu of to take care of the elderly people, if somebody execute a gift deed and the donee later failed to look after the welfare under that act, that's different. But sub-registrar or registrar has no role to cancel the document unilaterally.
I had seen in one general.
Generally something different, madam. The provision is there. Even section rule 26K1, 1K1, because see that's what we've been saying. Even of course in Telangana, when we practiced in Composite High Court, a reference was made to Division Bench Justice Nagarjuna Reddy Garu, where in fact I argued that matter. It's a gift deed. It was cancelled unilaterally. Then His Lordship pointed out the word uses conveyance on sale. Conveyance on sale, it doesn't include the gift deed.
Under AP Registration Act.
That's what, 26 1K1. Then recently, that reference was ordered by Division Bench of Telangana High Court. It's only 1 month back, just before vacation. They followed Thought Gangalashmi and said, you can't cancel it unilaterally. A batch of writ petitions were allowed. Thought Gangalashmi is a leading case. Yes, after Gangalashmi, Sitaramurthy Garu said he applied it for gift deed, but still they are doing it. Still going on. Yes, sir. Because always some interactive session is something required in these seminars. Yes, sir. What, sir? Yes, sir. Yes, sir.
Whether it would be required to the consent of the minor or not.
Which is the question of, sir, you are acting as?
Guardian.
Guardian only. A guardian cannot do that. Section 8. Section 8.
One supplemental question, madam.
Yes, sir.
If a father
Yes.
executes a gift deed in favor of the son,
Yes, sir.
who is a karta of the Hindu undivided family.
Yes, sir.
Father, by default, he is a karta and he is a guardian.
Yes, sir.
So he can donate a gift, and also he can also cancel being a guardian of the family.
Sir, that's where Section 8 of Adoption Maintenance Act say.
Well,
That's take care of the situation also. You can't see, you execute a gift deed, and see, when you execute a gift deed, what is the thing, sir? Registration, delivery, and acceptance. Now that acceptance is 2014 Supreme Court. Now, initially the difference between settlement and gift deed, what is the difference between settlement and gift deed up to 2014? Right in present time? In a settlement, you enjoy the property, and after your lifetime, the settler will enjoy the property. You are creating right in present time, and the settler will start enjoying after his lifetime. But so gift deed is concerned, you are delivering the property today itself. But 2014 Supreme Court said even gift deed is concerned, you can defer the delivery for some time. That's what Supreme Court said.
may I ask one supplemental question? In case of the surrendering of the property or the possession has been given to a minor, since the minor can't take the position in his favor,
Yes.
guardian on behalf of the minor, if he takes the position,
Yes.
or if he disputes that the position has not been transferred to the minor,
Yes.
gift deed may not be a conclusive gift deed.
Sir, what is the recital, sir? You go by recital or oral, sir? 91.
Minor.
There is always say, sir. Yes, sir.
Please, my lord.
Yes, sir.
Landowner, site owner has made an agreement with the developer, Your Honor.
Yes, sir.
By giving a power of attorney, and the developer without even making what we call
Activities as per the agreement.
యాజ్ పర్ ద అగ్రిమెంట్ అతనేమి మామూలుగా గుంటలు కూడా తీయకుండా ఈ పిల్లర్స్ కానీ ఏమి వేయకుండా ఈ సోల్డ్ అవే ది వన్ పోర్షన్ ఇన్ ది థర్డ్ ఫ్లోర్ విత్ దేర్ ఇస్ నో స్కెలిటన్ ఆల్సో. ఈ సోల్డ్ అవే థర్డ్ ఫ్లోర్లో ఒక ప్లాట్ ప్లస్ కార్ పార్కింగ్ ఈ సోల్డ్ అవే టు వన్ ఎక్స్ యువర్ ఆనర్. ఇప్పుడు వాట్ ఈస్ ద రిలీఫ్ అవైలబుల్ ఫర్ ది ల్యాండ్ ఓనర్?
అలాగే సార్ మీరు చెప్పిన దాంట్లో చూడండి, మీరు అగ్రిమెంట్ విత్ కపుల్ విత్ జీపీఏ ఉంది కదండి, దాంట్లోను అగ్రిమెంట్ కపుల్ జీపీఏ లేకుండా ఆయన అమలేడు కదండి ఆయన.
అవును సార్,
అగ్రిమెంట్ విత్ కపుల్ జీపీఏ ఉంటేనే కదా మీకు మీ తరపున ఆయన యాక్ట్ అవుతాడు. మీ ఏజెంట్ కిందే చేస్తారు కదా ఆయన చేసే యాక్ట్ ఏదన్నా కూడా.
ఏజెంట్ కింద అంటే దాంట్లో ఏంటంటే ఈయనకి పూర్తయిన తర్వాత ఇన్ని ఫ్లోర్లు ఇన్ని ప్లాట్లు.
కరెక్ట్ సార్, దట్స్ ద రీజన్ వై యూ కెన్ సీ.
ప్లీజ్ మై లార్డ్.
ఎస్ సార్.
సార్
చెప్పండి.
అదే అతనికి రావాల్సిన పోర్షన్లో అతను ఏం కన్స్ట్రక్షన్ చేయకనే అమ్మేశాడు అతను.
So that is reason why you file, generally you'll file for cancellation or see that's a matter for evidence, sir. Otherwise you have to see the recital in the agreement.
Please sir.
Coupled with GPA.
Please.
What are the plots to be allotted to that man and what are the plots to you?
Please.
And what is the ratio? All these things you ultimately are filing suit for
cancellation of contract.
You're asking for either because if you say that you cancel the, for example, you may say that I already cancelled the GPA.
Please sir.
అప్పుడు ఏం చేస్తారండి, బికాజ్ ఇట్ మై ఏజెంట్, దట్ సేల్ డజంట్ బైండ్ మీ.
ప్లీజ్. చీటింగ్ కూడా వస్తుంది
సార్. అది మనం సార్ దట్స్ వాట్ సార్ సేయింగ్ దట్ because most of the advocate friends that practice in civil side or original side, I will request pleading is something important, sir.
Please.
If you, that is the foundation for every case, sir.
Please.
If pleading is there up to, because see at the appellate side what is that they can do,
sir?
They can only tinker. They can't change the, see they can't substitute under pleadings.
Please sir.
So the pleading is something important. If you plead in proper manner, it will take the case to any level.
Please.
That is important.
Thank you.
Yes sir.
Namaste.
చెప్పండి సార్.
I am Dr. Rajshekar from Srikakulam.
Yes sir.
In one family settlement deed,
Yes sir.
4 brothers they got the property.
Yes sir.
They shared it they got the property through family settlement deed.
Yes sir.
Later in the recent resurvey,
Yes.
the lands, that property was, all the 4 brothers they got the property and entered into the passbooks also.
Yes,
revenue records, all the revenue records and passbooks, it was in the name of the 4 brothers.
Yes sir.
But in the recent land records surveys,
Yes sir.
that land was taken by the government endowment department.
Yes.
And passbooks were given to the endowment department.
Yes sir.
As such, endowment department has no documentary proof or any evidence at all.
Yes sir.
Simply the revenue department, with some malicious intention, they did it like that.
Yes.
It's causing a huge loss to the 4 brothers.
Yes sir.
What will be the remedy from your
Sir,
side, sir?
according to me, because there are 2 things. One is section 34 of the act, now you have to ask for declaration. Somebody also saying that before you can approach endowment tribunal on section 87. But I don't advise you, because for the reason, section 87 of the endowment act, act 30 say to declare the rights of the endowment lands.
As such, endowments, they don't have any.
But now, as of now, see, now there is a cloud over the title is there. Now the truth, see, if there is some, for example, if the property is included in section 38 register before of the endowment department, there is a presumption be available to them. They have go to the presumption. They say that it is my property, and you are not the owner of the property. If it's endowment land, for example, 1955 onwards, the Act 1955, you can't plead limitation, the adverse possession under the Endowment Act.
Your Honor, here, the land is in the name of the 4 fathers of the 4 brothers.
Sir, that's what, sir.
And for the last 50 years.
Sir,
they are
not
in
50
the
years, sir.
possession.
Sir, see, I'll just stop you for the reason. Please see the Endowment Act, sir. 148 or so, you can't plead adverse possession against endowment lands. It is from 1955. Even the 1920 Act is also there. 1920 Madras Endowment Act, there is this provision. 4 fathers, sir, we are pleading. See, even you can't even ask for acquiescence also. That's the reason why you have to ask for declaration of your title. And section 87, section 34 of the Relief Act is one thing where you have to ask for declaration so that the court will declare your title or the property. And in fact, judgment of Justice Vilas Abdul Purkar in a common Commonwealth High Court, followed by his Lordship followed judgment of Justice Jagannath Rao, 87, where their Lordship said you can maintain suit for declaration. 87 of the Endowment Act speaks about that whether the property belongs to endowment or not, that's all. It will not declare your right over the property.
No, it is a clear malicious act of the Revenue Department.
Sir, it may be, then you have to implead, sir. See, now that there are entries, what is section 6 of the Act, ROR Act? There is a presumption carries. Presumption carries or not? Probably then you have to establish your title over the property. Then if the court decrees, then there is the matter.
The party can approach the High Court through writ.
Sir, evidence is, sir, High Court in writ petitions is all affidavits, sir. Affidavits we can't, High Court, I am sure, may not ask you to lead evidence before the High Court. It's probably, generally I don't advise. As if I have to be advocate, I don't advise.
Thank you, Your Honor.
Yes, sir. Yes, madam. Yes. Benami transactions. You can't even print that. Madam, that's what you have to prove that. Yes. Yes.
In the documents, she has mentioned with the income, I had drawn the income of the wife's account.
Yes.
She proves she can maintain the money.
Why not, madam? Benami transaction, section 3 of 4B, so please see that. It's there. There's no problem.
Wife and also can.
Why not? It is yours. That's what legal. See, right to property. It is, see, there are disputes, and you send the, for example, wife is in elsewhere. She sent the amount to the husband, and husband purchased the property. Later there were disputes, and wife, if she proves that it's I send this amount to purchase the property, can't she maintain? Because of this thing, definitely can maintain. Yes, sir. Yes, madam. Yes, sir. Yes, sir. That's fine. The recital is always there. Question itself is there is answer. Yes, madam.
Lord, if a document is executed between the two parties,
Yes.
for instance A and B,
Yes.
some other person, a third party,
Yes.
who has some interest in that property, if the document left outstanding, it will cause definitely, he is in apprehension that some specific injury to be caused. If the property is, if the document left outstanding, can he file a suit for cancellation of a document?
No, that's what, madam. That's what, madam, section 31 say. See, that's what. It's your property. A and B entered into agreement. Or rather, this A sold the property to B. If property belongs to you, you are not party to the document. A party to the document alone, because see, by cancellation, see, unless your right is declared, that is where the court has declared your right. You have the better right than those two people. That's when you are supposed to ask for declaration, and consequential is that.
My lord, if I am also co-partner, as A is a co-partner of that property,
Yes.
if I am also co-partner of that property,
Yes.
if I have also same interest as A have,
Yes, madam. You are saying that a co-partner. How do you establish as a co-partner?
by instituting a suit.
Suit. Then you have to establish a co-partnery.
Yes.
And at least to that extent, the other person share, he can sell the property or not.
To his share, he can.
That's what. Then you can't ask for cancellation directly.
My portion up to
So,
my.
but that's what. That is where you have to ask for declaration.
Yes.
Court may say that you are also a co-partner. You are also entitled to share in that, and they sold it to that extent. See section 12. Of course, we can't impose section 12 here, but court may declare to that extent.
Yes.
That's fair.
Thank you.
Yes, sir. Because now already 4:30, sister is waiting here. We don't want to. You see this Relief Act and yes, sir.
Your Lordship, I have only one question.
Yes, please.
Lordship.
Yes,
As
please.
per Section 6 of Specific Relief Act,
Yes, sir.
the no appeal lies from the
Decree.
decree.
Yes.
In case, Lordship, if any appellant court entertain the order which has been pronounced by the lower court regarding the dispossession of tenant by the true owner, actual owner, landlord, in that case, my lord, what will be the solution? Because I have seen one case.
No, sir. What is that? Please repeat. Is it after
Section-
decree
as
or
per-
before decree?
After decree, my lord.
After, sir, when the statute itself specifically bars appeal, where is the question of filing appeal?
Surprisingly, none of the advocates, either appearing for the appellant or the respondent, raised the question before the appellant court.
Sir, court
and
can-
appellant court decided the matter on merits.
Probably, sir, it's without jurisdiction.
Yeah.
Without jurisdiction. See, it's only, what is that you are, it's a summary in nature. You are not deciding title of the parties. You are only saying within 6 months, I was disposed illegally and I am before you within 6 months. That's not the requirement under Section 6.
On the judgment of the appellant court, my lord, what will be the remedy?
CRP, the only revision, sir. Revisional court also can undo all these things because revision 227 jurisdiction or 115. The jurisdiction is that you can correct these. If lack of jurisdiction or exceeding jurisdiction, it is there. Yes, sir. So with this, I think because it's already time is running now, this please see the importance of these two acts where the first part is concerned possession, second part is concerned enforcement of our contractual obligations, third part is concerned preventive relief. With if we read and the reading of these provisions also, please look that. Don't read it so casually. If you read it by giving pause, you will understand the concept of it. And because it's a issue now, it's been settled by 3-judge bench Supreme Court also. It's only prospective in nature that we did not go into all these things. I think with this, I'll conclude my little effort on this subject, and I'll thank you all the participants, and I'll say good wishes and also the Bar Council of India. Yes, thank you.
Thank you, sir. The presentation on Specific Relief Act and the Registration Act, please, sir, by Justice Subbareddy Garu is well educated. Now I request all the Bar Council members who are off the dais to come over on the dais to facilitate the guest, Chidambaram Garu.
There will be tea break after the next session. Please, we will continue the next session and we will have a break.
Please be seated, everyone. I request everyone to be seated. The next session is commencing. I repeat, I request everyone to be seated. We are commencing the next session. Honorable Justice Venkata Jyotirmai Pratapa Garu. She hails from Tenali in Guntur district, completed her degree in law from Acharya Nagarjuna University. She was appointed as district judge in the year 2008 and worked in the CBI court, VAT tribunal, SC/ST court, family court, and as a principal judge in Vishakhapatnam, Prakasam, and East Godavari districts before being elevated as additional judge of High Court on 27 January 2023. Her meticulous attention to detail and unwavering commitment to justice are truly commendable. Her dedication to uphold the law with fairness and integrity inspires all of us. I request the guest of honor, Honorable Srimati Justice Venkata Jyotirmai Pratapa Garu, Judge, High Court of Andhra Pradesh, to come to the dais and adore the chair. I request Sri Parvati Garu and Ramadevi Garu, advocates Vishakhapatnam, to present a bouquet to their lordship. I request the chairman of the Bar Council and Dwarkanatha Reddy Garu to preside over the session.
I request the President of the High Court Bar Association and also Bar Council member Chidambaram Garu, Mr. Brahmananda Reddy Garu, the Bar Council member from Guttur district, and Narsingh Rao Garu, the Bar Council member from Vishaka. Please join with us to bless all the advocates. We are very fortunate, the Honorable Srimati Justice Venkat Jyotirmaya Pratapa Garu here, and she will address an overview of intellectual property rights. A very good subject, intellectual property rights. Please make a note of it and use it. Thank you, Madam.
Okay.
I am going to invest 1 hour of my time here. Are you ready? Yes, thank you. My warm greetings to the members of this august gathering. I am honored to receive the invitation from esteemed Bar Council of Andhra Pradesh to address the gathering. When I was given with the task of choosing the topic to speak, I used all my intellect to decide to speak on overview of intellectual property rights. My session would begin with this opening statement. This session consists various types of intellectual property rights, interesting and important case law on the subject, the proactive role of the judiciary, how this intellectual property rights are indelible part of our daily life, right from toothbrush, which includes a beautiful designed necklace from Tanishq. Everything, whatever you see. Plethora of intellectual property rights. Intellectual property stimulates creativity and fosters innovation. It has the capacity to be a powerful asset, financial asset. Though our country has been one of the pioneers in innovation, but I think awareness regarding the significance of intellectual property rights is missing. It is for this reason, talk on this subject, which is globally pertinent, is very much essential to all of us. Broadly, intellectual property in India can be classified into patents, copyrights, trademarks, geographical indications, designs, trade secrets, traditional knowledge, semiconductors and integrated circuits layout design, plant varieties and farmers' rights. Also, this is a topic which is ever relevant in our life. By this time, all of us have our mobile phones. Let us simply examine the kinds of intellectual property rights present in this common device. When we speak in more technical terms, each mobile application, if you open, several applications are there. Each application opens a plethora of intellectual property rights. One by one, let us have a bird's view. Patents. Patent is a recognition for an innovation. It is a reward for creativity and faster technological growth. It is the exclusive right of the inventor to prevent others from possessing, using, selling, manufacturing are importing the patented invention. You please remember the word invention. It is within a definite geographical area. Remember, patents have a territorial jurisdiction, which means we have to register our innovation as a patent in all countries if we are so interested. If we have registered our patent in India, it won't work in US. In India, patents are governed under Patents Act 1970. Patent rules are also there. Once again, broadly speaking, patent has to satisfy these three things. One is novelty. Does the invention already exist? కొత్తది ఏమైనా చెప్తున్నారా? ఆల్రెడీ ఉందా? Is it non-obvious? Non-obvious to whom? Invention must not be obvious to a person having ordinary skill on that subject. Non-obvious to not everyone. Non-obvious to a person having ordinary skill on that subject. That is the second. Is it non-obvious? Is it actually useful? When it is not useful, why this invention? What is the use? That is industrial application, capable of application in industry in a general sense. Section 3 of the Patents Act deals with what are not inventions. 16 subsections are there. To speak a few example, I may ask for patent compiling all the current affairs of 2023 year. Am I eligible? No. Then we know the combination of hydrogen and oxygen is water. I have applied for a patent for water, saying that this is water. This is a mixture of hydrogen and oxygen is a water. Have I done anything? Have I invented? Have I at least discovered anything? No. Then for plants, animals cannot be patented. Fourth, mathematical methods and business methods, algorithms cannot be patented. Section 4 of the Act says, no patent shall be granted in respect of any invention, even if it is invention relating to atomic energy, because it has impact on the security of the country, security of the world at large. So, no patent for atomic energy. Meticulous procedures are in place under Chapter 3 and 4 of the Act to obtain patents. How to apply, what we have to prove right. Chapter 4 narrates as to how one can oppose the grant of patent after the application is published. In India, there is a slight change in the practice in US and in India. In India, after applying for the patent application with the details be published. But in US, till the inventor get that patent, nobody knows. That is the difference. I will come later on that point. After all the formalities are completed and when the patent is finally granted, the term of the patent, term means the protection of that patent is for 20 years. After 20 years, no. After 20 years, anybody can do that, can use that thing. It's no more an invention after 20 years. It is made, this is made, the rights of that patentee is subject to section 47. What section 47 says? If the patent is in relation to a product, the patentee gets the exclusive right to prevent third parties who do not have his consent for making, using, selling, import, whatever. If the patent is in relation to a process, the patentee gets the exclusive right on the act of using it in any process. Patents can be surrendered or revoked. By whom? Controller, as per the provisions of chapter 12. One circumstance under which patent can be revoked is public interest, that is the utmost importance. There is an interesting concept of compulsory licensing under the Act, under section 84. Any interested person can make an application for grant of compulsory license at any time after expiry of 3 years from the grant of patent. On what grounds? The reasonable requirements of the public with respect to this invention have not been satisfied. దేని కోసం చేశారో అది అవ్వడం లేదు. Number 2, patented invention is not available to the public at a reasonably afforded price. Honorable Apex Court time and again heavily come down on this point. I will come bit later. Third, patented invention is not workable in the territory of India. Then what will be the use of that patent? Under this provision, public advantage and the capacity of the applicant are given weight. The central government has every power to notify that compulsory licenses should be granted in respect of the patent in circumstances of national emergency, extreme urgency, war time, COVID time, epidemics, or public non-commercial use. When once compulsory license is granted, terms and conditions are imposed under section 90. 92A is there. It provides for compulsory license for manufacture and export of patented pharmaceutical products. Just now we have discussed the public interest is paramount consideration for anything human. So for pharmaceutical products, to any country having insufficient medicines or no manufacturing capacity in the pharmaceutical sector for the concerned product to address public health issues. Under those circumstances, central government have authority to notify for compulsory license for manufacturing, export of these medicines. I hope you understand. Chapter 18, it elaborates on the jurisdiction in case of infringement. Appeal against the decision of the controller required to be filed before the High Court. Revocation petitions, of course, before the High Court, respective High Courts in the country. Suit for infringement, it has to be filed before the district courts. When some of the High Courts in our country got original jurisdiction, then before the High Court. Third parties have the right to institute suits for declarations as to non-infringement. నేను చెయ్యలేదు అనే declaration కూడా వస్తారు. And for relief against groundless threats of infringement proceedings, they also can file suits before the district courts. The reliefs, they can plea infringement suits. The reliefs they can plea are injunction, either damages or account of profits. Patents may be enforced by instituting a suit. The Act provides various reliefs, as we discussed, either damages or account of profits, interim relief such as temporary injunctions. Just now, my brother Subba Reddy sir clearly discussed about the injunctions. Sometimes people are filing the petition along with the suit, out of order suit, asking add interim injunction, that's all. In some cases, I have seen when advocates, they file temporary injunction applications, the courts are rejecting, saying that you have not asked for add interim injunction. These are the situations we have come across. An interesting case is there, Novartis AG versus Union of India. The citation is there. It is a landmark judgment, Honorable Apex Court, which dealt with the patentability of pharmaceutical substances, denied the patent application of the cancer drug, holding that drug did not meet the criteria for patentability under section 3D of the Patent Act 1970. The judgment emphasized the need to prevent evergreening of patents and to ensure access to affordable medicines. Another interesting case, Bajaj Auto Limited. This is a case where it is focused on patent infringement concerning a twin spark plug engine. The Supreme Court, Honorable Apex Court, highlighted the importance of interpreting patent claims accurately to determine infringement and underscored the necessity of comparing the patented invention with alleged infringement product in detail. Coming to Bharat Glass Tube Limited case, Honorable Apex Court examined the issue of patent validity and infringement and held that for a patent to be valid, it must meet the criteria of novelty, inventive step, and industrial applicability. The decision reinforced the importance of rigorous examination of patent applications to ensure that only genuinely innovative inventions receive protection. Next, copyrights. Copyright seeks to protect the very original work. You please remember the catchy word to understand copyrights is originality. Originality. In patent, invention. In copyrights, originality. Original work of author expressed in whatever mode or form, irrespective of its merits. Copyright cannot protect mere ideas. Originality does not mean the work must be unique or novel, but that it must originate from the author and not be copied from another work. The work should show some degree of creativity and independent effort. The Copyright Act 1957 deals with the law on copyrights in India. As per the Act, original, artistic, musical, dramatic, literary works, sound recordings, cinematograph films are classified as works which can be subject matter of the copyright protection. Generally, the term of protection of copyright is lifetime of the author plus 60 years. Lifetime of the author plus 60 years. Then what are the rights that are protected under the copyright? economic and neighboring rights, moral rights. Coming to economic and neighboring rights include reproduction in different forms, distribution of copies, public performance, broadcasting or other communication, translation and adaptation. Here is an interesting case. Eastern Book Company and others versus D.B. Modak and another. Honorable Apex Court addressed very pertinent issue which is very much relevant to all of us, whether the reproduction of judicial decisions, including head notes and editorial notes, infringes copyright. The court held that while judicial decisions themselves are not subject to copyright, but the original and creative expression found in head notes and editorial notes can be protected by copyright. That's how this judgment is very much important to us. Coming to moral rights, right to paternity, which incorporates the right to assert the authorship of the work, and I can prevent others from claiming the authorship of my work. Then right to integrity, which is a right to restrain or claim of damages in respect of any distortion, modification, mutilation or any other act relates to the said work of such distortion or alternative act would be prejudice to claimant, honor or name. To understand moral rights better, it is necessary to deal with a decision of Kerala High Court in Sanjeev Pillai. Here is an interesting story. Sanjeev Pillai is a film director and script writer. He who claims to have researched the history of a grand ancient festival, Mamankam, which is ancient festival of Kerala. Then Sanjay signed MOU with Kavya Film Industry, which belongs to one Venu. Though Pillai was appointed as the director, but after some time, after 2 shooting schedules, his services were terminated. Then Sanjay Pillai elicited that the script was mutilated, distorted, modified. Therefore, he filed a suit for infringement of his right. The film company, they have taken a stand that Sanjay already assigned his work to us. We have paid 3 lakhs to him. He is no more a owner of that work. That was the defense taken by the film company. Then it was held that according to section 57 of the Copyright Act 1957, rights of the author is always protected as it places the author in an elevated position, and copyright being a form of the intellectual property gives rights to the creators for their work. It was held that an author has the legal right to protect his intellectual property even after he has sold his rights to the film company. However, while considering that stalling of such a movie would be a huge financial issue, the court directed to release the film without displaying anybody's name till the disposal of the suit filed for infringement, which is pending before the trial court. Author of the copyright also has the right to assign his work based on the terms and conditions as may be decided. This is one way of generating the wealth. As I said, it is invisible property, intangible property. Next, another interesting case, Entertainment Network India Limited. In this case, the court addressed the issue of compulsory licensing under Copyright Act and held that broadcasters must obtain license from the copyright holders and that the Copyright Board has the authority to set reasonable terms for such licenses. This decision underscores the importance of balancing the right of copyright holders with the needs of the broadcasting industry, because for the public good, somebody wanted to broadcast it. So to maintain the balance, the court said, fair dealing is the statutory limitation on the exclusive right of the copyright owner, which permits reproduction or use of copyrighted work in a manner that otherwise would have constituted infringement. Section 52 takes care of it. Few instances of fair dealing include private and personal use. ఈరోజు ఒక ఈ లెక్చర్ చేయడం కోసం ఇక్కడ మాట్లాడడం కోసం ఒక బుక్ తీసుకున్నాను. అందులో ఒక సెక్షన్ ఏదో అవసరమైంది, ఒక కేసులో అవసరమైంది, ఒక కాపీ ప్రింట్ తీసుకున్నాను. అది నాకు సేవ్ అవుతుంది. I have not done any violation of any infringement of copyright of anyone. So criticism and review, it can be done. Reading and recitation of any literary or dramatic work in the public domain. Acquisition of copyright is automatic and it doesn't require any registration formality. Registration is not mandatory. However, certificate of registration of copyright serve as prima facie evidence in a court of law with reference to a dispute relating to ownership of copyright. The tenure of protection is usually the life of the author plus 60 years, as I said. What are the remedies for infringement of copyright? Chapter 12 of the Copyright Act of 1957 addresses the civil remedies for copyright infringement. These civil remedies encompass restitution, injunction, conversion damages, Mareva injunctions, John D orders, Anton Pillar orders, we will discuss later, are few kinds of reliefs that can be granted. District Court has jurisdiction over these matters. Coming to section 63 of Copyright Act specifies criminal penalties for copyright infringement. These criminal penalties are the maximum sentence of imprisonment is 3 years, the minimum is 6 months, and fine is up to 2 lakhs from 50,000. The Metropolitan Magistrate Court of First Class has jurisdiction to take cognizance of these offences. Next, coming to trademarks. A trademark may include name, word, or sign that differentiates goods from goods of other enterprises. It performs the important function of identifying the owner with the goods and services rendered. ఇప్పుడు సపోజ్ ఇండిగో ఫ్లైట్ ఎక్కాము, దానిలో ఉన్న గుర్తు చూసి ఇది ఇండిగో చెప్పేస్తాం. So it may be marks, service marks, shape marks, collective marks, certification marks, patent marks. It provides for registration of the trademarks, which confers exclusive rights to the owner to use the trademark in relation to goods or services for which it is registered. It also prohibits certain types which are deceptive, scandalous, or contrary to public order. In the application process, there are absolute grounds and relative grounds for refusal of registration. By virtue of section 27, it's very important. No person is entitled to seek action for infringement of an unregistered trademark, but subsection 2 of section 27 states that the act does not affect the rights of action against any person for passing off, which means unless your trademark is registered, you can't file a suit for infringement of your trademark. But yet, your goodwill, your reputation can be protected by this right of passing off. If a person sells his goods as the goods of another, ఒక్కసారి చూడండి, ప్యారీవేర్ అని ఉంది, PARRYWARE. అక్కడ PARRY దగ్గర PARRI పెట్టారు, అయిపోయింది. పార్లే ఉంది, PARLEY. ఓకే, ఇక్కడ PARLY పెట్టేశారు. సో మీరు ఒక కాన్సెప్ట్ ఆఫ్ డిసెప్షన్ చేస్తున్నారు. కన్జ్యూమర్కి ఏం చేస్తున్నారు? ఇది పార్లే ప్రోడక్ట్, ఇది బిస్లరీ, ఇది ప్యారీవేర్ ప్రోడక్ట్, ఇలా చూపిస్తున్నారు. సో ఈ పాసింగ్ ఆఫ్ ఎలా ఉంటుంది? If a person sells his goods as the goods of another, it protects the goodwill attached to an unregistered trademark owner. It is a limited right. Nobody has any right to represent his goods as the goods of somebody else. నేను ఇప్పుడు ఈ శారీని చూపించి ఇది కంచి పట్టు చీర అని చెప్పి దీన్ని నమ్మజెప్తే ఎదుటివాడికి అది ఏమవుతుంది? నా గూడ్ కాదు, అది కంచిపట్టు చీర కాదు, కానీ వేరే వాళ్ళ గూడిది అని చెప్పి నేను అమ్ముతూ ఉన్నాను. సో ఈ రైట్ ఆఫ్ పాసింగ్ ఆఫ్ అనేది ఇందులో ఉంటుంది. ఇంపార్టెంట్, వెరీ ఇంట్రెస్టింగ్ కేస్, సయ్యద్ మొహిద్దీన్ కేస్. This judgment is landmark decision rendered by Honorable Apex Court of India, where inter alia the court held that passing of action can even lie against a registered proprietor of a trademark. Here is an interesting thing. A respondent in this case was in the business of selling one halwa in the name of Iruttu Kadai Halwa since 1900 in Tirunelveli place. He had obtained registration for the trademark also in that name, but appellant registered the name Tirunelveli Iruttu Kadai Halwa in 2008 and also sold halwa under this trade name. Honorable Apex Court had to decide between the rights of two registered owners here, and while doing so, the court held that a passing of action can even lie against a registered trademark holder. The court went on to elaborate that a trademark exists independently of registration. So, it is not mandatory to have registration, which merely affords additional protection under statutory law. In case of conflict between two registered proprietors, the evaluation of the better rights in common law is essential, as the same would determine whose rights between the two registered proprietors are better and superior. The respondent won the court case, and the court recognized the rights of prior user as superior to the registration. Even the registered proprietor was unable to disturb or interfere with the rights of the prior user as concluded by the court. What are the infringements involved in trademark? Used by an unauthorized person, identical or deceptively similar. The trademark used by an unauthorized person needs to either be identical to that of the registered trademark or deceptively similar. Deceptively similar. That halwa case, what happened in halwa case? Deceptively similar. The term deceptively similar here only means that the common consumer, that is the test. The common consumer may be confused between the marks and may think of them being the same. ఒకటే కదా, ఇది అదే కదా, ప్యారీ షుగరే కదా అని కొనుక్కున్నాను. ఇక అయిపోయింది, నష్టం జరగక్కర్లేదు కూడా. నా మైండ్లో ఒక కన్ఫ్యూజన్ వస్తే ఒక కన్జ్యూమర్ మైండ్లో అయిపోయింది, ఇన్ఫ్రించ్మెంట్ జరిగిపోయింది. The operational word here being may, it only needs to prove that there is a possibility, doesn't require the proof of actual injury. As long as there is a chance of misrecognition of the marks, it is enough for proving the infringement. Coming to class of goods or services, for the infringement of trademark, the unauthorized use of the mark has to be used for the propagation of goods or services that fall under the same class of the registered trademark. Similar to the copyright law, infringement of trademark also includes civil and criminal remedies. We will discuss a bit later in detail. The term of the protection for this trademark is for 10 years and renewable indefinitely, because this is the halwa from the year 1900. He can take that registration forever, subject to renewal, indefinite period. Next, designs. You please see that design itself indicates what is there in the act. The Designs Act 2000 is the relevant statute. The appearance of an article plays a pivotal role in affecting the sale of the product. It is for the same reason that the sellers invest much amount, a good deal of time and money to create a design for their product. చూడండి మీరు ఒక్కసారి తనిష్కి వెళ్ళండి, లేకపోతే జాయల్కాస్కి వెళ్ళండి, లేకపోతే మలబార్కి వెళ్ళండి. ఒక్క దగ్గర చూసింది ఇంకో దగ్గర ఉండదు, ఒక్క దగ్గర చూసింది ఇంకో దగ్గర ఉండదు. ఒక్కటి డిజైన్ బాగుంది అంటే ఇంకోటి కూడా ఉండదు, ఇంకొక పీస్ కూడా ఉండదు. అంటే హౌ మచ్ టైమ్ అండ్ మనీ దే ఆర్ ఇన్వెస్టింగ్ ఫర్ దాట్. దట్ ఈస్ ది ఇంపార్టెన్స్ ఆఫ్ ది డిజైన్. బికాస్ నాకు నచ్చింది అంతే, నాకు ఇది నచ్చింది, ఈ చైర్ నేను కొనుక్కున్నా, వారికి అది నచ్చింది అది కొనుక్కున్నారు అంతే. ఎందుకు నచ్చింది డిఫరెంట్ ఇష్యూ. దట్ డిజైన్ as per the act, design means only the features of shape, configuration, pattern, ornament, composition of lines, colors applied to any article, whether in 2-dimensional or 3-dimensional or both, by an industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by eye. ఇప్పుడే చెప్పాం కదండి, కంటికి నచ్చింది అంతే. ఐ ఒకటే డిసైడ్ చేస్తుంది ఈ డిజైన్ యొక్క ఇంపార్టెన్స్ని. సో యాక్ట్ ఫాలోస్ ఫస్ట్ టు ఫైల్, ఫస్ట్ టు గెట్. నేను ముందు అప్లై చేశాను, నాకు రావాలి. డిజైన్ కదా, నిమిషాల్లో మారిపోతూ ఉంటుంది హ్యూమన్ బీయింగ్. సో ఫస్ట్ ఇన్ ఫస్ట్ అవుట్. ఫస్ట్ అవుట్ మీన్స్ ఫస్ట్ to file, first to get. It simply means that an innovator of a design should get his design registered by filing an application to the concerned authority at the earliest in order to make his design exclusive and to protect it. Dear audience, I have a small announcement. At the end of my session, surprising gifts are there, MCQs are there, so please listen with dedication. The Act provides for the concept of absolute novelty. Here is an interesting case. Hello Mineral Water Private Limited. The dispute was concerning a water dispenser which was designed in a cylindrical shape. Delhi High Court held that mere form or shape is not sufficient for the purpose of novelty. The ultimate test is to consider the design with an instructed eye to locate the difference between the design previously published and the registered design for the present. What is infringement under the Act? regulating the other IPRs is piracy. It is crucial to note that this act only provides civil remedy for the infringement of copyright in a design. The term of protection is 10 years and extendable for additional 5 years. After 15 years, Kail Katam. So, it will be in public domain. Nobody can claim that this is my design, my design. So, ultimate is 15 years. Coming to an interesting thing, please observe. You can enjoy it. Please observe. Geographical indications. GIs identify the agriculture, natural, manufactured goods associated with territory, region, locality. Why it is important? Protection is necessary to promote and build the regional industry. Next, give access to the international market and build a connection to the consumer with the goods. Example, you can see and understand Tirupati Laddu, Nagpur, Kamala, Kolhapur, Chepals, Tamil Nadu, Kanchipuram, Pattichiralo, Chhattisgarh, Bihar, Bhagalpur silks, West Bengal, Darjeeling tea. Tea anangane Darjeeling. Darjeeling anangane tea anangane kaadu. Darjeeling anangane tea gurtostunda rada. Laddu anangane Tirupati gurtostunda rada. Idokate test andi. Athrayapuram anangane Pootarekal gurtostunda rada. This is the only test for geographical identification. Geographical identification tags are issued as per Geographical Identification of Goods Act 1999. There is a legislation for that. A geographical indication may be registered in respect of goods falling under the classification identified by the registrar, which include handicraft, agriculture, food, manufactured goods, etc., wherein such class of goods in respect of definite territory of a country or a region or locality in that territory. Unless you register it, you can't claim any infringement of this GI. Registration may be refused to those that are konnisal registration cheyakudu, vetik cheyakudu, obscene, likely to cause confusion, hurt the religious susceptibilities. No question of any registration of GIs. Registration of GI shall be for a period of 10 years, but may be renewed indefinitely. Similar to the trademarks, unregistered GIs cannot seek action for infringement. However, Act doesn't preclude the action for passing of the goods. Next. Next, coming to Semiconductor Integrated Circuits Layout Designs Act 2000. A layout design expressed in any manner which is original, which has not been commercially exploited for more than 2 years from the date of application for the registration, which is inherently distinctive and capable of being distinguishable from any other registered layout design, is protected or registered under the Act. Registration of the layout design shall be only for the period of 10 years. That's all. From the date of filing or date of first commercial exploitation. After 10 years, you cannot claim that this is my right, this is my right. 10 years is the maximum period. The act of reproducing, selling, importing, distributing of integrated circuit layout design for commercial purpose constitute obviously infringement. Such act is performed for the purpose of, ikkada chinna exception chudandi, scientific evaluation, analysis, research or teaching shall not constitute an act of infringement. These are the exceptions. Next. Trade secrets. is no legislation as such for trade secrets, but the way out is there. When a secret should be capable of adding economic value, owner should take reasonable precautions to keep that in secret. In case of breach, owner should prove that competitor got the knowledge by illegal means. That is the only thing he can claim for damages for that. But there is no legislation for this. Next, traditional knowledge. Traditional knowledge. It is a collective property owned by entire community. It is owned by the entire society. Neem, వేప చెట్టు ఎవరిది? అందరిది. పసుపు, టర్మరిక్ ఎవరిది? అందరిది. బాసుమతి రైస్ ఎవరిది? ఎంటైర్ కమ్యూనిటీది. These are some important cases. Turmeric is a tropical herb cultivated in eastern India. Turmeric powder is widely used as a medicine, food ingredient, and dye to name just a few of its uses. It is used as a blood purifier, for example, in the treatment of the common cold, as an antiparasitic for many skin infections. It is also used as an important ingredient in many Indian cuisines. In 1995, what happened here? Please see. In 1995, the United States issued a patent for wound healing rights on turmeric to the University of Mississippi Medical Center. The asserted subject matter was the use of turmeric powder and its administration for wound healing. They have applied for this on turmeric powder and its administration for wound healing, both oral and topical. It received an exclusive right to sell and distribute. Then, Indian Council for Science and Industrial Research had objected to the granted patent. We have discussed in patents, we can make our objections. Granted patent and had provided USPTO with written proof of the prior art. ఆ పసుపు మనకి ఎంతకాలంగా ఉంది, ఏముంది, అది మనకు నిత్య జీవితంలో ప్రతి ఇండియన్కి అది ఎలా ఇంపార్టెంట్ అనేది వాళ్ళు లిటరేచర్ తీసుకెళ్ళారు. While it was well established reality that turmeric usage has been recognized in every household in India for ages, finding documented knowledge on the use of turmeric powder through oral as well as topical routes for wound healing has been a Herculean job. Because of extensive research, there were 32 references in various languages, namely Sanskrit, Urdu, Hindi, and therefore the authorities have revoked the patent to US, stating that the claims in the patent were obvious and anticipated, agreed that the use of turmeric was an ancient art of healing wounds, therefore it belonged to India. Our country was safeguarded in the turmeric case. Coming to basmati, here is an interesting issue. Basmati rice, it is in Punjab, a part of another part of the Punjab, now in Pakistan. That is the geographical indication. Rice Tech Inc. US was granted US patent entitled Basmati rice lines and grains in 1997. New rice lines were produced by crossing semi-dwarf varieties from India and Pakistan. Then, it was with 22 traditional basmati varieties. The patent application includes 20 arguments covering not only novel lines of rice grown from rice germplasm, but also different varieties based on traditional farmers' bred varieties. In addition, Rice Tech also grabbed the name Basmati and thus assumed exclusive control of new varieties based on traditional rice varieties nurtured by farmers' generations. The specific characteristics such as fragrant aroma, ఒకలాంటి మంచి వాసన వస్తుంది కదండి బాస్మతి రైస్ వండుకుంటే. Long and slender grain. The distinct taste of basmati are attributable to the geographic area, larger Punjab area divided between India and Pakistan, where it grows in. This business was thus misleading the public against different and inferior goods. అంటే మన దగ్గర చాలా క్వాలిటీ బాస్మతి వస్తుంటే అంతకంటే ఇన్ఫీరియర్ క్వాలిటీ బాస్మతికి పేటెంట్ తీసేసుకున్నారు. సో బాస్మతి రైస్ అనే పేరుతోటి మన వాళ్ళు ఎక్స్పోర్ట్ చేయడానికి వాళ్ళ బిజినెస్ తగ్గిపోయింది. క్వాలిటీ బాస్మతి అనేది ప్రపంచంలో ప్రజలకి అందడం తగ్గిపోయింది. దీనివల్ల వచ్చిన నష్టాలు ఇవి. అండ్ ది ప్రెజర్ ఫ్రమ్ non-governmental organizations, the Government of India filed an application for re-examination in the year 2000 on the ground that the rice lines in question lacked inventiveness and innovation. What I said? Coming to patent, please remember the word innovation. Have they invented anything here? That is the question. Rice lines in question lacked inventiveness. In the year 2001, in response to our request, the authorities in US only allowed 5 claims. We have made 20 claims. They have allowed 5 claims. And the title of the invention was also changed from Basmati Rice Lines and Grains 10 to Rice Lines BAS 867 RTI 117, like that. RTI 121. Next. It is so important. Plant varieties and farmers' rights. Here is a legislation for that in India. The Protection of Plant Varieties and Farmers' Rights Act 2001. Term of protection varies depending on the type of plant from 15 to 18 years. This Act 2001 and the rules of 2003 primarily deals with protection of the rights of plant breeders over the new varieties that they have produced and the right of farmers to register new varieties and also to conjure, breed, use, trade, share or sell varieties of plants that they have produced, improved and preserved for several generations. ఎంత కష్టపడి మన వ్యవసాయదారులు చేసిన వాటిని వాళ్ళు సురక్షితంగా ఉంచుకోవడానికి ఈ చట్టము వెసులుబాటు కల్పించింది. సో కమింగ్ టు civil remedies. Under Copyrights Act 1957, Section 55 takes care of it by way of injunctions, damages, accounts of profits. Trademarks Act 1999, Section 135, the very same thing. It is the option of the plaintiff. Patents Act 1970, Section 108. Plaintiff can also be granted an order for the delivery up of the infringing labels and marks for destruction or erasure. ఇక్కడ పేటెంట్ కదండి, ఇంకొంచెం యాక్ట్ లోపల ఇంకొంచెం భద్రత చేశారు. ఏవైతే వాళ్ళు చేశారో అవన్నీ ముందు నాశనం చేసేయండి, అవన్నీ తెచ్చేసి ఈయనకి ఇచ్చేయండి, అలాంటి వెసులుబాటు కూడా కల్పించారు. కమింగ్ టు డిజైన్స్ యాక్ట్ 2000, Section 22 takes care of it by way of injunction and damages. Coming to criminal remedies, under Copyrights Act, Section 63 to 70 are relevant. As I said, the punishment of imprisonment minimum is 6 months up to 3 years. Minimum fine is 50,000 up to 2 lakhs. And seizure of the copies, because it is a copyright, seizure of the copies. Semiconductor Integrated Circuits Layout Designs Act 2000, Section 56 to 59 of the said legislation take care of this criminal remedy. Up to 3 years imprisonment, fine, Forfeiture of goods also there. Please remember, forfeiture of goods also there. Coming to Trademarks Act, section 103 to 108, punishment is up to 3 years and also fine. New developments by courts on injunction. As I said, the proactive role of the judiciary to attend the situation to protect the intellectual property rights. Mareva injunction, the principle of Mareva injunction is seen as an attachment before judgment, Order 38, Rule 5 of CPC. This is called Mareva injunction. The court can attach the money lying in the bank account of the wrongdoer and attach the property, whatever. Mohit Bhargava and Bharat Bhushan Bhargava case is important here. AR 2007, SC 1717. The court observed these two orders are certainly within the jurisdiction of the court which passed the decree, since they are only orders of restraint being issued to a person from handing over a property in his possession to the judgment debtor along with documents concerned and keeping the documents in safe custody. They are in the nature of freezing order. Freezing. We all know about freezing. So they are in the nature of freezing order or a Mareva injunction and an order akin to Anton Pillar order that can be issued even if the property or the person concerned is outside the jurisdiction of the court. Even the wrongdoer is outside the jurisdiction of the court has every authority to grant such reliefs as stated by, as held by Honorable Apex Court. Anton Pillar order, what is this? This is similar to search warrant. Sometimes people are filing the suits. Along with suit, they file a petition seeking appointment of Advocate Commissioner, Order 26 Rule 9 or so. So, like that Anton Pillar order, objective is to stop the defendant from destroying the evidence, to preserve the evidence as it is. What is there to keep as it is? This is Anton Pillar order that can be done, like Order 26 Rule 9 CPC, Order 39 Rule 7. When to issue? Eppudu ivvalandi. Here is an interesting case. Bucyrus Europe Limited versus Vulcan Industries Engineering Company Private Limited. The citation is 2005 30 PTC 279. Here are the circumstances where the plaintiff has an extremely strong prima facie case. Eppudu ivvachu? Extremely strong prima facie case where the actual or potential damage to the plaintiff is very serious. It was clear that defendant possessed vital evidence. There was a real possibility that defendant might destroy or dispose of such material so as to defeat the ends of justice. The purpose of Anton Pillar order is the preservation of evidence. John D. order, it is ex parte in nature and issued in those matters wherein defendant is unidentifiable. Dynamic injunctions. Here the word dynamic injunctions, the court used the word dynamic injunctions. Courts grant orders blocking the infringing content with reference to specific URLs, not the entire website. It is specific URLs. Eros International Media Limited versus Bharat Sanchar Nigam Limited, 2016 SCC online, Bombay 10458 is an important case here. Court refused to pass orders for wholesale blocking websites that allegedly hosted illicit links to the movies Udta Punjab, Great Grand Masti and Dishun. An order to block entire website without demonstrating that the entire website contains infringing material cannot be granted. Specific uniform resource locators, URL, containing infringing material must be identified. Please bear with me for 5 minutes. Court considered the appointment of ombudsman to root all such grievances and complaints relating to infringement. Geo-blocking and global injunction. You please see to what extent the remedies are there. Geo-blocking and global injunction. Global injunctions have a wider scope as they are necessarily extraterritorial injunctions. Global means the word itself denotes its extraterritorial jurisdiction against online content and defies territory or jurisdiction. Swami Ramdev and another versus Facebook Inc. and others. Here is a case matter concerning defamatory content on Yoga Guru Baba Ramdev for illegal content which was uploaded outside the Indian territory. The court directed geo-blocking access and disabling viewership of such content from within India. Indialo undi global మొత్తానికి చేసే ఆర్డర్స్ కూడా ఇచ్చే అధికారం ఉంది. Coming to criminal side, NIT Pro International versus State of NCT 2022 3 SCR 90 is the citation. Honorable Apex Court held that copyright infringement is a cognizable and non-bailable offence under the Act. Thus, for the offence under Section 63 of the Copyright Act, the punishment provided is imprisonment for a term which shall not be less than 6 months, but which may extend to 3 years, and with fine. Therefore, the maximum punishment which can be imposed would be 3 years. Therefore, learned magistrate may sentence the accused for a period of 3 years also. In that view of the matter, considering Part 2 of the first schedule of the CRPC, if the offence is punishable with imprisonment for 3 years and onwards, but not more than 7 years, the offence is a cognizable offence. Now, this is the quiz time. Are you ready? ఎక్కడ హుషారు లేదండి. Surprise gifts are there for the winners. ఈ ఎంసీక్యూస్కి వెళ్ళే ముందర రూల్స్ ఆఫ్ ది గేమ్ ముందే చెప్పాలి కాబట్టి చెప్తున్నాను. ఎవరు కరెక్ట్ ఆన్సర్ చెప్తారో వాళ్ళు ఫస్ట్ హ్యాండ్ రైజ్ చేయాలి. వాళ్ళకి ఆర్గనైజర్స్ ఐఎమ్ రిక్వెస్టింగ్ దెమ్ టు పాస్ ఆన్ ది మైక్. ఎక్కువ మంది కరెక్ట్ ఆన్సర్స్ చెప్పడానికి ముందుకు వస్తే వాళ్ళలో ఫస్ట్ ఎవరు చెప్పారో దానికి ప్రయారిటీ. సపోజ్ ఒకే టైంలో ఎక్కువ మంది చెప్తే చిన్నవాళ్ళు ఎవరో వాళ్ళకి ప్రయారిటీ. ఓకే ఓకే నో డిస్క్రిమినేషన్ ఎప్పుడు వస్తుందంటే 2 ఈక్వల్స్ మధ్య వస్తుంది డిస్క్రిమినేషన్. ఈ మధ్య రాదు, ఇలా ఉన్నప్పుడు రాదు. 2 డిఫరెంట్ ఆస్పెక్ట్స్లో ఎప్పుడు డిస్క్రిమినేషన్ రాదు. ఐ హోప్ ఐఎమ్ కరెక్ట్. Learned senior counsels are there, so they can clarify it. Among equals, no question of discrimination. These are the rules before going to MCQs. Gnana, you please assist me. First question on the screen. Which of the following is not an intellectual property law? Copyright Act. Copyright Act. ఇందాక సారీ అండి, రూల్స్లో ఒకటి చెప్పలేదు. నేను క్వశ్చన్ మొత్తం చదివేదాకా మీరు ఆగాలి. Copyright Act 1957, Trademark Act 1999, Patent Act 1970, Seeds Act 1966. Seeds Act. అందరు చెప్పేశారు కాబట్టి ఇందులో జూనియర్. నో Junior, who is the junior? All are juniors. Okay. ఏంటి అయితే అయితే మీ అందరి తరపున బార్ కౌన్సిల్ చైర్మన్ గారికి ఇచ్చేస్తున్నాను. వెర్ ఇస్ పెన్? సార్ ప్లీజ్ యాక్సెప్ట్ ఆన్ బిహాఫ్ ఆఫ్ ఆల్. మీకు 10 పెన్నులు మీకే వచ్చేలా ఉన్నాయి. థ్యాంక్ యూ సార్. Seeds Act is the correct answer. మీ అందరి తరపున రిప్రజెంట్ చేశారు. కాపీరైట్ యాక్ట్లో అది కూడా ఉంది. యూ కెన్ అసైన్. Next question on the board, please. Jack, Jill and James take photograph of the Taj Mahal from 3 different corners. Is each of them entitled to a separate copyright? No. No. Okay. They are entitled, yes. నో అన్న వాళ్ళు ఎంతమంది? అందరు కదా. ఒక్క నో వచ్చి ఎందుకు నోనో చెప్పండి. చెప్పండి చెప్పండి. ఆల్రెడీ ఎగ్జిస్టింగ్. ఓకే ఓకే. అక్కడ ఏముందండి? అక్కడ ఉన్నది ఏంటండి? అక్కడ ఏముందండి? కాపీరైట్ని ఇందాకే ముందే చెప్పాను నేను. కాపీరైట్కి ఒరిజినాలిటీ మాత్రమే అని. సో మీరు ఎస్ అని చెప్పారు. ఎందుకు చెప్పారు?
This is a photograph. This is original. Each photograph is original. Structure is different.
Yes, yes, you are right. Yes, yes. I am successful. I am successful. Yes, yes is the answer. Next question on the screen. An advocate dictates a petition to his typist, Mr. Shyam. Can Mr. Shyam claim as the owner of copyright? Yes or no? All no? Why no?
The author of the petition is the advocate. Yes. No.
మీరు ఫస్ట్ కూర్చున్నారు కనుక మీకు I will come to you. I will come to you. Next question on the screen. Which of the following attributes is not necessary for a piece of information to qualify as a trade secret? Commercially valuable, known to limited number of people, reasonable steps to keep it secret, it should be in writing. ఏంటండి చెప్పండి. బి బి ఇస్ ది ఆన్సర్. ఎందుకు బి ఆన్సర్ అనుకుంటున్నారు చెప్పండి. చెప్పండి.
It should be known to limited number of people only.
ఓకే, బి ఇస్ ది ఆన్సర్. యు ఆర్ కరెక్ట్. ఇంకా ఇంకా చెప్పట్లప్పుడే వద్దు. ఇంకా కమర్షియల్లీ వాల్యుబుల్. ఓకే, యువర్ ఆన్సర్ ఈజ్ ఆల్సో దేర్. ఇంకా ఎవరన్నా? డి డి ఎవరు చెప్తున్నారు? డి ఇట్ షుడ్ బి ఇన్ రైటింగ్. ఓకే, ఎందుకండి? ఎక్కడ చెప్పారు అలా ఉండాలని?
Still they are
దట్స్ వై. సరే, ఇప్పుడు కమర్షియల్లీ వాల్యుబుల్ ఎవరు చెప్పారు? మీరు చెప్పారు. ఈయనకి ఎవరైనా ఓట్లు వేసే వాళ్ళు ఉన్నారా? ఈయన ఒక్కడే మిగిలిపోయాడు. అది చెప్పండి. ఎవరన్నా ఒక్కళ్ళన్నా ఓటేసే వాళ్ళు ఉన్నారా? మీరున్నారా? ఓకే, చూద్దాం ఇప్పుడు ఆన్సర్ ఏంటి. of the following attributes is not necessary for a piece of information to qualify as a trade secret. ఏమండి నాట్ అనేది మీరు మర్చిపోయారు. కమర్షియల్లీ వాల్యుబుల్ కరెక్ట్, known to limited people correct, reasonable steps to keep it secret correct, it should be in writing is not correct. So it should be in writing. D చెప్పిన వాళ్ళు ఎవరు? D చెప్పిన దానికి రీజన్ చెప్పిన వాళ్ళు ఎవరు? రండి. మీరు కొంచెం చప్పట్లు కొడితే మీ ఆరోగ్యానికి మంచిది. చదవండి చదవండి. X made an application to register trademark for Tevasol, a veterinary medicine. Y objects to the application stating he is the registered proprietor of the Temasol, a human medicine. Is the objection sustainable? Woman అక్కడి నుంచి woman, first time woman. నోనా? అలాంటి అబ్జెక్షన్ చెప్పకూడదా? హీ కెన్ మా ఒక్కటి చెప్పండి. బీనా ఏనా అదొక్కటి చెప్పండి. మీరు ఆన్సర్ బీనా ఏనా చెప్పండి. బి చేయకూడదు. ఓకే ఓకే మీది అయిపోయింది. ఏ ఆన్సర్? ఏ ఆన్సర్ అమ్మా? అమ్మా బి కాపితే ఏ ఇంకేముంది? ఏ ఎందుకు ఆన్సర్ చెప్పండి ప్లీజ్. ఏ ఎందుకు ఆన్సర్ చెప్పండి. She is telling. So, if it is for a human medicine or veterinary medicine, the medicine is the same. The content of that medicine is the same. Come. We will see what is correct answer. Yeah, come. Next question on the screen. Can masala dosa be patented by Miss Vidya, a South Indian cook? ఒక్కళ్ళు కూడా వేస్తలేరా? ఒక్క పాజిటివ్ కూడా లేరా? ఎస్ ఉన్నారా? ఎవరు? ఎక్కడ మీరు? ఎస్ ఇంకా ఎస్లు ఎవరు? పాజిటివ్, బి పాజిటివ్ అండి. ఇంటికి వెళ్ళబోతూ ఇప్పుడు నోలేంటని. ఎస్, సో ఎస్, we will see what is the correct answer. I'm sorry.
హలో,
అందరూ నో చెప్పారు. ఈ రోలో పెన్లు వచ్చాయి, ఈ రోలో పెన్లు వచ్చాయా? రాలేదా? ప్లీజ్ కమ్, ప్లీజ్ కమ్. బ్యాక్ బెంచెస్ రావాలి, ముందుకు రావాలి. Yes, you are from Rajahmundry. Okay, okay, congrats. Next question, only to back. Geographical indication is private right, community right, vested right. What? Community right. ఎవరు ఏ ఆన్సర్ ఎవరు లేరా?
ప్రసాద్ మేడం.
అందరు కమ్యూనిటీ రైటేనా? ఇంత బాగా వినేశారు పాఠాన్ని. ఫస్ట్ మీరు కాదు, బ్యాక్ బెంచెస్ ఈసారి. బ్యాక్ బెంచెస్, బ్యాక్. ఎనీ జూనియర్ ఫ్రమ్ బ్యాక్? ఎనీ జూనియర్ ఫ్రమ్ బ్యాక్? Please come.
Community right.
చూద్దాం. Yes.
Madam.
మీరు బ్యాక్ లేరండి. Next question on the screen.
Only India, madam. C. C, madam. C. India, madam.
Only in India.
Only in India.
ఎందుకు ఇండియా అని చెప్పిన వాళ్ళు ఎందుకు ఇండియానో చెప్పండి. అట్రు ఎందుకో చెప్పండి. ఎందుకో చెప్పండి. మైక్.
Territorial jurisdiction, madam.
Only in India, not in US. Territorial jurisdiction. Okay. Oh, no. Across the world. India, okay. So it is across the world. That is your answer. Okay. Across the world. ఓకే. సి బి. ఎవరన్నా ఏషియా ఏ ఉందా? ఏ చెప్పేవాళ్ళు ఎవరైనా ఉన్నారా? డి చెప్పేవాళ్ళు ఎవరైనా ఉన్నారా? ఎస్, అన్ని ఆన్సర్లు వచ్చాయి. చూద్దాం.
మేడం పెన్నులు.
ఫ్రమ్ దిస్ గ్రూప్.
మేడం ఇక్కడ.
ఫ్రమ్ దిస్. కమ్. థ్యాంక్ యూ.
అయిపోయింది, క్వశ్చన్ అయిపోయింది.
ఎన్నో క్వశ్చన్లు ఉన్నాయి. As per Designs Act 2000, the features of a design upon its application to a finished article can appeal to and are judged solely by చూద్దాం మీది అయిపోయింది. మిమ్మల్ని చూడలేదా? మీరు చూసేలాగా ఏమన్నా చెప్పాలి కదా. నోస్, ఇయర్, టంగ్, ఐ. వెరైటీగా ఎవరన్నా ఇంకేదైనా ఆన్సర్ చెప్పగలరా? ఏం లేదు. చూద్దాం ఆన్సర్ ఏంటో చూద్దాం. ఐ. మరి అంతే. ఇదంతా సరదా కదా. Tarts was published by ABC Publications on 1/9/2023. Please observe the dates. A book on law on injunctions was published by XYZ Publications on 9/9/23. XYZ registered the cover design in October and ABC applied for registration in November. Who gets the protection under Designs Act? ABC. మీరు అయిపోయింది. ఏబిసి ఎవరు చెప్పారు? ఏబిసి రండి. ఏబిసి రండి. ఏబిసి ఎవరు చెప్పారు? ఆ రోల్ నుంచి రండి. XYZ ఎవరు చెప్పారో వాళ్ళు ఒకళ్ళు రండి. రండి. ఇద్దరే రావాలి. ఒక్కలే రావాలి. ఒక రో నుంచి ఇద్దరు రాకూడదు. మీరు ఆల్రెడీ తీసుకున్నట్టున్నారు కదా. ఇంతమంది వస్తే కాదు. ఒక్కళ్ళే మీరు రిప్రజెంటేటివ్ని ఎన్నుకోండి. ఒక్కళ్ళే చెప్పాలి. XYZ ఎందుకు అది చెప్పండి. మీరు అందరికి వినిపించేలా చెప్పాలండి. XYZ ఎందుకు
XYZ రిజిస్టర్డ్ కవర్ రిజిస్ట్రేషన్ అనేది అక్టోబర్లో చేసుకున్నాడు తను. ఆ తర్వాత ఏబీసీ అప్లై చేసుకున్నాడు, దేనికి రిజిస్ట్రేషన్ కోసం అప్లై చేసుకున్నాడు. బట్ ఫస్ట్ కవరేజ్ అనేది జరిగింది కాబట్టి ఇక్కడ XYZకి వస్తుంది.
ఏబీసీ చెప్పిన వాళ్ళు ఎవరో చెప్పండి.
ABC first published on 1/9/2023. Hey, designed and published. That is the reason ABC is the right answer. As per citation,
Can I answer, madam?
Okay. 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 ఫస్ట్ అప్లై చేశారు కాబట్టి ఫస్ట్ వాళ్ళకి ఇస్తారు.
Can I answer, madam?
చూద్దాం. ఆన్సర్ ఏంటో చూద్దాం. XYZ, you please come. I think it is the time to wrap up. This may be the last question.
Hello.
An overview of all the IPR indicates the legislation in place are archaic and similar. In all the legislations, balance is sought to be achieved between the creator and the consumer. This is the beauty of this area of law. The need of the hour is to read IPR and with other branches of law in one voice, particularly intellectual property rights and human rights, though usually read in isolation. Sir, may I take a break? Intellectual property rights and human rights. You please think. Before leaving the dais, I am just making a request. You please think. What is the interplay between the human rights and intellectual property rights? As Honorable Apex Court heavily come down in the case of Sun Pharma, so many cases relating to pharmaceutical drugs of serious diseases. How human consideration has been taken by the court, how proactive the court in attending such situation. Please think. The role of judiciary in enforcing the IPRs cannot be overlooked. Almost in each IPR, there has been significant contribution by the courts, from looking into the technical aspects to unearthing human consideration. The courts of this country embraced the law of IPR. As young lawyers, I request you all to make yourself completely aware of the laws and contribute to the development of the subject, which will produce enormous results to all fragments of the society. I believe knowledge is a progressive elimination of ignorance. I hope and trust the synergy of this auditorium could achieve that object to some extent. I have placed the MCQs at the end of my presentation because it is the assessment of the speaker, assessment of what the speaker has done for the last 1 hour. When you have given right answers to every question, I am very happy for that. If I place MCQs at the beginning of my presentation, that would be helpful to the speaker to assess your understanding about the topic. That's why I thought it fit to place them at the end of my presentation. Thank you one and all for patient hearing. This is Jyotirmay.
Thank you, madam. Please sit. Honorable Srimad Justice Venkata Jyotirmaya Pratap presentation on the Intellectual Property Rights Act. And the question answer is well received by all the people. Madam, they expect next time from you gold pens, not this type of pens. Flattery. Thank you, madam. It's a very lively. We all no. Entire people. I am not just for see very lively. It's almost a lively show. I just saw in many places where I visited in some foreign countries also how a person who speaks attracts the entire audience by going into their minds, not only into the minds, but midst of them. This is one type of art of speaking. Thank you, madam. Very nice of you. Now, I request Srimati Vijay Sudha, Head of the Department of Law College, who are the hosts here, and also our Secretary of the Bar Council, Srimati Padmalata Garu, to facilitate the guests along with all the members.
Couple of announcements. We'll have a tea break and again come back for a cultural blast. It's being a last today. My lord already activated all of us, making ready. Finish the tea, come back fast so that you can utilize the time. Another announcement is tomorrow, by all probability, we will be able to complete the entire program by 3:30, because to reach your destinations, buses have to be provided because it is not a working day. And you pack up your luggage in the morning itself, get ready, and the moment it is over, you can pick up your luggage and utilize the buses to reach your destinations. Thank you.
సార్ వర్కర్స్ పిలిపించారా మాస్టర్ ఇంకేం ఉండదు అదే కలిసి